ಡೀಟೇಲ್ ಬರೀಬೇಕು ಮೆಮೊಲಿ.
All memos to the court officer. Yes, call the list.
Memos.
Milads for tomorrow, Milads.
Give all the memos to the court officer, write the urgency, how the court can understand. If I understand the urgency, I'll accordingly give the dates. Yes.
Page. List number 1, page wise adjournment. Page number 2, serial number 4 to 6. Page number 3, 7 to 16. List number 2, page number 3.
My lord, serial number 11. First list to serial number 11, my lord.
Huh?
My senior counsel is not feeling well, my lord, today.
Have you informed the other side?
Yes, my lord. Already
TJ
informed
Sunkapur.
and to communicate with the settlement on the trial court, my lord. Kindly investigate of
It is submitted that there is a likelihood of settlement. This is matter
any date, please.
on 18th of November.
You got serial number
The
3.
model, if any,
Interim order.
Serial number 3 in this second
Seven.
list, your lord.
it is not at fault.
Interim
Yes. Yes.
Kindly interim order.
Extend ಆಗಿದೆ sir.
Yes.
List number 2, serial number, page number 3.
Yes.
Serial number 3, your lord. Next week sometime inform the other side.
I am for a respondent. Copy
Inform the
submitted.
senior counsel. Next week, your lord.
Senior will come, my lord. Senior birthday.
Seeking adjournment.
Senior will come.
Next week I told him.
Copy not served, my lord.
Copy is given, everything is given, sir.
Two things, copy not given to you and he's seeking adjournment. You have any objection for that?
Yes, my lord. Senior will come.
Then please wait till the matter is called. Yes.
Page number 3, serial number 9 to 12. Page number 4, serial number 13 to 18. List number 3,
Yes.
page number 1, serial number 2. Page number 2, serial number 2. List number 4. To 44, page number 10, 45 to 51, page number 11, 53 to 53, page number 12, serial number 53, page number 13, 56, page number 14, 57 to 59, page number 15, serial number 60 to 64, page number 16, serial number 65 to 17, serial number 71 to 75, page serial number 76 to 81, page number 19, serial number 83 to 85, page number 86 to 89, page number 21, 91 to 96.
Well, as serial number 91, my lord. Serial number 91, I have some difficulty, my lord. Kindly have it next week, my lord, at any date. I informed the, yes, I informed Vijay Kumar. Yes.
P. Vijay Kumar.
This is matter at the request of Land Council petitioner on 2nd of December. Yes.
Page number 22, serial number 97 to 103, Page number 23, serial number 104 to 110.
104 my lord. CR Ravishankar president.
Huh?
CR Ravishankar president. Other side is Saruda.
104
Not the
already.
president.
104, it is Ashok and Patil.
Ashok
No,
and Patil.
107 CR Ravishankar.
100 and,
For
on
Patil.
his request.
Party is Saruda.
Huh?
CR Ravishankar plus time.
Why?
107 my lord.
Why he praised time?
Some inconvenience.
This is matter in the month of December, on 10th of December,
Please.
at the request of one counts for the appellant. Yes, call the
Page
list.
number 16, serial number 111. List 1 for orders matter, serial number 1.
Ladyship, just wanted to mention,
Kumar.
Complaint court order. Yesterday I tried to apply for along with
ಲಿಸ್ಟ್ ಒಂದು 13 ಟೈಮ್ ತಗೊಳ್ತೀನಿ.
served the handsome.
What is the advocate's name?
my lords, waiting for the response, filing wakalat for the respondent, my lords. Natural guardian, kindly a date may be fixed for this matter in
Then
emergency.
counts for the,
No,
Mr.
registration
So-and-so
file.
submits, he has instructions to file wakalat. List this matter on 11th of November.
Kindly action.
Yes.
Ladyship,
I'm
my lords, one
mentioning memo.
submission.
I'm sorry, I didn't know when to mention, Ladyship, but if it can be taken up for tomorrow.
Which one?
Ladyship, there's a mentioning memo which we have filed for 4 writs.
See, I'll see, no urgency for any, if I feel there is urgency, then only I'll grant.
Or Ladyship will have it next week otherwise, Ladyship.
But see.
I'm so grateful, thank you.
My lords, one submission, my lords. Only the hand summons copy has been given. The copy of the petition is
Counsel
not.
for the petition, to serve the copy of the petition on the counsel for the entire papers on the counsel for the respondent. Yes, next.
Serial number 2.
File
No,
ಮಾಡಿದೆ.
Sebastian.
The hand summons issued is duly
Where
served on the
is the
respondent.
memo?
My lords,
Memo.
it's filed, my lords. It's filed on 9/10/2025, along with the affidavit also, my lords. It was served on 6/10/2025.
Who's the advocate? Advocate.
The advocate's name is one. No mention of the
Ashwini.
advocate. Ashwini, my lords, yes.
It is, a memo is filed stating that as per the order passed by this court, handsomens were taken on the counsel appearing for the respondent.
List serial number 1.
The list, print the name of Ashwini. This was matter. You have an interim order?
It should be excellent, my lords. I have an interim order.
List this matter on 11th of November. Interim order earlier granted is extended.
Much appreciated.
Serial number 3.
Yes.
I'm appearing on behalf of the petitioner, my lord.
9.
My lord, there was an order passed by the Honorable Family Court one day before the vacation, that is the Dasara vacation, granting certain visitation and overnight custody to the father. My lords are aware of this matter. In fact, this is the matter in which my lords had referred the matter to Nimans, wherein both the parties were supposed to report to Nimans and a
Report
report.
is also here. Where is that report?
My lords, today was the date for reporting to Nimhans.
Today is the date.
Today was the date to report to the
I will
Nimans.
go to
However,
Nimans.
my learned friend here has filed a memo yesterday and gotten the matter posted for today, knowing fully well that he was supposed to report to Nimans. In fact, the petitioner is before Nimans as we speak.
My lord, I filed the memo on 14th because 13th was an adjournment.
What is the urgency for filing a memo?
My lordship, my son is,
Listen, until you go to the NIMHANS and get yourself evaluated,
I'm
no
doing,
further orders cannot be passed.
of course, my lordship, but the thing is, my lordship, one clarification I need to make here. Even though the vacation bench gave this stay pending this Nimans report, my lordship, the evaluation is for both parents, my lordship. It is not just only for me, and there is no evaluation for the child. The child is doing perfectly fine. He comes to me as per your orders daily between 7 to 9 p.m. and he asks, Papa, I want to stay here. I want to, like stay overnights, and I have.
God, this enthusiasm is not required in these cases. Please take it slowly. Go as per the orders of the
My
court.
lords,
Whenever you want, the matters cannot be listed. As per the order, go before the NIMHANS today, and then we will see.
my lords,
Once
there is
the
a
report-
Deepavali vacation, my lordship. Dasara vacation was infructuous because the wife, my wife did not obey the court orders. She said, I'm filing the case in High Court, so I will not give you over this vacation custody, my lordship. And there is no illegality mentioned in any vacation bench also. There is no perversity in the order. It only says there is a Niman's report. That's why the father has to.
What is the order of this court?
Please, my lords. My lords, if I may invite my lords' attention to writ petition number 30128 of 2025. Order dated 3/10/2025, my lord. That is the vacation bench order, wherein the entire order passed by the trial court has been stayed.
Why?
Basis the fact that till now, right from the birth of the child till now.
Order of the court.
Please. If I may invite my lord's attention to annexure A, page number 20 of my writ petition number 30128, my lord. The operative portion can be found at page number 36, my lord. Are my lords there?
No, what is the order now that is existing?
My lord,
The order that is existing is the order that was passed by my lords. And that is being duly complied. And my learned friend is also admitted in his application that it is being followed. However, his grievance was with respect to this particular order, which was subsequently filed. My lord, if I may make one respectful submission, he files an application for overnight custody. Such an application gets dismissed and only visitation is provided, challenging which he comes before this honorable court. This honorable court passes a particular order, after which he files a review and recall application making allegations against his own counsel, and he tries to reopen this case. In the meantime, he also files an application before the trial court seeking overnight custody during vacation. Initially also he seeks for overnight custody, but not during vacation. Later on he
But
seeks for
I need
overnight custody during vacation.
I need to clarify.
It is
a few
only
things.
masked under the category of vacation, but the order remains the same.
My lord, I need to clarify a few things.
List this
My lord,
matter. We will hear. List this matter along with what is other writ petition.
All the writ petitions are connected.
my lords,
All the
one-
writ petitions are before my lords.
Yes.
my lords, in the interim, Deepavali is coming next week, my lord. He has 1 full week vacation, at least daytime custody, if you may grant. There is a stay only on the overnight. Daily visitation, weekend, there is nothing on that. I have also filed an IA
He
for
may
that.
exercise the existing visitation. We will follow that in both letter and spirit, my lord.
My lords, I am following it.
What is the difficulty of the mother when the child is comfortable?
My lord, if I may invite my lord's attention to his application.
I have interacted with the boy.
Please.
Boy has no problem with the
Please,
mother.
my lords,
Then what is the
we have
problem of the
absolutely no issues insofar as visitation is concerned. But if my,
As per the order passed by this court in the earlier case.
Please.
What is the visitation that is granted?
my lords, if I may just invite my lord's attention to his prayer, I will leave it to my lord's wisdom, my lords. He has sought for entire 18th to 26th. If I may invite my lord's attention,
Let's not go to that.
please.
It's not on a technical aspect.
Please,
here.
my lords, please.
Now, during
Please.
the Diwali vacation.
Please.
Please get instructions and pass over this matter from your client. If
Please.
not pass over, I'll take it up tomorrow.
Please, my
You
lords.
let him go to the NIMHANS.
Please,
the way it is,
please.
scheduled.
Please.
Tomorrow, get instructions. We will grant the day custody visitation to the father.
My lords, all that I request is not every day, my lord. He has sought for it every single day between 18th and 26th. I am requesting at least an arrangement may be worked out, alternative days or anything.
Lords,
I will seek instructions to that effect as per my lord's
My-
instructions.
My lords, if you can give 50% of vacation overnight custody, there is no
Overnight
perversity
custody
in
is
the
what has
order,
been
my
dealt
lord.
with and stayed by this honorable court, my lord.
Let me submit, my lord. The very first overnight application IA was submitted when the child was 10 months old. When the child was 3 years old, there was no order in this court for any overnights or anything. I came to know that the child is going to school only in this court, my lordship. I was not even informed about. Just 1 second, my lordship. So in this context, my lordship, since the child is going to school, in order to get a decent bonding with the child, vacation custody was required, my
Fight
lordship.
the litigation in this manner, the court cannot help you. Court wants to help you that you are not understanding. Please go to the NIMHANS today. We'll take up this matter tomorrow. Let him get instructions.
Please, I will, my lord.
We'll pass
Much-
orders tomorrow.
Much of.
I'm grateful.
Use this matter tomorrow.
Interim order may kindly be extended.
Tomorrow, all your granted is extended till then.
My lord,
I'm
office
grateful.
objections are there regarding the recall. That may be overruled, my lordship.
Where are the office
That
objections?
cannot be overruled, my lord.
What are the office objections?
My lord, that is insofar as he is. I have my reservations, but I don't know if my learned friend has appeared before the committee. If committee has given him,
My lords,
he's appearing as party in person.
my lord.
Earlier,
after
he was
getting
represented by an advocate.
There are several misconceptions purported by the opposing counsel.
Don't refer anything to the other advocate. That's
Sure.
not, you're not supposed to do it. Whatever you want to submit to the court. Where is objection?
3.3.
Oh.
In that IA, he has filed recalling of the order of disposal, already disposed of the WP order. The WP
That we will see, that on the merits of it.
Yes,
Please, my lords.
Yes.
My lords, one small other request is my son's name is appearing in the daily orders, my lordship. That may be redacted, please, for his
In
privacy.
which order it is reflected?
310, vacation bench order 310. Kindly redact.
I give my
name.
consent, my lord. I give my consent to that.
In the order dated, which is the order?
3/10/2025.
It is, the name of the child is mentioned by the trial court. I think that's how the
Please,
coordinate
please.
bench has also carried.
Please, please, please. my lords.
In the order dated, it is submitted with the party in person. The name of the child is mentioned in the order dated 3/10/2025. Then if that has to be modified, it has to go to the very same judge. I can't do that. Yes.
I'm grateful, my lord.
My lordship, tomorrow, my lordship.
Cell
Much
number
obliged.
4, hearing on interlocutory application, cell number 4.
Sir, my lordship. Mutual consent divorce will file the trial court, my lordship. Mutual consent divorce will file the trial court, my lordship.
Your file.
No, my lordship, will file. Matter will settle within 3 weeks, my lordship.
By the moment you file a mutual consent, the court will grant.
My lordship.
I have 1 of 23 for early hearing filed by the advocate, for the petitioner.
My lord, I am for the petitioner in this matter, my lord.
So whatever things are happening, let them happen. Why should we keep it pending here?
My lordship, I'm the proxy counsel, my lordship.
Yes.
Yes, sir.
My lord, as the counsel has said, we are filing a mutual consent divorce petition, my lord, under 13B. So it may kindly be taken up after 4 weeks, my lord. By that time, it will be reporting settlement, my lord.
Against which order you are before this court?
My lord, it's against an order passed by the third 9th additional district and sessions judge on application seeking custody of the child.
It is in a GNWC.
Yes, my lord. That is also going to be dealt in the mutual consent.
What is the order? Let's not keep matters pending like this. It has nothing to do with that. What is this order?
My lord, the order is in page 23, my lord.
IA number 1 filed under section 12 of the guardian so-and-so seeking interim absolute custody of the minor child is rejected. However, the petition is entitled to visitation rights in the following manner. So, how can in an interlocutory application absolute custody will be granted?
Hello, sir. Are you audible?
Yes. Yes, my lord. Yes, my lord. I'm audible. I hope I am audible, my
Will
lord.
not keep this matter pending, Mr. Counsel. The order that is passed by the court is perfectly
My lord,
right.
it was passed 2023. It was passed, my lord.
What is that?
My lord, thereafter several attempts have been made and between the parties to mutually settle the matter, and finally, my lord,
Settle the matter. Settle the matter in whatever manner you want. As far
Yes,
as
my
this IA is concerned, there is nothing to interfere. I'll close this writ petition. If you want, I'll close, or else I'll file it. I will record. I will pass order on the merits of it. We'll not wait till the disposal of or the settlement.
My lord, 2 weeks time may be granted, my lord. We will file.
No 2 weeks. This is matter on 28th. No further adjournments will be granted. Is 5.
Preliminary hearing, cell number 5, Purnima HS for petitioner, Ashavardhan for Kevitar.
Paid for the KVT.
Yes.
Petitioner, my lord, we are challenging this is the second round of litigation filed by the petitioner seeking reduction of interim maintenance, my lord. The previously family court had
Please
passed.
come to the impugned order. Where is impugned order?
My lord, impugned order at page 39, my lord. Operative portion is at page 38, 39.
What is the order?
May I read out, my lord? I number 3 filed by the petitioner under section 24 of the Hindu Marriage Act is hereby allowed in part. Respondent is hereby directed to pay a monthly interim maintenance of rupees 25,000 to the petitioner from 3/12/2021 till the disposal of this petition. My lord, we are filed this writ petition seeking reduction of the maintenance on the grounds that, my lord, the custody of the child, 11-year-old son, is with me, and I also have to.
Income.
My lord, my income is, my lord, I do not have a fixed income, my lord. Presently, I am unemployed. I work on certain commission basis for some as a freelancer, my
You
lord.
must file your statement of assets and liabilities. As per that, what is your income? What do your bank statements say?
My lord, I
Have been recorded by the court. Come to that.
my lord, that is in paragraph 20, my lord, page 34.
Please read.
My lord, respondent has only stated that he resigned his job owing to the sending of repeated notices to his company by the petitioner. In his affidavit of disclosure of assets and liabilities, the respondent has neither stated the date of
For
resignation.
the income, for the assessment year 2024, 25. your
Please, my
income
lord,
is
was rupees 16,16,000.
690.
Yes, please, my lord. But my lord, the petitioner is earning, my lord, the respondent is earning, respondent wife is
What is
earning.
evidence for that? What is her earning?
My lord, she has also filed her statement of objection, my lord. That is at page 18, my lord, page 32. She has filed her assets and liabilities affidavit, and she contends that, my lord, her gross income for 24-25 is around 13 lakhs, my lord, 11 lakhs, my lord.
11 lakhs.
That is income of the husband, my lord, not the wife.
My apologies, my lord.
What is her income?
My lord, she is unemployed.
My lord,
And
she is unemployed.
once she had joined an NGO for 5,000 meager salary. But husband has gone there and humiliated her and made her to leave that job. This is the conduct of the husband, and every now and then he goes to her home and create nuisance over there, and more than 10 to 12 complaints have been filed against him. And he has violated all the conditions of the bail, and he has given life threatening to her, and even FIR and charge sheet has been registered against him.
Yes.
And
My lord, petty respondent has also caused problem in my workplace, my lord.
Just leave it.
That
Now,
is matter of fact on merits, my lord.
Your income is?
My lord, my only contention is that, my lord, I have the custody of the minor child who is 11 years old. I am taking care of the entire expenses of the child, and I'm also physically taking care of the child, keeping the custody. I have aged parents who are undergoing dialysis. My financial commitments are huge. I'm not able to spare 25,000 a month. It may be reduced to
Where are your
this possibility.
expenses? Let's see.
My lord, that is I have stated it in the affidavit, my lord, along with the IA. There is no proof for the expenses
in your statement
produced.
of assets and liabilities, that is what you're supposed to say.
Yes, please, my lord. That my avowments are a part of the affidavit, my lord. I have not produced any proof for the expenses as such. But I have stated it on oath, my lord, that I am incurring expenses of my
what are the
parents.
expenses? That's what I'm asking.
My lord, I spend, my father undergoes 12 dialysis for 12 times in a month, my lord. And that expenses alone comes to close to around 40,000 a month. And I have to I stay in a house for which I'm paying a rent of rupees 8,500 a month. And my lord, along with that, monthly expenses, miscellaneous, along with groceries and all household expenses comes to around 20,000. And I also incur school fees of the child.
How much?
School fees is, my lord, around 1,20,000, my lord.
Per annum.
Per annum. And along with that, other transportation and other child expenses.
Let's take it in 10,000 per month.
Yes, please, my lord. Lord, I incur on expenses of almost 1 lakh. This is a estimate, my lord. 1 lakh is subject to increase according to inflation, my lord. Now, my lord.
And your salary is 1.5 lakh.
Yes, my lord, but that is the CTC, my lord. What I take home is 1,25,000.
So, 25,000 is the reason in spite after spending all the amounts, still you're left with it.
My lord, that makes my situation hand to mouth, my lord.
No, 40,000 you're left with.
No, my lord, my expenses comes to close to 1 lakh, my lord, and it is not fixed, my lord. Sometimes there are miscellaneous expenses as well, because I have aged parents and the rent is also increasing.
Whatever that expenses you have given, they are coming to 78,000.
So, close to 80,000, my lord. 10,000 may be taken as miscellaneous expenses. which incurs sometimes and sometimes it's not. And I also have to do some savings for my son, my lord. I cannot spend all the money on my expenses alone. And she's an able-bodied person. She's also running some own small-scale business of her own.
My lord, one submission. Even the trial, before the trial court, we have produced enough evidence to show that he is running multiple beauty parlors and spa. He has more than income, 8 to 10 lakhs income. My lord. We have produced all the evidence, including videographs, his own bank statements, everything. Observing that the trial court has ordered only 25,000. My lord. Even I am ready to produce the same evidence before this honorable court, and in the assets and liabilities produced by him before the honorable trial court, he has declared his income around 1,50,000. Apart from only 1,35,000 as part-time income, and he has not disclosed that parlor income. And we have given all the evidence before the trial court.
Lord, that was already
My lord,
considered
kindly
by
see
the
page
trial.
number 27, my lord, paragraph 14.
Lord, that was considered by the
Paragraph,
trial court
my lord.
before passing the impugned order.
I will complete my answer.
Please, apologies.
My lord, kindly come to paragraph 14 of the
Read.
learned counsel for the petitioner vehemently argued that petitioner is unemployed and she has no sources of income. Respondent was working as a software engineer in Toltec Private Limited, and thereby he was earning more than 2 lakhs per month. Now he left the job to look after the
The age of the boy or the girl?
boy.
11-year-old.
11 years old. And before the trial court, they had suppressed the fact that his father is an earning person and he is getting pension from the two departments. He is an ex-army person and he is a retired government employee. He is getting a pension of more than 50,000 per month, his father. But they had suppressed that one, and we had filed application proving same, and then only they declared their income, his father income. Even earlier occasion.
Again that 40,000 they're spending on dialysis.
No. That is completely false. And one more thing.
Lord, I have averred that on
one
the
more
affidavit.
thing. What they have produced the address, present address, is they are not residing there. They have already left that address, and even the caveat notice was sent to that address. It has come that nobody is residing there.
My lord.
That they are, as per our information, he has bought some luxury apartment and they have shifted there. He completely misleading the courts. We have all the evidence to prove that, including his own bank statement reflect that he has.
My lord, that is a subject matter on merits, my lord. My lord, that is a subject matter
we
of
have
merit.
already given enough evidence.
My lord, my only prayer before this honorable court is that, my lord, let it be reduced to 20,000, my lord. Even sparing 5,000 rupees a month will be a benefit for me to take care of the child.
But when your father is an ex-serviceman and he's getting a pension, why did you say that you are spending 40,000 for him?
My lord, I'm supporting him, my lord. That is a genuine submission. I've averred on the affidavit.
What is happening to his money?
My lord, he is incurring more expenses than 40,000. He undergoes dialysis for 12 times in a month, my lord.
If you're saying that, then we can't.
Lord, he is undergoing dialysis 12 times a month, and my mother is also there, my lord. All those medical expenses, I am bearing it, my lord. It comes close to 40,000 a month, my lord.
Without placing any of the material before the court, we just give some figure and that the court has to accept.
My lord, this was all reconsidered before passing the impugned order, my lord. This is the second round of litigation on the same
income
order.
of the petitioner in this petition also, my lord. Every time they are suppressing their income.
Lord, it may be reduced to 20,000, my lord.
In MC number 6357 of 2021 dated 24th June 2025, whereby the court had granted 25,000 as maintenance to the wife. The husband is before this court. Then counsel appearing for the husband submits that the husband earlier was working, now he has no job. Further, he has to take care of his father, who is undergoing dialysis. He is spending an amount of rupees 40,000. He is taking care of the 11 years old child who is with him, and also take care of his mother. And all these expenses will come around 1 lakh rupees, and he's only left with another 25,000. It is submitted that the wife is educated and able-bodied women, and she can work and earn for herself. But for herself, it is submitted that after taking care of all the needs of the parents and the child and the petitioner himself, it is difficult to pay an amount of rupees 25,000 per month. Hence, the amount that is granted by the court may be reduced. Then counsel appearing for the respondent wife submits that the husband, apart from their job, is also having business and earning substantial amounts. It is submitted that the father of the petitioner is a retired ex-serviceman, and also thereafter he joined the central government, and from that also he resigned and is getting the pension. It is submitted that without placing any material before the court, just they have stated that the income, the expenditures is about 1 lakh. The wife is not doing anything, and whenever she takes up a job, the husband is coming there and interfering and humiliating the wife, and she could not.
That the wife is also doing, my lord. That may also be recorded.
She could not continue the job. It is submitted that the income of the husband is not correctly stated before the court, and they have all the evidence to show that he has come before the court with suppression of facts. In response, it is submitted that the court has rightly considered and granted maintenance, and there are no grounds to interfere. Then counsel appearing for the petitioner, in response to that, then counsel appearing for the petitioner submits that in fact the wife is also harassing the husband, and because of the harassment he lost the job. Next one, having heard so and so, so and so. As per the statement of assets and liabilities filed for the assessment year 2024-2025, the gross income of the husband was rupees 16,16,694. According to him, what are all the expenses of the husband? He has stated that he is spending 40,000 to the dialysis of the husband. He has not stated about the pension that is received by the father, and even no documents are filed in support of the expenditure that is incurred. There is no dispute about the fact that there is nothing, no, not dispute, there is nothing on record to show that the wife is earning. In spite of the fact that he's even considering the fact that he's taking care of the child and spending, and as the wife is not working and is financially capable to support the wife, court had rightly granted 25,000 as maintenance. This court finds no reasons to interfere.
One small submission. From the day one, they are not paying the maintenance. From the past 4 years, it is spending around 9 lakhs arrears is there, and they are suppressing that one execution petition. They are suppressing, and even today they are not paying them.
Who filed the MC?
Yes, ma'am.
Who filed the MC?
We only filed the MC.
Then file a petition before the court under 151 CPC.
We have filed the execution petition, my lord.
Apart from that, you file a petition under 151 CPC also.
Lord, kindly direct the respondent husband to pay the arrears.
No, an order is passed by the family court. It is not a court.
Yes.
And he is not paying.
So
why should there be a direction by this court? That's not the scope of this petition. Yes.
Grateful, Mother. Obliged.
Cell number 6, Declan Combs for petitioner.
Yes.
We are seeking for an expedited hearing for the trial court to conducted in an expedited nature.
Where is the case pending?
Third additional, my lord, family court.
Here is this MC. No.
My lord, 2022, the MC was filed. My lord, 2024 July, it was posted for cross-examination. Till date, my lord, it is still posted for cross-examination. IA to recall reopen has been allowed. Post that, my lord, they've taken 4 adjournments.
Will not grant any such order, will not issue any mandamus to the family court to dispose of an MC of 2022 when the MC of 16 is still pending on the file of the family court. Please come.
My lord, at least cross-examination stage could be.
I will not grant any order of any nature, and I have directed the family courts not to take up any matters which are after 2019. They have to first complete 2019 by December 15th of 2025. Thereafter, they will accordingly from the oldest matter they will take up. No, we will not grant any direction. Come,
My lord, only for
The-
the cross-examination stage because
They will not take up, I'm telling you, the writ petition is filed seeking the following prayer. When counsel submits the MCs of the year 2022, but still it is at the stage of the cross-examination, and there may be direction to the family court to expeditiously dispose of the matter. The family courts at Bangalore are burdened with work, and the matters right from 2016, even the matters of 2016 are pending before the court. And already this court has issued direction to the family courts to dispose of the matters from the old matters, and they have to complete the matters till pending till 2019 by December 15th. In those circumstances, this court cannot give a direction to the family court to dispose of an MC which is of the year 2022. Accordingly, this is.
Case number 7. Vijayalakshmi and for petitioner.
My lord, may kindly be pleased to come to the annexure G, page number 102. Annexure G, page number 102.
Yes.
On 30 October 2024,
Come to the impugned order.
not impugned order,
Please,
my lord.
then please come to your prayer if there is no impugned order.
This is a mandamus writ to
That's what I'm
direction
saying.
the dispose the matter within 3 months, because I have filed one IA number 3 before trial court under section 21B of the Hindu Marriage Act. The 21B of Hindu Marriage Act states that every petition under this act shall be tried as expeditiously as possible, and endeavor shall be made to conclude the trial within 6 months from the date of service of notice of the petition on the respondent. The respondent wife had not filed her objection to the IA number 3. Hence, I have filed on 29 January 2025 writ petition before this Honorable High Court of Karnataka in WP number 2760/2025 and 2785/2025, seeking writ of mandamus direction to the trial court to the dispose of an IA number 3 within a week. On 1 February 2025, the Honorable High Court of Karnataka passed the order and directed the trial court to expedite the matter in accordance to section 21B of the Act and dispose of the matter expeditiously as contemplated under the Act. The above said 6 months period was ended on 31st/7/2025.
Tell the court
Despite
MC,
of the order,
Please of which year?
my lord,
Of which year?
23.
Then what is urgency for that, for the court?
ಅಲ್ಲ
to-
21B ಪ್ರಕಾರ ಅವರು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ದೇ ಹ್ಯಾವ್ ಆರ್ಡರ್ಡ್ ಆಸ್ ಪರ್ ದ 21B ಕಂಟೆಂಪ್ಲೇಟೆಡ್ ಯು ಹ್ಯಾವ್ ಟು ಡಿಸ್ಪೋಸ್ ದ ಮ್ಯಾಟರ್ ವಿತಿನ್ 6 months ಅಂತ. ಬಟ್ 8 months ಆರ್ ಓವರ್, ಬಟ್ ಟಿಲ್ ಟುಡೇ ದೇರ್ ಇಸ್ ನೋ ಪ್ರೋಗ್ರೆಸ್. Order is there, my lord. Order is annexure L, madam. Annexure L, page number 134 and 137.
This is the whole difficulty. Now, when an order is passed for MC of 23, what will happen to the, what is the great, what is this exceptional case that your case has to be out of turn heard by the court?
No, my lord, I request, my lord.
Not request. Why should there should be some reasonableness in the request?
100% reason is there.
What is the exceptional nature of your case?
Yes, madam. I will explain. My first ground is the section 21B of Hindu Marriage Act says 6 months time. Within 6 months, he has to dispose the matter. And I am second point is desertion. I am already respondent is deserted the petition from 2018 to till date. That is 7 years already over. I am having aged parents, and I want to restructure my life.
That
And
is everybody's problem, Mr. Counsel. I cannot pass any order of disposal of an MC.
already the Honorable High Court has ordered.
If
my
ordered,
lord.
let them
Please,
do.
my
I
lord.
will not further order. Why every day you will come to the High Court and High Court will pass one fresh order, and there is no need. I do not see any reasons.
One last request.
If you want to withdraw, or else I will say that there is no urgency for this case.
One submission, last one submission. I will read annexure L, my lord. Kindly see annexure L.
That's what I'm saying. Supreme Court has time and again is giving direction saying that you shouldn't pass such orders. What is Why should the court decide the board of the trial court without any
I
reason?
need 5 seconds, my lord. I need 5 seconds. In page number 187,
I've seen that.
137,
I've seen
therefore, this honorable court is inclined to direct the principal senior civil judge and CGM Chitradurga to expedite the matter in accordance to section 21B of the act and dispose of the matter expeditiously as contemplated under the act. They are already clearly mentioned.
Anyhow, when order is passed, let them take care of it. The writ petition number, the 6 is filed seeking the following prayer. It is submitted that already directions are issued by this court and the family court has not disposed of the matter, but that another writ petition is filed. This court cannot entertain successive writ petitions of this nature and accordingly dismissed. Next, sir.
Cell number 8. Shantappa.
Yes.
The marriage was solemn. Marriage was solemn in 2020.
What is the impugned order?
The impugned order, your lordship may kindly page 34. The 34 that and relevant page number is that. Yes, IN number 4 that. 34 that. Your lordship may kindly see 34 that. The husband has filed the application under 12 of the Guardians and Wards Act that. His prayer, your lordship may kindly see application at
Celebrate Varamahalakshmi festival.
That is his prayer that. That for the reasons stated in the accompanying affidavit, this honorable court please to pass an interim order direct respondent to hand over the ward custody of the petitioner on 8/8/2025 for Varamahalakshmi festival and one very Friday from morning 10 to 5. This is the prayer that. Your lordship may kindly come to that impugned order that.
Take out notice.
Oh, what had happened that? Your lordship may kindly
summons
see.
to the respondent.
No, what had happened? Your lordship may kindly just annex F39. Your lordship may kindly see.
In
On the taking advantage.
Custody and visitation matters, I'll not pass any.
No, that your lordship may kindly see that I am not seeking any that. Your lordship may kindly page 36. Impugned order has been passed. That each and every day that 3.5 years old female girl is there. That each and every day to take the child to court. That she is residing at Bangalore. The MCP GNWC petition is pending before the Kolar court. That it is nearly 80 to 90 kilometers. That Bangalore to Kolar. That and 3.5 years old the female child is there. How can I get the each and every date of hearing? That it is very difficult on the part of the petitioner to take the child along with each and every date of hearing. That and your lordship may kindly see and taking advantages of this order. That he visit the petitioner house and nuisance. That he has come with.
First, please read the order.
That your lordship may kindly see.
Operative portion of the order.
IA number 4, section 12 is allowed. Liberty is granted petitioner to visit the house of the respondent and spend time with the ward and give any presentation if he wish. In the event petitioner visited the house of the respondent, then she should treat with him all respect and dignity and handed over the custody of the ward between 10 to 2 p.m. The respondent is hereby directed to bring ward all the dates of hearing to the court and handed over the ward to custody of the petitioner in between 12 to 2.
The family court by order impugned had permitted the father to visit the house and have the custody of the custody of the child between 10 a.m. and 2 p.m. and also further directed to bring the ward on all the days of hearing to the court and hand over the ward to the custody of the father in between 12 p.m. and 2 p.m. Then counsel for the petitioner submits that the mother is staying in Bangalore. And the court is a distance of?
Kolar, 80 kilometers.
80 kilometers, and it's very difficult to take the child on each date of hearing. Considering the submission and the order as far as directing the child, directing to bring the ward on all the dates of hearing to the court, it states no petition is for notice, and in addition, petition is permitted to take out hand summons and file a memo to that effect on the counsel for the respondent and file a memo to that effect by 12th of November if the memo is not filed by 12th, the stay granted by this court stands vacated. Yes.
Cell number 9, Sanchan Jainandan,
Emergency.
Petitioner Kumar KG, respondent.
Yes. No representation. List on 12th of November.
Cell number 10,
So the petitioner in this matter, my lords. My lords, we're challenging the orders passed on an application under section 26, in a petition under section 9, in a restitution of conjugal rights petition, and custody order has been passed on an application. Lords, copy of the Supreme Court judgment which says in a section 9 petition, an application under section 26, no orders can be passed. A separate petition to that effect has to be filed for the custody of the child.
It is for the visitation, you might have.
Please, but here, my lords, custody has been granted. Custody for Saturday and Sunday has been granted. If my
That is, you can't call it a custody. It is
my
not
lord,
a
the order
custody
clearly
at all.
says, no, my lords, if my lords may
It's an
kindly,
interim visitation,
Correct.
custody. It
Correct.
can be, there are judgments to the effect there are judgments to the effect.
Please, my
The
lords, but-
family court under the, in a pending MC can grant
but
the,
the petition is filed under section 9 by their husband.
whether
He
it is
files an
section 9
application.
or a section 13.
Please, my
Parties are before the court, the welfare and the life of the child is involved. So how does it make a difference? Court cannot grant custody means it's a final custody, not an interim order.
Here,
Take that order.
here what it says, my lords, if my para number
There are
17,
judgments, sir. There are judgments to that effect. Take the
sorry.
judgment.
page 7, page number 2, my lords, para number 7.
Yes.
The respondent should have filed a separate and independent petition under section 26 of the Hindu Marriage Act instead of securing an order in the proceedings pending under section 9 of the Act. The order dated giving visitation rights or temporary custody of the child to the
Petitioner,
respondent
this
is thus
this
patently
a
illegal.
transfer petition.
Please, but in that also there is a mention about that, my lords.
That's not that, you cannot call
But-
it a ratio.
Please, my lords. But otherwise also, my lords,
There are judgments.
please, if your lordship may
Just
kindly
straight
see
judgments on that.
page number 17, the impugned order, my lords.
Yes, please come.
Here it says the petitioner is entitled for custody of the child on every Saturday and Sunday till further orders.
What happens?
Please,
then?
my lord, we've been complying, no doubt. Even otherwise also, even though it was not challenged, we've been complying. Now what is happening, my lord, there is no place. He is a resident of Kolkata. The father was earlier a resident of Netherlands. Now after the court directed him to appear, if not, he would dismiss the case. He appears before the court and tells that we've not been complying with the orders of the visitation, which we've always been doing. There are also emails attached to that. Subsequently, my lords, whenever we've met him with the child, there are 3 instances of him physically abusing us, towards which there are NCRs. Now, this order doesn't even say what is the time that the child can be taken to, or the place, or what is the time frame.
As an interim order will specify that.
Please, my lords, let that be
Come to-
specified, my lords.
Please come to the order. Where is it? Page number?
My lords, page number 17, my lords. Even though the visitations were being complied, my lords, he seeks.
IA, what he is supposed to, the IA for visitation.
Please, my
Instead of
lords.
saying that.
But the
so you
custody
have,
has been.
You have taken advantage of
No,
this.
no, my lords, he is taking advantage of that. Now he is started telling that Friday evening I'll pick up the child and from school I'll drop the child back to school again on Monday morning.
Petition is entitled for custody. Where is this application? Come to that application.
Please, my lords.
IA.
IA number 1, my lords, at page number 34, my lords.
Hmm.
Here he seeks for visitation rights, but it doesn't mention as to at least where would he take the child. He doesn't have a residence here.
Of the child.
10 years now, my lords. My lords, as recently
To
as
meet his son at the venue mutually agreed upon the parties and to permit the petitioner to take out of his child to any place which the child choice or interim custody.
which we have been complying with.
What is this?
Principal, second additional senior civil judge Anikal. The orders were passed by principal senior civil judge Anikal. Now it is pending before the second additional, my lords.
No, he's having overnight custody.
Presently, my lords, recent 2 incidents, he's physically abused the mother and the child. So there was an NCR also registered to that. Subsequent to that also, we informed him. He's also got an order for assisting you in visitation with the police. So we told him, you come before the regular police station, give it in writing. that he will not harm us. You can take the child for visitation. To that he's not replied, neither has he appeared there, my lords. The emails are there to that effect, as listed as last week, my lords.
Where is that?
It's page number 85, my lords. Page number 84, email dated 3rd October 2025.
Mm.
Given the last incident on 21/9, wherein you had physically assaulted me in front of public, that all the trial emails are with related to that itself, my lords. We even told him, you come there at 11 o'clock. Lords, 4 weekends we waited there for him to come. He doesn't reply to that. Neither does he turn up there, my lords. Because he himself has obtained an order to take the assistance of the police for the visitation purposes.
Please come. Agreed with the order passed on I number. What is this IA?
1, my lords.
I number 1, whereby the court has granted custody to the father on Saturday and Sunday. The mother is before this court and counsel submits that in a petition filed under restitution of conjugal rights, the father cannot seek custody and you ought to have filed a separate application. Further, it is submitted that even before the order is passed, wife or mother is granting.
Lordship,
permitting.
one humble submission, my lords. Even before that order was passed, there was a restraining order that was obtained against him, which was not disclosed before this court by getting this order, my lords. 23/9, he gets a restraining order against him.
Before this order is passed, the mother has obtained a restraint order. It is submitted that the father has assaulted the mother and assaulted them in the public. And in this, in this regard, the NCR is filed. And also, they've exchanged the emails. Those emails were filed before this court. It is also submitted that the court has simply stated that the father is entitled for the custody of the child on every Saturday and Sunday till further orders. And the court has not even mentioned any time. It is submitted that if the father gives an undertaking that he will not assault or physically harm the child and the mother has no objection for the father to have the visitation.
Please, my lords. Please, my lords.
Visitation. In these circumstances, the order dated, there shall be stay of all further proceedings. Pursuant to the order dated, date of order is
My lords, 10/12/2020, my lords.
10. What is this order?
10/12/2020. Subsequent to that, it was only posted for mediation and settlements.
But how can you question an order of 10/12/2020?
We wanted to comply because no proceedings happened subsequent to that, my lords. Now is when he comes with the police custody orders, my lords. My lords, as latest as 23/8.
To take out hand summons on the council appearing for this bond.
My lords, let there
File
be,
a memo
my
to
lords.
that effect.
No, my lords, at least with regard to the visitation, let there be, my lords, because the matter is posted tomorrow. And
Let it be.
my lords, he is planning to take the child away to the Netherlands.
Just because there is no limitation to file a
No,
writ
my lords,
petition,
we
you
wanted to
cannot come
settle.
after
No, my
5
lords,
years.
we wanted to settle it. Till date, my lords, for 4 years, he was in Netherlands. He doesn't turn up.
Once the memo is filed, then.
That's
then
one
this
humble
is-
submission, my lords. For
I
4
will not- I'll
years,
not interfere.
for 4 years, he did not turn up for the
Let it be.
mediations also, my lords. Plus, the matter is posted tomorrow. Let me be directed to hand serve.
Let it, do it. That's what I've already passed that order issued.
Please, my lords.
For the hand summons.
Because, my lords,
While the
for
memo, it
4
is
years,
registered.
for 4 years, we've been harassed by him, my lords.
But
That was the reason we asked for the stay of that order.
I can't interfere. There can't be an ex parte order for an order passed on an impugned order of 2020. Yes.
Cell number 11 adjourned. Cell number 12 Prakasham Patil for petitioner.
Yes.
Ashit B.
For
Kavita.
respondent,
There may be a short accommodation. There may be short accommodation.
Lord's last date of hearing also.
At the request of learned counsel, the petition lists this matter on.
My Lord's last date of hearing also they took adjournment, my Lord.
Is there any interim order?
Interim order is there, my Lord.
Huh?
No, my Lord.
Then what is urgency to you? List this matter in the month of December at the request of learned counsel, the petitioner. Don't give a date.
Cell number
Much
13
obliged.
Vishwanath Shetty B for petitioner.
Petitioners,
Sir, sir.
in this matter,
Yes.
the small mistake crept in the revenue documents concerned, my lord. Small mistake which was crept in the revenue documents, my lords, please. In this case, my lord, the respondent, petitioner number 1 is the husband of the respondent, my lords.
What is the impugned order? First,
My lord, impugned order is, my lord, passed by the Honorable Executing Court at Annexure M, kindly. Annexure M on the basis of the memo Annexure L.
page number.
My lord, page number 113, my lords, please.
Yes.
Execution petition 1 of 2007.
You are the JDR.
My lords, please, I am JDR.
JDR husband.
My lord, petitioner number 1 and 2 are both are JDRs. Respondent number 1 has paid. My lord, this is a case where a settlement is arrived between the
Who are petitioner 1 and 2? What is the relation?
petitioner number 1 is the husband of the respondent. My lord, petitioner number 2 is the first wife's son of the petitioner number 1. My lord, 20 guntas of land is held by both the petitioner number 1 and that is 10 guntas each. Petitioner number 1 who acquired in pursuance of a partition in his family. Petitioner number 2 from his mother's side, my lords, in the same survey number, 10 guntas he got gifted. My lord, the respondent, second wife of the petitioner number 1, files case for maintenance. I am not disputing the fact that, my lord, it is settled between the parties. The land is in survey number 63, my lords, please. In survey number 63, the 3 guntas in the land of petitioner number 1 agreed to give to respondent. Similarly, petitioner number 2, entire extent of, that is, though he is first wife's son, he agreed voluntarily, though not party to the proceedings, he was present with his father. He has agreed also, I am not disputing, even now also.
So you have agreed to give 20 guntas of land.
With, no, 13. 3 from petitioner number 1, 10 from petitioner number 2. My lord, survey number 68/3, it is agreed and joint memo is filed. We were ready to execute the document. In meantime, what happened, my lords, please? As on the date of what settlement happened between the parties, survey number was 68/3. Both the petitioners are also agriculturists. They continue, they had no occasion. But as on the date of the gift deed to obtain where the respondent number side in execution petition decree holder, it seems, your honors, please, the other owners of the same survey number, they got subdivided their portions. By that time, my lord, for the land of the petitioner number 163/7 is assigned. For the land of petitioner number 2, 63/8 is assigned, my lord. But it seems the advocate for the decree holder, when you verified the RTC extract, it's in 63/7 and 8 new number, which is assigned subsequent to the settlement and all. He found that and filed a memo stating that the judgment debtors have misrepresented, judgment debtors council has misrepresented.
When this subdivision had taken place?
My lord, that is subsequent to this 2017 or so. I produced the documents.
When is the compromise?
My lords, please.
When is
Compromise is in 2014, my lords, please. By that time, it was the same. Up to 2017, it is continued.
And 2014?
Anyhow, my lord, even now also, my lords, please, my humble submission. We are ready to execute with this new number.
What is this order?
My lord, the order is as if the counsel for the petitioner and petitioners before my lord and petitioners are misrepresented.
With liberty to
Ask us. My lord, all these things. It has not.
To take
Please,
legal action, both
please.
civil and criminal, against them.
We are ready to give the land, my lord, absolutely. And whenever they come with the deed, we'll sign.
Page number 114.
114?
13 he read there.
114 or 5?
114. She is at liberty to file a fresh petition for maintenance. Further, as JDR number 123 played fraud on this court and responsible for pending this matter for more than 7 years, it is just and necessary to impose heavy cost. Cost was imposed 1 lakh rupees, and the maintenance, it is 96,000. This is all pending. And the compromise was taken place, and that was not effected since 11 years.
My lord, there is a reason that. My lord, the daughters of the respondent, my lord, who barred to the petitioner number 1 through her, they filed a suit for partition. For that purpose, this execution petition was closed as suit was dismissed. They were not entitled for share. Then appeal filed by the daughters was pending. Finally, matter has reached this honorable court in RFM.
So how does it matter?
No. The executing court, since this property is also subject matter of that, has closed the execution. We have not refused. My lord, execution court closed it.
No, you execute the same.
No, no,
I am ready, my lord.
Execution,
My lord, you-
execution court
My
has.
lord, let them come any day. My friend informs.
You execute the same day.
I'll execute. No, gift deed. It would
That's what
it would cost less to them also. We are ready, my lord.
Yes. When are you
That
going
my
to
endeavor is also to see that,
When are you going to execute?
my lord, whenever they got prepared, the document informs me. I'll see that
For
within.
compliance,
Can
first
we-
week of November. Please.
Absolutely, I am not to deprive of her right, my lord.
Land council?
My lord, please, so.
Huh?
No, order for the cost which has to be paid and the maintenance which.
My lord, suppose if we have misrepresented, definitely we are bound to pay. It's
Alala,
number,
Alala,
subsequent numbers
DHR to
paid by
proceed
the
against
survey
GDR 1 to
authority.
3 and their advocate to take legal action, civil and criminal against them. It is the order. The senior civil judge has passed an order to take action against advocate and JDR 1 to 3.
Why to take action against advocate?
Because the plate fraud, they given
What fraud he has
misrepresentation to the
paid?
court and.
What is the role of the advocate?
That was there. That was. The order is, I read the order, what the order was passed by the senior.
The land council appearing for the petitioner submits that. The petitioner is always ready. Petitioners are ready to execute the
Registered gift deed.
Registered gift deed to the
To report
in favor of
compliance.
the respondent whenever she is ready. Land council appearing for the respondent submits that. In the first week of November, she'll come with she'll prepare the gift deed and comes and they'll be ready for the.
We'll report this court after this court.
No.
Court are reporting to the court, then order may be passed.
Maybe.
Why to report to this court?
Because
First of all, you go, get the gift deed executed, then inform the court.
Please.
That on November 4th,
Much.
on the November 4th, the petitioner shall execute the same gift deed in favor of the respondent. This is matter on 11th November, and by the date, on November 4th, if the gift deed was not executed because of any lapses on the part of the petitioner, on the next date of hearing, court will pass orders on the merits of it. Yes.
Cell number 14.
Interim order is there.
Interim order earlier granted is extended till that.
Cell number 14. Rajshekar S for petitioner. Nankumar Shetty.
Petition may not be maintainable, my lord.
What is this?
Executing court has finally disposed of the execution petition. Family court, my lord, under section 18, an appeal will have to be against every order.
The petition is maintainable for two reasons. One, my lords, earlier,
Where is impugned order?
my lords, impugned order is at annexure A, page 12.
Page number?
Page 12, my lord, starts from page 12.
Hmm.
Operative portion is at page 20. Execution petition filed under order so and so is hereby allowed. The objections of the JDR is hereby rejected. JDR is directed to make the payment of the execution amount without fail. Lord sir.
Section 18 may kindly be perused.
Yes.
Now, my lord sir, on an earlier occasion,
Section
this,
18
now,
of the
now kindly
Family
see, my
Courts
lords, now kindly see what was the decree, my lords. Initially, my lords, in the year 2020,
Lord,
2014,
May I read? Section 19.
According to it's a final order.
It is a final order. It is a final order. Save as provided in subsection 2, notwithstanding anything contained in Code of Civil Procedure Code 1908 or in the Code of Criminal Procedure Code or in any law,
According
an
to you,
appeal
how
shall
it is
lie from every
That's,
judgment or order.
In the light of 19.
now, my lords, since they have suppressed the subsequent filing of MC petition and obtaining an order, judgment and
There is
decree.
nothing. That MC petition has nothing to do with this order.
No, I will point out, my lords, only.
For the court under 226.
Lord sir. Now, my lords, sir.
On the ground of fraud, natural
No,
justice.
that is one aspect, my lords. Now, kindly,
First of all, under section 19, this is a final order.
yes.
Against the final order, you cannot file a writ petition.
Lord, sir.
This is admitted. This matter is admitted. Not
Rule,
admitted.
rule is not issued, but B group.
What is no, that issue apart, what is it?
Now, my lords, earlier, my lords, in the year 2014, MC petition came to be filed, which your lordship will get at annexure B, page 21,
MC is filed by husband.
filed by the husband,
Seeking,
seeking for, my lords, restitution of conjugal rights.
what happened to this?
That ended in compromise. Kindly see page 26. That is what is now sought to be executed in the present.
Compromise dated
Compromise dated, my lords, 26/3/2014. 26/3/2014.
Where is that?
Page 26, my lords. Page 26, annexure C.
Hmm.
The relevant is, my lords, page 27, clause 7. The petitioner shall pay rupees 4,000 every month to the minor child so and so. He shall deposit the amount in the account of so and so, Karnataka Bank so and so.
So every month you are supposed to pay.
I am supposed to pay. Now, thereafter, my lords, kindly see clause 11. In case the petitioner is unable to take them abroad, the understanding was, my lords, restitution was agreed. And in the event if I am unable to take them abroad, he shall make a rented house and shall look after the rent and other household expenses apart from paying 4,000 rupees to the child. Then, my lords, this as per the terms of the present compromise, she was supposed to come and lead a life with me. Then, my lords, that particular compromise did not materialize. She files a petition, my lords, in the year 2019, seeking for dissolution of marriage, which your lordship will get at page 33, annexure F. There, my lords, kindly see the operative portion of the order, which your lordship will get at page 60. Page 60. Dissolution of marriage is decreed. The prayer for dissolution of marriage came to be decreed. Apart from that, I was directed to pay an amount of rupees 10 lakhs towards permanent alimony. This was subsequent development, my lords, which took place in the year 2019. And this particular decree came to be passed on, my lords, 4th March 2023. I have assailed that by filing appeal before.
In between 2014 and 19,
Yes.
wife has not filed the execution.
She has not filed the execution. She has not filed. We were living together. Then, my lords, for obvious reasons, differences again cropped up. 2000, my lords, 19, she files the
Then
same.
when both of you are living together, where is this clause of 4,000?
There was not, that is my contention, one contention.
Subsequently.
And second,
Subsequently, my lord.
subsequently, now I'll come to that. Now, my lords, subsequently, my lords, this honorable court.
In an MC that is filed for restitution, entered into a compromise.
Yes.
When both the parties, as per the compromise, when both of them are staying
No,
together.
they were not living together. No,
As on that day when the agreement is entered,
no, my
they
lord.
were supposed
There
to
was,
stay
no, they
together.
were not living together. Therefore, an application for restitution of conjugal rights was
No, no,
you
by the
entered
husband.
into a compromise.
no,
That was compromised.
In that
Compromised, and the wife was had agreed to join the husband.
Correct. So where
My
is
lord,
the question
thereafter,
of-
my lord, differences.
2019.
No, please understand the question. This is a compromise entered.
Yes, but in
subsequent
the
to
year
a-
2014.
In the compromise, why are these clauses of paying 4,000 household
To the
expenses?
child, man, to the child.
But they're staying together.
Now, they are not staying, my lord.
Now,
they are not
2019
staying
onwards.
together.
Now, kindly
And
see
his
one more
liability to
development.
Maintain the child still arises, my lord. He has to maintain the child.
Kindly see the
Child,
subsequent
my lord,
development.
it is the
I'm
question
not
is
talking about the subsequent development. I am referring to the compromise memo that is filed in that restitution petition. As on that day, both the parties have resolved to stay together.
Yes.
When they have resolved to stay together, where is the question of these expenses? That's what I'm
Not
asking.
expenses, my lord. 4,000 rupees to the child. That's all. He has to maintain.
When
my lord.
both of them are staying together, where is the question of?
No, my lord.
paying
Subsequently also he has to maintain the child. He has to maintain throughout, he has to pay the amount. Not only during that period.
Something is very strange in this agreement, in this compromise. I can understand if they want to live apart and then you have the arrangement for what is the amount to be paid. When you want to stay together, what is this arrangement? That I'm not able to understand. That's what I'm asking.
But that is the decree, my lord.
Hmm.
That is the decree which has to be followed.
Which has to be executed before this, when they, after that you filed
Yes.
this MC for divorce.
Yes.
That is decree.
That is ended in
2019, till the decree of divorce is granted, you have not, you have not touched that
No.
for the execution. When the execution is filed?
2023.
2000?
No.
Execution case number 51 of 23.
Let's see that execution petition. Where is that?
Page 79.
As per the compromise.
As per the
petition.
compromise annexed to the decree, respondent shall pay rupees 4,000 every month to the minor child by depositing same in the account of so and so deposited. Amount due from April 2014 till date 4,50,000, 56,000.
Hmm. Yes.
This was the demand. Now, my lord, subsequently in the year 2019, she goes and files MC petition seeking for
That
dissolution.
is between you and your wife. This
Yes.
is pertaining to the
Now,
child.
there, my lords, she claims permanent alimony. That is why I requested my lords to kindly see the division bench order at page 77.
Hmm. Yes.
This is, my lords, assailing the order passed in MC filed by the wife.
Hmm.
This order came to be passed interim stay of execution of the impugned decree. So for it relates to permanent alimony subject to the appellant depositing 5 lakhs. I have complied with this order. Now virtually, my lord, sir, she is making me to, my lord, face parallel proceedings.
Oh.
Now, on one hand, she claims maintenance, my lord, sir. Kindly see the
Maintenance to herself.
my lord, sir, the maintenance, what is her contention before the family court is with regard to minor child again. In the MC petition also, kindly see, my lords, yes.
MC is filed. Permanent alimony is granted to the wife.
Now, permanent alimony is granted to the wife. My lord, sir, in the petition or contention, what she has taken up before the MC court, family court in the year 2020 to 2019. My lord, so that she has to look after and manage the minor child as well. This is the contention. Yes.
Whatever it is, you have agreed and you said that you will pay 4,000
Yes.
or 4,500.
4,000.
4,000 per
4,000.
month to
4,000.
the child.
Yes.
So whether you are paid or not is the only question.
Yes.
If you are not paid, you are supposed to pay.
That is what the order directs.
My contention is only this much, my lords. From 2014 till 2019, my lords, there was no claim. In 2019, she goes and files a divorce petition. Then, my lords, in the year 2023, she comes up with a plea that, my lords, there is a compromise decree, execute that.
Even from 2014 to 2023, she has the time to file the execution.
12 years.
12 years is there, no doubt about it. I am not on the issue of limitation. I am only on these 3 grounds.
Yes. Will dismiss. Please come. The presented petition is filed. Agree to the orders passed in execution case number 51 of 2023, dated 25th November 2024. The petitioner before this court is the husband. The parties are referred to as husband and wife for the sake of convenience. The wife had filed MC number 61 of 2024.
Husband
Has filed MC number 61 of 2024, seeking restitution of conjugal rights that came, and a compromise was entered between the parties on 26/3/2014. As per clause number 7 of the said compromise, the husband has to pay 4,000 per month towards the expenses of the child. Thereafter, in the year 2019, the wife had filed MC 460 of 2019 that came to be decreed on 6th March 2023. As for the same, an amount of rupees 10,000 is awarded as permanent alimony. The wife had filed
10
execution.
lakh.
10 lakhs has been awarded. The wife had filed execution case number 51 of 2023, seeking for recovery of that 4,000 amount from the date of compromise, the date of compromise. That came to be allowed by order impugned, whereby the court has allowed the execution petition filed by the wife on the objections of the husband judgment debtor are rejected. And the judgment debtor is directed to make payment of the amount without fail. Land counsel appearing for the petitioner husband submits that the order is passed in the year 2014. That the compromise in the restitution petition is in the year 2014. Thereafter, in the year 2019, she has filed the MC for divorce. In that, all through she was claiming the maintenance for herself and for the minor child. And by virtue of this order, he is made to pay. He has to face the parallel proceedings, and already permanent alimony is granted. In those circumstances, the court was not right in passing the order impugned. Next para, and counsel appearing for the respondent wife submits that there is a compromise decree dated 26/3/2014. As per the terms of the compromise, he has to pay an amount of rupees 4,000 to the wife, to the child, and admittedly, which he has not paid. It is submitted that the court had rightly considered and passed an order, and there is no interference is called for. Next, having heard the concerns on either side, there is a material on record. Undisputed facts in this case are the husband has filed MC 61 of 2014, and there is a compromise decree where the husband has to pay 4,000 to the child. Admittedly, the same is not paid by the husband. The permanent alimony that is granted is to the wife. As he has paid the permanent alimony to the wife, it will not absolve the his liability to pay the amount of 4,000 as per the compromise decree dated 26/3/2014. In the constant opinion of the court had rightly allowed the execution petition, and there are no grounds to interfere. Accordingly, dismissed.
Great.
Great.
In Sarvana as for petitioner.
That's okay for the petition in this case.
Yes.
Under the impugned order notes, annexure D at page 42. Now, the respondent husband was given an interim visitation right of a child. Now, this was on 20th March.
Read the order.
No, sir, we have no difficulty in this order. Thereafter, notes what happened. There was a hesitation.
This order is dated 23/2024.
No, there was hesitation from the part of the child to meet a father.
You're the mother.
I am a mother. Petitioner is the mother. Respondent is the father, is the husband, and he is the father of the child. No, this was the order in the March 20th of 2024. Not as I said, not the father abandoned the company of the child in the year 2020. Petition was filed in the year 2023, and order was passed in the year 2024. Now, despite mother, she made a best efforts to ensure that child meets the father. But for some reason, the child not.
What is the age of the child?
Not now is 12 years notes. He's present, but I have kept him outside the court. Lordship wants to interact later notes. Not immediately within 5 months notes on 6/8/2024, he files a petition before the family court stating that the mother has disobeyed the order. She should be detained in the custody. Not that was proceeded ex parte. We didn't have the knowledge of that proceedings. Only we came to know that not that petition is filed. Not we are compelled to file that challenge that order, because the miscellaneous court also said until that order is there, court is helpless. Notes may take notes few correspondence what has happened from the order passed from March 2024.
This is an ex parte order.
Not this was a order considering both the parties. Thereafter, not within a span of 4 months, he files another petition.
No, what was she doing without questioning this order dated.
But that is the reason. That is the reason. Notes, I will take your lordship notes straight away to annexure H, my lords, at page number 87. Lord, lordship will get the email correspondence between the respondent and the petitioner. Lord, the first, my lord, after this is the 15th April 2024. Then, my lord, the second one is 16/5/2024. Lord, 16/5/2024, respondent, Lord, he intimated the petitioner that he will be coming to mediation center. Next page, notes 88. This is the response by the petitioner. Will be available on 18th May, 3rd Saturday, 2:30 p.m. to 5:30 p.m. in child visitation room for Bangalore Mediation Center, so and so. Then, my lords, then he replies, running late by 30 minutes, we have reached. But the child, my lord, some hesitation. His child is not willing to go. Then kindly see next, my lords, next correspondence, 31/5/2024. Then also, my lord, the second one response. With the true intention, wanted to bring him along at 3 p.m. as per order, as he has to prepare for his school that starts tomorrow and is not inclined to come. Apologies, we will not be able to make it today. Then, my lords, page 89, this is June 2024. He was given visitation notes on the first Sunday and third Saturday. Not then, not lordship were to see next mail correspondence. There also 14/6/2024 response coming to mediation center in 10 minutes now. They have reached. Child is not willing to go. Not it so happened. Then again on 7th July 2024, as informed earlier too, he is not willing to come meet you today too. But I can demonstrate from each mail and correspondence that there was no intention on the part of the mother. And other hand, my lords, what happens in the August 2024, he files a miss.
If that is the case, instead of sending emails to the husband, what you are supposed to do?
But I brought her. That is the reason we have reached the mediation center.
Supposed to go. You are supposed to file an IA before the court. You should seek a modification, or you should come before this court. And you just can't keep quiet and say,
that is the reason.
Sorry, we won't be able to make it as my son is not interested to meet you. That's not the communication.
But that is the reason that now we have been before your lordship. Let now one more efforts be made by this court also. I kept the child also present. He is now grown up. Not one more. Not for a moment.
Why the mother? She is educated. She know an order is passed.
Yes.
On 23/20/24. Nearly after 1.5 years after the order is passed.
In between,
the court.
In between, she is taking the. There was an order that I should take on Saturday. I should take the child to mediation center. On Sunday, I should take to Orion Mall or someplace.
This is August 7, 2024.
Yes.
She says about then. Every day she says he is not interested, he is not interested.
Then
ultimately, what is it? You are not complying with the order of the court, which should be in the notice of the court.
But therefore, we have.
What the court do now? Please come to the impugned order.
Impugned order is that.
Contempt is filed now.
Now, miscellaneous petition is filed. That has proceeded ex parte. We didn't know about that proceedings. Now, that matter is also posted for orders. Posted for orders. The court says.
1 minute.
Court says that order is in force, that court is also helpless, that this order should be challenged.
Yes.
We have no difficulty.
It's not about difficulty.
I represent the respondent, my lord. Kindly turn page number 58 of the petition, my lord. Page number 58. It is the order sheet of miscellaneous petition number 91 of 2024. On 21/9/2024, the respondent duly served and she placed ex parte.
If really mother is vigilant in this 1.5 years, so much of she would have convinced him, or else she could have taken him to a counselor. She could have done something. What is the reason for
now also that court can direct for counseling.
Page number 59, my lord.
Yes.
On 4/1/4/2025, counsel for the respondent appeared and prayed time to file his wakalat and contest the matter.
This is on 7/8/2020.
No, the recently.
1/4/2025, page number 59, my lord.
2024 is not exactly. No. Page 58, look at 59. When he has filed this application.
No, this is filed on my lord's 6/8/2024.
Yes. 1 year back.
No, but that we didn't have that knowledge of this filing, of this miscellaneous proceedings.
Why you are not contesting the case?
Not I not kindly see not at page number 62. It is only not they have served me on 1/4/2025.
No. Notice to respondent as per the bailiff endorsement
Not
served.
not
It is on 21/9/2024.
it's 21/9/24. Not she said.
We can't allow this kind of the smart play.
Not she's employed. Not she has to take.
She will face the consequences of it.
Kindly.
She should have some respect to the orders of.
She has not. She has not. Kindly come to page number 31. Only one para lordship may have.
They can't take it for
No,
just
minutes.
like that granted.
No, minutes.
30?
Page 31 minutes. That para 18 minutes.
Yes.
Mr. Lordship may go through that para 18 minutes.
All this we can't appreciate in this application.
The difficulty is there is two properties standing in a name. As I said, not 2020 abandoned. The child is hesitating to go with the father. Lordship may have interaction with the child. If Lordship finds my reason is genuine, then Lordship may of course pass any order.
When did he meet the father last time?
He is not met at all. He is not willing to go at all.
Oh, why? There should be some reason.
This is the reason. Whatever has happened in the past.
How old was he when he left
10
the
years,
father?
10 years. It was 10 years.
From when they are living separately?
From 2020. Even before to that, but 2020.
He is 20.
He is 12 years.
12 years old.
Yes.
Then as on that day, what
10
was
years.
his-
9 years, 9 or 10 years.
He will be 7 years old.
She was born on 2013, February
7 years old
2013.
he was 7 years old as on that day. So from that day, he is not able to forget what the father has done. and
No,
he
this
is not-
petition is filed in the year 2024.
Hmm.
Sorry. 23. Petition is of year
Of the
2000.
reasons the court is not at all convinced with
Lordship may have one chance direct to go before the counseling also. Father and child.
She should have done it by this time. 1.5 years. She wasted just like that.
She has to take care of
All
the
this
child.
communication,
She's the only person she has to go for employment and also take care of the child. She didn't have any
What
time.
she's doing now,
Their
she could
parents-
have done it long back.
But her parents are also died. There is nobody for her. She's stand alone. She has.
Anyway, she has come today. That she should have done it long back.
But that we told her, but in fact we told her to file an application for recall also. But since the matter is posted for orders,
Let the son be taken to the counseling. Let father, mother, son, everybody undergo counseling.
Let
Let him
Lordship-
meet the father.
as a last
That's
resort,
the only.
as a last resort, Lordship may direct not for a counseling. Let them go. Whatever report comes, Lordship will be in a better position to appreciate.
What do you say, Mr. Counsel?
Lord.
Mr. Venkatesh?
No. Cleverly, they have not filed the order sheet of the miscellaneous petition.
You want to meet your son. You want to meet your son.
Yes,
I don't
ma'am.
think it's your intention that your wife should be punished.
Please, Miller. No, Miller. No, I have no intention to punish the mother, Miller.
So,
My only concern is to pay the order passed by the honorable court.
2 o'clock. Let them be directed to its respondent to be keep present.
how can he come in?
Please,
Let the child be present.
please.
Today, Miller, may I make a petition, Miller?
It seems the child is there in the court, so we'll meet him at 2 o'clock today.
2 p.m. in chamber, sir.
And we'll, after lunch, we'll take up the matter. Yes, next.
Sir, number 16.
For the respondent, my lord.
Before the petition, I have filed
Number
my wakalat in
16.
this matter. Lord, wife's petition, my lord, challenging an order of visitation granted by the trial court. My lord, on the question of visitation, my lord, there is no quarrel. It's only about the time, my lord. 10 to 6.
Next is Vega City Mall. There is an order here.
Yes, your lordship's order.
My lord, if I may please submit about
They
how the
accompany
previous
child
visitations
and,
went.
Saturday, Sunday, that is on 11th and 12th October.
Yes.
Yes,
The father can exclusively shall have the visitation of the child.
Yes, my lord. My lord, on the previous date, on 4th and 5th, the child was sick. That was what was informed. And on 11th and 12th, the mother expressed some discomfort in making the child meet at a play area or a mall. So we were asked to come to a park. We're okay with whatever place. We're okay with whatever timings. What is convenient for the mother and child, we're okay with that, my lord. We just want to be able to meet the child. And if the mother may please be directed not to talk about any of the case-related aspects or any of the aspects
How old
between
is the boy?
the boy is
3
only
years.
3 years old, my lord. Even if we want, we have to come to the child's.
Even if the mother talks, what he'll understand?
My lord, it's not about that, my lord. On 11th, in the mall that they went to, the mother hugged this child and was saying, I've made a mistake by giving birth to you. Like, it's in emotions. We are not here to vilify the mother. We don't want to cause any more acrimony than it is there. We just want the father to be able to meet the child. Even if the father has to come to the society during if there is a play area to meet the child, we're completely okay with it. If the mother wants to supervise that also, we're okay with it. We simply want to be able to see the child. On 2 weekends were granted to us by this honorable court. We met the child on 11th and 12th, a total of 4 hours only across these 2 days, 4.5 hours only we got to see the child, my lord. And even the video calls, the honorable court had directed that it would be continued. One humble submission is, if the mother can turn the laptop to the bed where the child mostly is, because right now a Google Meet link is sent, and the camera faces a window. So, and there is a chair. I'm assuming it's an office desk from what we saw, my lord. If only the camera or if the laptop could just be turned to the bed, we simply want to at least see the child's face. The father has come all the way. There was this error in the previous order that it was written the father is coming from UK. He's coming from Haryana. For 3 months, he sought permission. He's moved down to Bangalore, and this has put his job at jeopardy, but he's trying his best. He just wants to see the child. And on Diwali vacations are coming, from 20th to 25th, the child, per the vacation schedule given by the learned counsel for the respondent in the lower court, 20th to 25th October, child has Diwali vacations, and school reopens on the 27th. 20th, 21st, and 22nd, if the father and the paternal grandparents can meet the child. 20th, 21st, 22nd. From 20 to 25, holidays are there. 27th is the reopening date. So only for 3 days, at least 3 to 4 hours, my lord, because pujas would be conducted during Diwali. So if the pattern,
He doesn't stay here. Where is he now
my
residing?
lord,
In Bangalore, he has a house.
right now he's living in a hotel, my lord.
That's what you're saying about the pujas and
The
all. Where is
puja
he?
at a family friend's house in Bartur. We have the address. We can submit that also, my lord. At a family friend's house where there is also another child of 3 years old. We figure that would be a much more convenient place for the child. We also don't want to disturb the child. The child is very attached to the mother. We understand that. We are not trying to snatch the child away or exercise the right with the child being damaged here psychologically. We just want to see the child. We just want to be able to interact with the child.
Lord Mayor, 27/11/2023 is when the separation took place. The mother, my lord, from Haryana returned to Bangalore. For the last 2 years almost, my lord, there's been no interaction between the parties, let alone the child and the father. The child was 1 year and 5 months old at that time. Therefore, my lord, the child is of very tender age. He needs to be introduced back to the father. The bond has to develop. Yes, my lord. That requires, my lord, some patience. I understand the father is anxious to meet his son. Some patience, my lord, so that they can re-establish.
What is the difficulty, sir? I mean, what is the reaction of the boy?
Lord, he clings on to the mother.
Lord, as
Because
of
he's
now,
only
the
been with the
child
mother for
does
the
not
last-
even know that the father is the father. Because first thing is to simply introduce that this is your father would be great.
Absolutely.
The child
If
won't
my
call
letter
the
can-
dad
can-
uncle.
Can permit me to not make. Lord, as a mother, my interest is to ensure my son's welfare, which also involves knowing his other parent and also growing up and developing a bond with him. But my lord, to impose, all I'm requesting is, my lord, every alternate weekend, if your lordship could, now the order is from 10 to 6 every Sunday, the father can pick up the child and drop him back. The child is refusing to go, my lord, because he's of very tender age. He's not seen the father for the last 2 years.
No, anyhow.
Yes.
What they say is,
Yes.
he he has taken off from the job.
Yes,
And it's for the, only for this purpose, he has come from Haryana to Bangalore.
Very
He is in Bangalore.
Yes.
Let's go, except his 20th, 21st
22nd.
and 22nd.
Yes, my lord.
And the remaining time, like till he is here, some, like whenever in the play area, wherever the boy plays in the evening, he'll go and play with him.
Lord,
Take him out.
Yes,
so far as Diwali is concerned, already our arrangement has been made by the trial court. In fact, the application was for the arrangement, and that order has been accepted on 22nd, my lord. The father has been permitted to visit the mother's residence and spend time with the child. That they've accepted that order. Now to come before your lordship and claim enhanced visitation rights in my petition, my lord.
They are reducing the 10 to 6 that was
Yes, my lord,
granted
the
with
hours.
My lord,
whether they have filed a petition or not.
Yes.
We will try to balance the.
Yeah, absolutely,
order,
absolutely.
interest of both the parties.
If it's a festival, even I celebrate.
No, it's only like 20th, 21st, 22nd.
Yes, ma'am.
We'll say like, or else if not 4 hours, but some 2 hours. Sometime which is convenient to you. And the remaining time when he is here, instead of taking the child outside your campus, wherever the play area is, the father will come and play with the child while he was playing.
Yes, ma'am.
May I seek instructions and tomorrow may I make submissions?
Tomorrow.
And also if my learned friend can, where he's staying, so that we'll know what distance. Yes.
The address for 21st.
Where you want to take him,
Okay.
that also.
I will communicate
furnish
it
the
right away.
details to him.
Taking him at my place, he could come and spend time.
It's only at least 1 day, if not 2-3 days.
Lord,
We'll
because
grant them 1 day.
paternal grandparents also have not.
That's why 1 day we'll grant them for 4 hours. Ask her.
The child does not go even for 5 minutes. Even last
Lord,
visitation, my lord, the child.
Even if the mother wants to accompany, we're okay with it. It's just because the puja is being held, we would like the child to be there.
Just ask her.
Grandparents
Ask
would like to
instructions
see
with-
the child.
I will very tomorrow.
Get instructions tomorrow. Yes.
List number 2, cell number 1. List number 2, cell number 1. Mahesh Kiran Shetty, S for petitioner.
I appear for the petitioner in
Devi
this matter.
Lokesh.
What is this council submission for non-compliance of?
My lord, that is with regard to service of the copy on the cavator.
Sir,
It's today morning.
it is submitted that the papers are already served on the cavator and office objections for complied with. Yes.
My lord, this is a matter pertaining to the sale notice, auction notice. It is scheduled to be held tomorrow. My lord,
No, well, without going into the other issues.
please.
Why should we entertain this writ petition?
My lord,
What are the exceptional circumstances?
My lord,
If you tell,
exceptional
then we'll go into the merits of the matter.
Please, please. My lord. Exceptional circumstances are that, my lord, that this NPA was declared in the year 2020 itself during the COVID moratorium that was granted by the Honorable Supreme Court. My lord, during the COVID period, my lord, without even restructuring my loan account, my lord, this NPA was declared. And now after lapse of nearly, my lord, 5 years, sale notice is issued, my lord. If my lords could kindly.
Yesterday he gave. Yes.
If my lord could kindly, my lord, the sale notice annexure.
That we will not be going.
Please,
What
please,
has
ma'am.
happened in 2020? After that, if they've issued the sale notice, so many other proceedings have taken place. 13-2, 13-4, and the 14.
From the
What did you do?
declaration, from the date of declaration of NPA.
Yes.
My lord, within 3 years, that should have initiated the proceedings. My lord, on merit, my lord, I'll not go because all surface matters, my lord, I can understand it is only a mercy petition. My lords may kindly put me on terms. Whatever the amount, my lord, need to be deposited before the auction tomorrow. Some amount, my lord, I'll deposit
There is no
tomorrow.
some amount. For
One
some amount, why should we stay?
One submission. My
For
lord,
a substantial amount, we will stay.
I may be relegated to DRT. I have no difficulty. My lord, I will avail the alternative remedy that is available under section 17. To that effect also, I don't have.
What is
Why
the
I have-
outstanding
why-
amount?
11 crores, my lords.
Huh?
11 crores.
11 crores is the outstanding.
My lord,
May I make this submission?
Let him say what is it. Yeah.
my lord, I will deposit immediately tomorrow 1 crore. I will deposit. One submission. Let me complete my submissions. My lord, 10 days time may be granted so that, my lord, I can approach the DRT. Before 10 days also, my lord, I will make some payment.
Why did you not go to the DRT before coming here when they?
My lord, so the sale notice itself, my lord, I was made to know only 3 days prior to this session, the date of sale. For that reason, my lord, I rushed this honorable court. Otherwise, my lord, I would have definitely availed the alternative remedy. For that reason, I made a mention that, my lord, I am not on merit of the case. It is only a mercy petition wherein, my lord, I want to save my property because the reason is this, my lord. close together property, the reserve price is fixed for a very lesser price, and even for 40 lakh sum loan, there are totally 4 loans, my lord. In respect of 40 lakhs loan, my lord, 4 crore property is brought for auction, that is reserve price. In respect of 2 crores, my lord, 20 crores property is brought for auction. For that reason, my lord, I want to save my property. I may put on terms, my lord, I will definitely.
Terms can't be 1 crore. For
My lords
for
may kindly.
For outstanding loan of 11 crores.
My lord, I will deposit within a reasonable time, my lord. I will definitely deposit before I could approach the DRT also, my lord. If I am protected, my interest is protected, I will make a deposit. On undertaking, your lordship may relegate me to DRT.
My lords, not for this, my lords, alternative remedy is very much available. You could have approached DRT. Here he has transacted over the property, and there's also allegation of another bank who has issued notice to me that he has mortgaged this property also to them. None of the property in the mortgage deed. And this encumbrance certificate may kindly take your lordship's consideration. Without my consent, he has executed a registered lease deed in favor of 2 persons.
Well, registered lease is not a.
Lordship may find page 2. My mortgage is in 3, my lords, para 3. MOTD in my name is Tumkur, page 2, my lords. Page 2. Anita versus Anita in favor of the manager Tumkur Grain Merchants Cooperative Bank. Subsequently, on the first in para 2, my lords, lease deed is executed in 2013. Again, my lords, another lease deed was executed in 2000. In the first page, you will find, lordship will find that on 18/5/2018.
Why they can't execute a lease deed?
You should take my permission, my lords. There's terms in my mortgage deed. You should take my, at least you should seek my consent before he can enter. But post, it was a vacant land which was mortgaged to me. Later, he can't. That is one thing.
Submissive proceedings are initiated when?
My lords, demand notice was issued way back in 2022. My learned friend allegations, what he's telling is like, in fact, morning it was served to me, I would have produced before this court. And now, my lords, sale is fixed tomorrow. Now, his submission that he'll pay 1 crore. What happens? The situation is that once the sale notice is published, the lordship is very aware. So Apex Court has held that once sale notice is published, the redemption right goes. Even I can't accept any money from him. Now I received the bid from the auction purchaser. Be that as it may, let it be open for him to approach DRT. Let him file a IA for seeking interim order before DRT. But no, I have serious apprehensions, my lords, because he is transacting over the property, various properties, and since last almost this is the 4th or 5th sale notice which we have published. This is not the sale notice published for post issuance of demand notice, and he has not issued any demand notice. Reply is not issued to me. 13/4 is not challenged. Position notice also not challenged. Ultimately, at the sale notice, at last leg, he is coming before this court and is telling that no notices are issued. Let him be relegated to DRT, but let there not be any, because already I published the sale notice.
Yes.
In fact, already auction purchase is in place.
Yes, Mr. Counsel.
May I make one submission? With regard to the lease which my learned friend has made a submission. My lord, before the declaration of NPA, my lord, that lease deed has been created. For that reason, my lord, that bank will always, it is open for them, my lord, because lease deed, they cannot prevent me because it's all valuable property. I cannot just keep my property stagnant and without any returns.
Fact remains is, you have never questioned any of the proceedings that have taken
My lord,
place
that
so far.
I have taken up that contention, my lord. 13.2 and 13.4 are not yet issued yet till today. My lord, this is a surprise which we are also, because even after, my lord, even after 2020, if my lords could kindly.
If my learned friend would have said,
my lord,
without issuance of 13 to 13/4, my lords, we can't go for sale notice. And
My lord,
I'm
Annexure C,
a
my
bank.
lord,
I'm
issuance
not
of
any
notice.
private lender.
Issuance of notice and service of notice in accordance with the rules that are different. My lord, they might have issued.
According to you, what has not followed?
My lord, 13.2 is not issued, 13.4 is not issued. That is required under Rule 8. That is also
According
not
to them, they have issued.
My
According
lords
to you,
may
you have
kindly.
not received.
Yes, my lord. Now, if
They
your
haven't
lordships could
acknowledged
kindly.
Because right now, it's not handy. If it's maybe
My lords could
2:30, I
kindly-
can produce it if your lordship wants it.
2:30.
And with
My-
acknowledgement.
One submission.
And-
The only thing, nothing. there
If
is
my
nothing
lords
to
could
do.
kindly see Annexure C. My lord, statement
Let
I
him-
have
let him-
produced.
Let him produce it. Afternoon. Yes, next.
Cell number 2, Videsha. Petitioner, BC.
Respondent bank
Avi-
caveator.
What are the office objections?
My lord, complied insofar as 6 objections are concerned. 3 of the objections, my lord, it will be done, my lord. It is only with regard to,
Objection, no, without complying with the objections, why
Lord-
they have listed it?
Lord, yesterday we had moved the memo on the pretext that, my lord, they have scheduled the, my lord, auction.
What the court can do?
My lord,
You are
that-
supposed to comply the office
Please,
objections.
my lord, yesterday itself we tried, my lord, these 3
Nature of
objections.
R1 and R2 to be stated in the cost title, that you don't state.
No, my lord, at the last moment, my lord, they raised this and I wanted to do that needful at that day itself, at that time itself.
No, you will get an interim order. What about the notice to them?
Please, my lord.
orders passed under section 14 is challenged by the tenant here.
It is challenged before this honorable court, my lord.
He's a tenant.
He is a tenant.
Is it, I am a tenant, my lord, and annexure N, my lord, my only contention is that let the bank take whatever the procedure they are following. My lord, there is nothing, my lord, denial of those facts, because
You can't deny also.
please, my lord, number of times, my lord, I have knocked the doors of this honorable court, reporting the fact that I am the lessee who is there in the possession of the property. Right, at no point in time, the bank at least convey that particular thing, whatever they are doing it. They could have at least sent a notice to me, bringing the fact about whatever the process or procedure they are following. To my knowledge, they never do that. Lord, my humble submission before this honorable court, subsequent to passing of this section 14 order, my lord, I take your lordship to page number 116, annexure N. Lord, the commissioner has been appointed by the learned magistrate. Lord, he cannot redelegate the matter to the other person because the commissioner has already been appointed by the court of law. Now section, now this notice has been issued by the very bank calling upon me, you ready to vacate this premises on 1610, which was only, my lord, pasted to the wall of the compound wall day before yesterday.
Please tell the court what is the procedure that has to be followed, what is violated.
My lord, my submission would be, my lord,
So your submission basing on the provisions, basing on the rules.
my lord, section, my lord, I'm not even against to, my lord, the order that has been passed by the learned
Saying
magistrate.
that a particular procedure needs to be followed and not followed, which
My lord,
which provision contemplates?
My submission, because of the fact that I have stepped into the shoes of the borrower, my lord, any
Can you
order,
pay the amount?
my lord, I'm ready to do that. I have knocked the doors. My lord, my humble submission, my lord, I'm ready to even, file a memo to that extent. I have knocked the doors of the bank. N number of times I have approached. I have also, my lord, issued a registered post.
The outstanding amount?
Outstanding.
1 lakh,
issuance
1
of-
crore 37 lakhs.
1 crore 37 lakhs.
Well, I being married, I am not only the lessee. There is also an agreement to that effect where I have entered by paying 51 lakhs to the owner. I have entered into a sale agreement where a suit is pending.
The council, please show to the court what is the what is your legal right and what is the.
My lord, my humble
what
submission.
What is the lapses on the part
My lord,
of
my
the bank?
only submission would be, my lord, the account of the, my lord, on the conduct of the bank. I want to make this particular
Conduct
submission.
of the bank in the light of the provisions.
In the light of the provision, my lord, my lord,
Provision.
section 14 has been passed. I take your lordship to the very order which is at annexure.
Let's look at section 14.
Please, my lord.
And what is to be, what
There-
are the lapses on the part of the
No,
bank?
I'm not on the point of.
There are no lapses, there is no question of
My lord,
interference by this court.
May I make this submission, my lord? I pray your lordship come to the order portion of annexure L at page number 105, my lord.
Yes.
Lord, number 2, the order at number 2,
Yes.
the honorable CMM has informed to judicial officer so and so, 4 lines. Hence, as per the memo of counsel for petitioner bank,
Where
Sri
are you reading?
Venkatesh.
One not?
Lord, it is 105 is the annexure L. Operative portion is at 9. 109. Last 3 lines in the second para, my lord, of the order. Advocate has been appointed as commissioner to execute the warrant and to hand over the possession of the property.
Yes.
My lord, come to annexure N at page number 160. Now, my lord, it should have been at least from the court commissioner who has been appointed by the magistrate. My lord, he redelegates, he takes back that particular order as though it has been passed in his favor and he issues the notice, not by the commissioner, by the bank, that it has been scheduled on 16th. I take lordship to the very order. Last but 3 lines. The court has appointed a court commissioner to take physical possession of the secured asset and the court commissioner will be executing the warrant on 16th October 2025. Now it's a kind of threat which he is making, my lord.
So we'll
The
ask the
bank.
commission to take question then.
My lord, I'm ready to comply, provided, my lord,
They'll do it.
my humble submission is, Lord, I issued a notice calling upon the bank that there is some kind of, Lord, things are happening in and around the premise. I request you, if something is there, please let me know that I am ready to deposit because my matter is pending before the civil court, wherein which I have filed for specific performance of contract on the agreement which has been executed by the very owner itself. It is been not for the.
Property is mortgaged to the bank.
That's the reason, my lord. Now I have stepped into the shoes of the borrower, so I am ready to even deposit that amount. Because my suit, which is pending, my lord, where the owner has already received a sum of around 1 crore 1 lakhs and she is enjoying that money. And now I've been, I've been thrown out from the property.
No, the court can understand, but what to do? That the court cannot help you.
May I make this submission, my lord? I'm ready to even deposit that money, my lord, provided that, my lord, the bank.
No, the court will declare that there is an agreement of sale between you and that person. And what, without going through the full-fledged trial, now the court is, with this order, that suit can be declared.
No, my lord, my only submission is that alternatively, my submission before this honorable court would be, and my submission would be, my lord, at least, not a breathing time should have been granted, because, my lord, my lease was executed in the year 2021, and my children, my husband, aged husband, who is retired, who is suffering from glaucomia, my lord, I need to take care of. All of a sudden, if they comes and my lord, vacates me from the property, I will be driven to the
First
streets.
sale notification or?
My lord, initially, it's not the first time what the petitioner is coming
Sale
to.
notice was
Earlier,
issued.
the auction sale, the petitioner himself has produced. Auction sale notice was published. He approached the
When was it?
auction sale notice was published in the year 2025, my lord, January 2025, Annexure E. Subsequently, he approached the Honorable DRT by filing essay under Section 17, availing alternative.
What is
remedy.
that number?
Essay number 152 of 2025.
152 of
2025. The Honorable DRT refused to grant any interim order. Subsequently, approaches this Honorable Court by way of writ petition.
What is the number?
WP number 7265 of 2025.
7265 of?
2025. This Honorable Court, noticing the fact that the auction has been failed, dismisses the writ petition on 9th April 2025.
9th April 2025.
25.
That order is 5.
Annexure H, my lord.
H, my lord.
Page number is not.
Page number is there.
In our petition.
Page number?
Annexure H is at page number, my lord, 78.
This court refuses to.
The pretext that, my lord, since sale auction was not taken place, it becomes infructuous. And even essay got
But if the
dismissed.
petition, your
produced that
lordships,
also.
in your lordships may kindly come to the petition. Now, para 6, in page 11 of the petition, para 6, my lord.
Where do you get that?
In writ petition, my lord. Page 11,
Petition.
writ petition, page 11, para 6.
Interim order was
How
granted. my
they
lord.
Please. This is how they misrepresent and swear to a false affidavit. My lord, it is further submitted that being aggrieved by the action of the Honorable Debt Recovery Tribunal, the petitioner filed writ petition number
No, I'm looking at paragraph 11.
6, page 11, para 6.
Para 6.
In page 11 of the writ petition,
Yes.
para 6. It is further submitted that being aggrieved by action of the Honorable Debt Recovery Tribunal, the petitioner filed writ petition number so on, and the Honorable Court was pleased to dispose of the matter by granting protection for a period of 4 weeks to the petitioner herein and proceed to auction the property. Kindly come to the order passed by this
Yes,
honor.
no, I've seen that.
No
It
protection
was the
was,
interim protection.
a false
my lord.
affidavit has
It
been
was-
filed.
But this, you have questioned the order of the Debt Recovery Tribunal by filing a writ petition.
Please, my lord, before this honorable court, interim protection was granted only to the extent that we are going to provide you 1 month time where you can do the vacating the premise and all these things. That was interim protection which was granted.
That order was dated 9/4/2025, and in the month of October, you're still talking about reasonable time.
No, my lord, I'm not even talking on that point. I'm ready to, my lord, go before the bank and ready to deposit that money. Bank is not.
Deposit, Mr. Counsel.
lord-
Repeatedly, you make the same submission.
The other part would be, my lord, now the bank itself has become a party to the civil proceedings, sir. But I can make an application before the civil court itself to
Let
my
them
lord,
take whatever
deposit the money.
Let them take whatever available remedies available in law, but this writ petition will not survive. my lord.
Yes.
And
My
he
lord,
has
my
not come
submission
before
is,
this
my lord,
honorable court with
protecting
clean
the,
hands.
my lord, possession only on 2 pretexts, my lord. One is, my lord, the bank is not allowing me to at least, my lord, to know about the facts of the case. My lord, now bank has entered, my lord, in my suit, my lord, where I can make application. Now, all of a sudden, if I am, been, ordered to be.
All of a sudden, this is going on from January, and you have come before this court, your writ petition is dismissed. And why this another writ
Lord.
petition? Because another, the first section, questioning that section 14.
My lord, may I make this submission, my lord? My attempt, my lord, in number of times I have gone before the bank where I have narrated in my registered post, which was sent because they were not even ready to receive the, my lord, to acknowledge that particular representation, which I wanted to make it.
Between you and the bank.
But because of the fact that, my lord,
Borrower,
I'm not the borrower, because of
you have
the
any grievance that is between you and your
owner, landowner of the
that you are
property.
that you are anyhow dealing with that before the civil court.
Please, my lord. My lord, there is already an order of, my lord, interim order which was granted by the civil court, my lord, with regard to alienation of that property, where it was only against the landowner of that property. Now, my submission is that
You cannot alienate papers or with them.
not for me,
What
my lord.
again? That's what I think.
Charge
The
has
order
been-
is as if it is not there.
My lord, my submission would be, my lord, because my only request is that since
We can't. Please come.
the other submission would be at least, my lord, let there be a time bound, my lord. If not, this particular thing will,
Not enough time is given to you.
lord, if action is initiated, my lord,
The writ petition is filed. The petition is filed, seeking the following relief. The petitioner is a lessee in premises of a property which is mortgaged by the, which respondent?
Respondent number 3.
By the respondent number 3.
Sorry, respondent number 1. My apologies.
Huh?
Respondent number 1 is financial.
You are respondent number 1.
Two, my
Who
lord.
is the owner of the property?
Owner 3, my lord. Nagama Muniswamy.
By respondent number, which is mortgaged by the respondent number 3. It is the case of the petitioner that the petitioner entered into an agreement of sale with respondent number 3 on 1/7/2021, having received an amount of rupees 50 lakhs. Respondent number 3 permitted the petitioner to occupy the premises. Thereafter, the respondent number 3 agreed to sell the property for rupees 1,87,50,000 and allowed continued possession pending the execution of the sale deed. Thereafter, the petitioner has filed OS number 4289 of 2022, seeking specific performance of the agreement dated 16/3/2022, and for a declaration that the transaction dated 18/6/2022 is invalid, and the said suit is pending before the CCH-18, before the City Civil Court, Bangalore. And an interim application is also filed seeking injunction, and the court has passed an order restraining the third respondent from alienating the property. It is submitted that the first respondent herein, that is the bank, is also a party to the suit.
Subsequently impleaded, my lord. Initially.
Subsequently pleaded as a party to the suit when he came to know about the property being mortgaged to the bank. The account of the third respondent is declared as a NPA, and the proceedings under the Surface Act were initiated. Now the petitioner is before this court questioning where is that order?
Is an annexure L, my lord.
Sir, L page number.
Questioning the order dated 25th September 2025, passed in criminal miscellaneous number 4714 of 2024. 25th September 2025, stating that the petitioner has spent given substantial amount to the third respondent, and he is also ready to pay the amount that is outstanding. And in this regard, he has tried to contact and negotiate with the bank, but the bank has never come forward. It is submitted that at this point of time, if the petitioner is forcefully evicted from the possession, it would cause a lot of hardship to the petitioner, as the entire family is depending. He has to take care of the family, and the family is depending on the what you're running a commercial. What is there in the premises?
Well, it's a residential property.
Residential unit.
That they are residing in the premises, and it would cause a lot of hardship to the petitioner and his family. Then counsel submits that if the bank is ready, he is ready to pay the outstanding amount. Further, learned counsel submits that as per the order impugned dated 25th September 2025, the court had assigned the advocate instead of says to that to enforce and execute the order. It is submitted that the learned counsel draws the attention of the court to the notice dated
Undated, my lord, it is
to
not.
the notice issued by the first respondent, where he was directed to vacate the premises to facilitate a smooth transaction. Learned counsel submitted that when the court has appointed the advocate to take possession of the property, the first respondent has no business. It is submitted that the bank, without informing the petitioner, cannot proceed, and at least the breathing time should be given to the petitioner to vacate the premises. Learned counsel appearing for the first respondent submits that the account has been declared as NPA in the year 2023.
Yes, ma'am.
2023, and the auction notification is issued on January 2025. Then the petitioner has approached the DRT by filing essay number 152 of 2025, and the DRT has refused to grant any relief to the petitioner. Then he has come before this court by filing WP number 7265 of 25, and the same is dismissed as infractions on 9/4/2025, as a sale was not conducted as per the auction notice. Learned counsel submits that they cannot accept the money from the petitioner. He is not the borrower, and he has already initiated the proceedings against the. He has already filed a suit, and it is for the third respondent and the first respondent to get their disputes resolved before the civil court. And as far as the bank, which is the secured creditor, is concerned, I've already initiated the subversive proceedings, and the petitioner could not point out what is the procedural irregularity which is warranting interference of this court under Article 226 of the Constitution. Next. Having heard the counsels on either side, but it was a material on record. The petitioner is a lessee. In the entire contentions that are recorded by this court in the preceding paragraphs, the petitioner has not raised any single legal tenable ground seeking interference of this court. Seeking interference of this court. The contention of the petitioner that he is ready to pay the amount. This court do not find any force in the said argument. When the civil suit is pending seeking specific, which is filed by him, seeking specific performance, it is for the civil court to decide whether he is entitled for the specific performance, whether there is a valid agreement between the parties. And at this stage, this court cannot permit the petitioner to pay the amount, and it virtually amounts to prejudging the civil suit. And that submission of the petitioner holds no water. Then the second submission about the reasonable time to be granted. The petitioner is fighting this litigation from January, from January, where he has gone to the DRT by filing essay number 152 of 2025. Thereafter, he came before this court, and that is also dismissed on 9/4/2025. Now, in the month of October. Again, the petitioner cannot say that he requires a reasonable time. In these circumstances, this court do not find any reasons to, to, to interfere with the order impugned, and accordingly, the petition is dismissed.
One submission would be, my lord. Lord, in any case, my lord, if the auction is conducted, my lord, after vacating me, at least, Lord, because now the amount which they have, my lord, the value which they have fixed is 2 crores 53 lakhs for this property. They are entitled for 1 crore 40 lakhs or whatever additional amount. Whatever the remaining amount comes, at least let there be, my lord, a deposit before
Let the borrower ask, not you.
My lord, at least because my protection needs to, at least I can recover that money.
There is no question of protecting you in surface of proceedings.
Cell number 3, B.B. Ravishankar for petitioner, K.V. Lokesh, Kivita.
Which time, your lords?
Interim order is not complied.
Please,
And petition
I'm
also
sorry
become
that-
infructuous.
Order, let us see.
Sorry, your lords.
Page 23,
Please, an interim order was granted by this honorable court. And on 23/5/2003,
Petitioner in the meanwhile is directed.
I
to
have paid
deposit
this amount, 30% of the amount.
That is 3 crores 13 lakhs 69,000 within 4 weeks from today.
I will,
Today is
I will produce the statement of account
May I make
showing that I have paid that this 30%
Lords,
of the
the
amount.
prayer, kindly come to prayer, my lords. That has become, this sale did not take place. 14/5, prayer 1 is to withhold the surface proceedings, page number 18. Prayer 1 and prayer 2 is, my lords, first number 1 is for withholding surface proceedings, number 2 is challenging section 14 order passed by honorable magistrate.
That is where I am.
Number three consequently issued writ of certiorari, caused a sale notice dated 14/5/2024. This sale has not taken place.
Now, your lords, may I say?
Let him go
Now,
before
what
DRT.
is the chief metropolitan magistrate order? Why I am coming before this court is now. At first breath, he says, I did not. Let me place a record. On record that I have complied the order.
21 order,
Please,
challenging
your lords.
24 minutes. 21 order passed in 22, 21. Challenging in 24 before in the present writ petition. Combining both sale notice and section 14 order. This prayer is combining both the common petition is filed. Let him go before DRT, let alternative remedies are very much available for him. 1
This
week's
man,
time.
why I am saying before this court? 1 month's time, the entire liability would be going. You lords may have it next week. You lords, I will say what is the amount due, total due. They themselves give an undertaking before this court. They're saying that now they claim 19, they claim about 10 crores. If you are their own letter there says that I'm due only 3 crores and not. That's why I record you lords may kindly give me a week's time. I'll submit the documents there before this court now.
But what he says is correct. Why this petition shall be entertained by this court?
No,
Why
I'm not.
can't you go before the DRT?
DRT, you lords, again, I have to go, instead of it, I'm going to clear the liability within a month. Nothing more than that, I'm saying. Let me first,
No, again, on the liability, there is a dispute. According to them, it is so and so. You say that it is.
your
not
lords may
amount.
kindly, please, your lords may kindly go at page 62. At one breath, they claim about 10 crores in the sale notice. Now, your lords may kindly go to the, at annexure 62. This is certified so and so that there is a liability of 5 crores 31 lakhs 24,767 as on 10/1/2023. I had borrowed a sum of rupees 10 crores, the initial proceedings. Immediately I said they recall the entire notices also. They gave me a fresh.
Finally, we'll grant you a time. We'll have this matter on 28th.
Please, your lords.
No
Please,
further
your lords.
adjournments. On that day, we will decide. the
Please,
matter.
your lords.
Kindly, it may be recorded, my lords.
At the request of learned counsel for the petitioner, list this matter on
The
20.
submissions may be recorded, my lords, that he told within 30 days he'll close the loan account.
26.
That did not, you, why you can't say that.
Requesting
You are
this
saying,
code,
I
same
am
thing was
placed the
told,
record.
same thing was told in 2024, my lords.
Whatever he does, I'll close the matter on, I'll hear the matter and dispose it off on 26.
Lords may have it, the
Then
interim
counsel
order
for the
be
petition.
extended till then, your lords.
Each time, list this matter on 26. No further adjournments will be granted. Interim order.
No, interim order is not.
28. No, 28th is not. 27.
25.
Matter on 27. No further. 29th. 29th. No further adjournments will be granted.
Please, your lords.
Yes.
Cell number 4,
Appearing for the respondent number 2, your lordship.
Anusha L for petitioner, Lata Shetty,
Appearing for respondent number 2, your lordship. I've sought adjournment in this matter. Lordship, I've sought adjournment in this matter. And I've also informed the petitioner, counsel, your lordship.
What is this non-compliance of office objections in a writ petition of 2024?
That we will comply it, my lord.
You should have been compliant 2024.
Query for respondent number 2, your
Outside to be.
That has been done, my lords. R3 has been deleted.
Interim order is there.
Interim order got vacated, my lord. There is an order on 10/9/2025. So far as the second petitioner is a tenant, he deposited 9 lakhs rupees by virtue of the interim order passed by the court. Bank has been directed to take further steps after the sale is concerned. My right is confined only so far as the deposit made to the bank. 13 lakhs rupees I made, my lord. That's the position.
This is matter on November 18th. By the time the office objection shall be complied with.
Please.
Till number 5. Vimanna Y.
Where is that? Office.
Two objections, my lords. At serial number 2, correct annexure and date to be stated. Lords, that is the date on which NPA was declared, 1/2/2024. No official communication has been given to me. It has been taken from their own petition filed before the learned magistrate.
Declaration of copy of NPA dated 1/2/2024 as per prayer 1 to be furnished.
That is the official communication which would not be given to us.
But that you have questioned it.
Lords, that has been stated by them itself in their petition under affidavit, my lords. At page number 26, my lords, your lordship may kindly see.
Origin of certified copy of annexure E
Lords,
to be furnished.
that is, my lords, something which has been annexed to the wall of the house, my lords. That
So now everything has some reason.
no, my lords.
So you will have A, B, C, D reliefs and no papers will be filed. Everything is stated by them and we have to accept it.
No, my lords, I have filed it, my lords. The certified copy of annexure E, my lords. All other things, my lords, I have done.
Council submission with regard to the office objections is accepted. Yes. What is the matter about?
My lords, we have taken a loan of 3 lakhs, my lords. I'm challenging the way how they have declared the NPA, my lords. Your lordship may kindly see at page number 12, my lords. That is the account statement that I have produced, my lords. That is first installment, my lords, above in the second table, 3/7/2022.
Oh, already section order section 14 is passed.
Yes, my lords. But the initiation of proceedings itself is void for the reason, my lords. Your lordship may kindly see page.
Was it declared 1/2/2024? What are you doing from there?
Lords, he is an illiterate, my lords. He has ailment of kidney failure and all.
Please,
Lords,
which bank is this?
For a moment, my lords, page 14.
Bank is this?
Lords,
This is Pegasus.
You appear?
I have not filed the wakalat. I just came to know that is.
I will.
Land counsel for the petitioner.
Lords,
So,
till such time, one submission, my lords.
without instructions in these matters, no interim orders. The land counsel, so and so submits, so and so shall take, is directed to take notice. The land counsel, the petitioner shall serve the copy of the writ petition on the council. This is matter on 23rd.
Great.
Yes.
Till number 6. Lata Shetty. Hearing on interlocutory application.
Petitioner, my lord. There should be an order of compliance of the order dated 24/9/2025 by the respondent, my lord, which is not yet complete.
What complaints with the respondent?
My lord, this honorable
Two
court
of
has,
23 is filed for early hearing. 1 of 23 is for the vacating of the interim order.
no, my lord, on the previous occasion, my lord, this honorable court has passed an order dated 24/9/2025, my lord,
You appear for the petition or respondent?
for the petitioner, my lord.
It's all or whatever we find it here, it is with regard to the petitioner. Non-filing of,
That is the IA filed by the respondent, early hearing
non-filing
and
of the
vacating.
memo depositing amount before this court by the counsel for the petitioner.
Serial number 6, my lord.
Yes, 6.1. That's what I'm looking at.
Please,
Look
my
at the
lord.
cost item.
Please, my lord. There is an order dated 24/9/2025
Anyhow, what do you
of
say
this
about
honorable
these,
court.
this office note?
Oh, in the first matter, my lord, it's for idly hearing.
Anyhow, these are all old matters, 21, we'll take it up on November 11th. IA number 1 of 23, 2 of 23 for early hearing is allowed. This is a matter on 11th November.
One submission, my lord. Kindly see the order dated
We'll see,
24/9/2025.
no urgency for this.
There is an direction to the respondent to provide us the OTS, my lord, which has not yet been done. Our contention is we have paid excess amount, my lord. They have recovered more than the
We'll see when we hear the matter.
much.
Number 7,
Yes.
Rajshekar. For petitioner, Nitin Chandra.
Respondent bank. It's the second respondent purchaser, auction purchase.
Where is the petitioner?
Well, the senior is appearing in the matter. He's in his legs in code of 25 is just reaching in a minute.
Asova? Yes, next.
Cell number 8. Cell number 8.
For the petition, my lord.
Hmm.
For respondent, my lord.
What is this annexure G and F?
My lord, annexure G. Annexure G is the 13-2 notice, e-auction sale notice, and annexure F is the 13-4 notice. My lord, this case
You
is.
find the copies of it.
Yes, my lord. I filed the copies. I have submitted an IA for dispensation of certified copies.
That's what I'm saying. You
Yes.
filed the copies of it.
I have requested to the respondent bank who owns the copy, who created the copy, to give me a certified copy. It is not yet issued to me. Application is submitted to the branch.
You have filed a copy of it, sought dispensation of certified.
That's
copy.
right, my lord.
Yes,
That's right.
I number 1 of 25 is ordered, which is filed for dispensation of the production of CC of the annexure G and F. Yes, for the present. Where is interim, where is impugned order?
My lord, impugned order is annexure H, which is the DRT order.
Where is
So,
that?
Annexure H is in page number 47, my lord. It was, we have filed a securitization application for the DRT, indicating the fact that SARFAESI proceedings were initiated against me under section 32 demand notice. My lord, for my lord CC understanding, my lord may peruse the synopsis page number 2, where I have given the chronology.
Why you shouldn't go to the DRAT?
Before that, my lord, it is essential that my lord understand the chronology of events,
Let's
because
understand. There should be, without going to the DRAT, you have come to this court. What is
Yes,
the reason for
because-
bypassing the remedy and coming here? First you argue on that.
yes, my lord. So as per the Supreme Court norms, nature of appeals must go to DRT, but DRAT. So this is not a nature of appeal. This is rather a question of law. My lord may peruse page number 55, which is the cardinal part of the order of DRT. Page number 55 in para 14. Para 14, it is mentioned that it is, my lord, I may read it for my lord. It is also contended by the applicant that the defendants issued annexure A1 possession notice dated so and so under section 13 of the act. Instead of issuing a fresh demand notice, as the same was issued at a much belated stage, that is after the lapse of more than a year from the date of issuance of demand notice. My lord, I'm skipping 2, 3, 4 sentence. The cardinal part is coming up from that point, 1, 2. From the 5th sentence, I am saying, which says that though the applicant contended that the authorized officer of the first defendant bank ought to have issued a fresh demand notice in furtherance of annexure B2 demand notice dated so and so, in view of annexure A2 sanction letter, it could not produce any provision of law or any judicial precedent prevalent in the country in support of such a claim. The scheme of the act and rules made thereunder do not provide for that. So here the DRT itself is appreciating the fact that the question we have raised before the DRT doesn't belong to the statute. It cannot be read straightway. It needs to be interpreted. So DRT is not capable of giving an order. So in such a case, my only option is to knock the doors of this honorable court, which I have done. And to understand why it is not there in regular statute, my lord might give me permission to take my lord through.
That submission of yours, I'm not able to understand. DRT is not in a position to give an order to you. What is that?
That's what DRT have given.
DRT has not said so.
No, DRT have
DRT
meant-
says,
Yes.
whatever you're pleading,
Yes.
is that such a procedure is not contemplated. That's what the
In
DRT
the
said.
law, or in other words, DRT is not ready to interpret the statute. DRT is created by the
That will not
statute.
give a rise to a writ petition before this court.
My lord, see, it's not an appeal, my lord. So when a statute, when the creature of statute itself says that I cannot see it in the statute, then it have to be interpreted, because it is saying that I am helpless to interpret the law, because I have been given clear instruction 1, 2, 3, 4. I need to follow this path. Now if there is a sequential error in 1, 2, 3, 4,
Yes.
we have to interpret, and that's the very reason I am before my lord in this matter. So that chronology will help my lord to understand this matter better. If my lord permit me to take my lord through page number 2.
Yes.
To page number 2 of the.
Please come to the judgments of the apex court. Where did they say that if the DRT is not able to understand the law, High Court will interpret it?
No, my lord. Judgment of the Supreme Court says that whatever can be closed in DRT, which is kind of appeal nature, should go to DRT. When there is a substantial question of law, then
Where is the substantial question of law in this?
I am coming to that, my lord. If my lord
Please come to
permits.
that. Yes, come to that.
My lord, page number 2 gives the chronology of events. In the page number 2 list of dates and events,
Yes.
on 28th of October 2020, I have taken a loan, which is around 3.55 crores.
Yes.
Then October 2021, loan is becoming irregular. January 2022, it is declared NPA.
Yes.
Now, on 4/2/2022, the demand notice, 13/2 notice is issued. Surface proceedings are initiated against me.
Yes.
On February 4th of 2022,
When the notice is issued to you on 13/2, what did you do?
I have represented my case.
What has happened?
They have given me an OTS against my representation.
Then
which
where is that in the?
My lord, chronology. In March 2022, OTS scheme is issued. That means February.
In the chronology, what it should come is 13/2 notice is issued. So when did you give the reply? For that, what are your objections?
OTS
And what is the
declaration is
reply?
there, my lord. I thought I will take my lord through the synopsis, then go take it through the documents. OTS is there, my lord. That goes attached.
What are the grounds that you have raised in that notice to 13/2?
OTS notification, my lord. OTS notification is in page number. In Annexure D, my lord.
Page number?
Annexure D is in page 27, OTS sanction of your term loan and working capital accounts. This is in reference to our sanctioning letter dated 24/3/2022. That they have given me an option to settle it. Page number 27 and 28.
Yes.
So, and against OTS on 31st March 2022, I am paying 3 crore 5 lakhs out of OTS scheme was for 3.5 lakhs, 3.5 crores. OTS scheme was sanctioned for 3 crore 50 lakhs. And 31st March of 2022, I am paying 3 crore 5 lakhs, which means essentially my balance will be 45 lakhs.
Yes.
And my lord may kindly note the date. It is 31 March 2022. My 13/2 notice was issued in February 4, 2022. So it is within the 60 days. I am completing it. There is an OTS scheme in between, but within 60 days, I am paying a substantial amount back to the bank.
Yes.
Now, on 24 June 2022, OTS schemes end. I am unable to pay the remaining 45 lakhs. And on April of 2023, 13/4 notice is issued in continuation of that 13/2 notice.
Yes.
So my question lies essentially there, my lord, whether a continuation 13/4 notice can be issued by the respondent, or respondent should issue a fresh 13-2 notice.
What happened to that amount?
My lord,
What happened to that amount that is paid 3 crore 5 lakhs?
my lord, it was appropriated to the loan account, and subsequently, my lord, on the default created by the petitioner by not compliance with the agreed OTS, the entire amount which was mentioned in the demand notice and position notice remained as it is, my lord. But subsequently, my lord, after no, that, my lord, that was deducted, and the subsequent claimable amount was with interest was claimed, my lord.
What was that amount?
My lord, that amount, my lord, is not mentioned here, my lord, because, my lord,
Mentioned in Annex F, my lord.
subsequently, on the default of the OTS, my lord.
No, you
See,
will not continue the proceedings from there on.
my lord.
You will not continue the
Yes, my lord,
proceedings from there
but
on.
the
You have to
documents-
issue the fresh proceedings again.
My lord, here it is clearly mentioned, my lord, the non-compliance of the OTS will not affect the surface proceedings, my lord. So
But
on the sale of,
money and everything will vary now.
my lord, my lord,
Now, as on the day, outstanding was how much?
3 crore 64 lakhs and odd, madam.
3 crore 64 lakhs. He has already paid 3 crore 5 lakhs.
My lord, subject to that payment, one property was released, my lord. He has got the benefit of that OTS, the partial benefit. On the default of the remaining complaints of the,
What is remaining is 54 lakhs.
that is with respect to 2023 dues, my lord, and subsequently with interest, I'm not aware about the outstanding. I'll get the details of the outstanding amount, my lord. But whereas in this writ petition, my lord, the contentions which the petitioner is taking, the same contentions, same grounds have already been urged before the DRT, and considering.
According to them, DRT is not able to understand it.
No, my lord, my friend was very clever by reading the part of the judgment. Subsequent recording.
I know. What about this? It's only what is outstanding is only 54 lakhs.
That I will get the details, my
Are you
lord.
ready to pay?
Yes, my lord.
When will you
I'm
pay?
ready to pay. Anytime I can pay, my lord. Once they rectify, I didn't pay it because
We'll have this matter on 23rd.
Oblige, my lord.
We'll have it on 23rd.
I'll bring-
Please come up with instruction. What is the amount?
Oblige, my lord.
my lord's kind leave is needed. 19 to 28, I will be in Delhi, my lord. I will come back after
Whenever you want to be. When do you want?
after 28, any date is okay, my lord.
Let's this matter on 30th.
Great, sir.
By
My
the
lord,
time, then counsel with the respondent shall get specific instructions with regard to what is the outstanding amount as on today after paying an amount of rupees 3 crore 5 lakhs.
my lord, one more
Oblige, my
kind
lord.
submission. It was submitted by the respondent that they will not take any action. It's an undertaking done now. Let the undertaking be continued till next date.
When they have given undertaking.
No such undertaking has
No,
been given,
first
my lord.
date, it is there in the order, my lord. My lord may peruse the order.
My lord,
It is mentioned that respondent have undertaken. Let the
court-
undertaken continue.
No, my lord, the court had said not to take any coercive step by issuing subsequent sale notices till
That's what he's also saying.
But no, my lord, there is a letter given
There in the order, my
with
lord may
respect
kindly
to
peruse.
his right of redemption, which is not a coercive step. Only an information is given to him. Oblige, my lord.
Already on 14/7/2025. The court has recorded that when counsel the respondent undertakes that till he gets completes instructions, no precipitative action would be taken in the light of the same till the next date of hearing. No precipitative steps shall be taken.
Great.
Oblige, my lord.
Yes, next. 10 or 9.
My lordship, in this case, appearing for respondent bank, my lordship. Lordship, in this case, the petitioner was challenged the CGM order, my section 14 order, my lordship.
Where is the petitioner? Interim order is there.
My lordship, just one submission, my lordship. Since order dated 2/7/2025, my lordship, there is no representation on behalf of petitioner. It is made clear that if the petitioner remains absent on the next date of hearing, the court would be considered to pass appropriate orders in light of the contention to respondent that the substantial remedy is available before the DRT as per the order dated on 2/7 and 8/7, the petition was not represented before the court, my lordship. And 14/7 also, the petition was not represented. And today also, the petition was not represented before the honorable court, my lordship.
We will not extend the interim order Yes, no representation on behalf of the petitioner. List this matter for dismissal on 28th of October.
Grateful, my lordship.
Yes.
Lords, I'm submitting two documents. My lords, there was a sale notice issued on 2nd September 2025.
Why is it adjourned? Yesterday I've asked you something that I'm going to dismiss this petition. You have to tell your client.
He's neither a borrower nor a guarantor. He claims to have
Yes.
some right.
So only for your sake, this is.
Lords, I may be allowed to make one submission. My lords, the sale notice was issued on 2nd September 2025, and there was a paper publication on 3/9, and then subsequently again on 10/9/2020.
What you have to understand is you have no locus in these proceedings. So when you have no locus, question of going into merits of the matter will not arise. So that you will inform to your client, that's the only reason why I have adjourned it, not for anything. Yes, come.
Lords, some leeway may be granted. I'll act on behalf of the borrower and I will try to settle it, my lords. Some may not be precipitated, my lords, the auction.
What is the outstanding amount?
4 crores, 43 lakhs, 38.
When is the auction?
Today.
My lords, the paper publication, we have no information if it's
Where is the
published.
borrower? The present petition is filed, seeking the following relief. The petitioner before this court is an agreement holder with the borrower. It is the case that the petitioner has invested about 3 crore 50 lakhs to a civil works and labor and other works and further towards the purchase of Writ. The petitioner has entered into an agreement of sale dated 23/9/2019 with the third respondent to purchase the scheduled premises for a sum of rupees 4 crores. On the date of entering into an agreement, the third respondent has acknowledged the receipt of rupees 2 crores, which was the investment for the third respondent business, and agreed to execute the sale deed within 12 months. As the third respondent has failed to execute the sale deed, the petitioner has filed OS number 199 of 2020 on the file of the initial senior civil judge at Bagepalli. And an interim order, the court has granted an order of status quo in respect of the scheduled property. Later, as the petitioner has failed to pursue the case, the suit came to be dismissed on 1/4/2022 for non-prosecution. And thereafter, he has filed miscellaneous 34 of 2022 on the file of the principal and district judge at Chikbalapur to set aside the order dated 1/4/2022 and to restore the original suit. And also, the court, it is submitted that the court had also passed an order dated 34/2022 restraining the third respondent from alienating the scheduled property, and the same is extended from time to time. It is submitted that later they came to know about the mortgage made to you are the first respondent. Mortgage made in favor of the Canara Bank.
It is 8/10/2013. Date of mortgage is 8/10/2013.
As a petitioner has a right and interest over the property, and as the principal borrower has kept quiet, and the court and the bank has issued the auction notification, sale notification, if the property is sold, it would cause lot of prejudice and hardship to the petitioner, which compelled him come before this court. It is submitted that if a reasonable time is granted, they would negotiate with the principal borrower and make arrangements. See that the amounts are paid to the bank. Next, when counsel appearing for the first respondent submits that the petitioner has no locus to file this writ petition. Even the rights of the petitioner is not crystallized and the suit is pending before the civil court. Further, the mortgage in favor of the bank is on
8/10/2013.
8/10/2013, and according to the petitioner, the agreement of sale is on 23/9/2019. Being a secured creditor, and otherwise also his agreement, his mortgage is first. It is submitted that the outstanding amount is
4,43,38,000.
4,43,38,000, and the auction is scheduled for today. Today it is submitted that there are no grounds to interfere. Next, having heard the counsel on either side, peruse material on record. The petitioner is an agreement holder from the third respondent, and he has filed a suit, and the same is pending. At the first, on the first round, the petitioner has no locus to maintain this petition when his rights itself are not crystallized and pending consideration before the competent court. The counsel for the petition has also submitted about the procedural stated about how the 13(2) notice is issued and other procedural aspect. Even those submissions cannot be considered by the court, as in these securitization proceedings initiated by the bank, the petitioner, who is alleged to be an agreement holder, has no locus. In those circumstances, this court is not inclined to entertain this petition and accordingly dismissed.
Lord, in this case, I'm not a guarantor, I'm not a borrower, my lord. I'm the leaseholder, registered lease agreement, my lord, and is on a registered lease agreement, and I have made payment 10 lakhs of rupees through online payment. My lord. Time is, my lord, till 2027. Till such time my possession is protected, my lord. I'll make some arrangement with the borrower. Borrower is in Hassan, my lord. He is not coming forward to the bank or settle the matter.
2027, your position should be protected.
Only possession, my lord, because I'm staying in the premises from past 2010, my lord. I'm the senior citizen. I don't have any other.
But we can understand the problem, but there can't be any remedy.
If I recovered my 10 lakhs, my lord, at least I can do alternative arrangement, my lord. For that one also, the borrower
What is the outstanding amount?
Outstanding amount is 1,73 lakhs in the possession sale notice, my lord.
Will you pay that?
My lord, and
You can't pay. We can't interfere with this.
Only
Who appeals to the Punjab National Bank? Any counsel?
Punjab National Bank. That is
Francis,
Vignesh.
Francis,
I
Vignesh
appear
and Francis.
National Bank.
Punjab National Bank. Vignesh Shetty. Vignesh
You
Shetty.
appear?
No, I am for the PNB Housing Finance. It is PNB Bank. Vignesh is
Vignesh Shetty.
I appear for Punjab National Bank. Your Lord.
Lata Shetty.
The name?
Lata Shetty.
Lata Shetty.
Lata R.
Land counsel, the writ petition is filed, seeking the following relief. For seeking the following relief. The land counsel for the petitioner submits that petitioner is living in the premises from 2010.
Yes, my lord.
2010, and the lease is till 2027.
My lord, 2026, December 2026.
December 2026. The borrower is residing in Hassan.
Borrower is residing in Hassan.
Residing in
R3.
Hassan. And
Hassan.
the borrower is not showing any kind of interest. And it's now when is the sale?
Sale yesterday it was there, my lord, on 8th of.
It's already sale is over.
I don't know, my lord. We don't have any instruction.
Submitted that the bank has initiated the securitization proceedings on the securitization act, and they're going to put the property to sale. It is submitted that if an order is passed directing the bank not to interfere with the possession of the petitioner, she would make arrangements and negotiate with the borrower and see that the amount that is due to the bank is paid. The bank is paid. Land council submits that she has been residing in the said premises for a long time. It would lot of having heard the land council, the petitioner, there is a material amount of the relief that is sought by the petitioner cannot be granted by this court. Petitioner has no locus to come before this court when neither she is a borrower nor a guarantor. The substantial amount of 1 crore and odd is outstanding, and outstanding, and there are no legal tenable grounds which seeks interference of this court in the proceedings that are initiated under the Securitization Act. Hence, this court do not find any reasons to interfere. Accordingly, dismissed.
Sale number 12. Sale number 12.
Hearing for the the respondent, your lordship.
Yes.
What's
Order in view.
Notes we approached the DRT. DRT passed an order not to take any further action in relation to the property in question. Then I should not use the word false statement. An inaccurate statement was made before the DRT, which was handling Section 17 application, saying that the properties in question is subject matter of an attachment in a OA proceedings pertaining to some other loan transaction. Recording that, the DRT now has virtually vacated the interim order. That is the reason why I am before your lordships. But there is a very interesting question of law which arises for your lordships' consideration. Notes the petitioner's father borrows the money by mortgaging one property. Notes I will call this as loan A. Now, he also stands as a guarantor, only as a personal guarantee in respect of loan B pertaining to some other borrower. Now, insofar as this loan A is concerned, it was about 75 lakhs. Notes time and again the money was paid. 2 times we had approached this honorable court. This honorable court had passed conditional orders. We complied with the conditions, after which we were relegated to the DRT. As on the date when the sale notice was issued, it was about 40 lakhs. After that, 6 lakhs is paid. Another 34 lakhs is due, so far as loan A is concerned. Now, the 34 lakhs, if it is taken into account that the amounts which has been paid, I will not be overdue. I may be due of this loan amount, but I will not be overdue considering whatever installments I was required to pay. Now, what this bank does, this is in relation to Canara Bank. The other loan is pertaining to Syndicate Bank. Loan B is pertaining to Syndicate Bank. Both these banks merge. Syndicate Bank and Canara Bank merge. Now, what they do is, the sale notice is sought to be issued, or proceedings is sought to be initiated by clubbing both the loans, loan A and loan B. And they want to proceed against the property which is not the subject matter of the security agreement under loan B. It is not that the first time the matter is coming up. This matter had come up in such circumstances earlier before various courts which has dealt with the issue. Consistent view taken is that banker's right of lien under section 171 of the Contract Act is always subject to contract to contrary. Every security agreement is always deemed to be a contract to the contrary. That means the security agreement is always deemed to be a security interest for the loan which is subject matter of the security agreement.
Now they're going to realize the amount with respect to loan B.
Loan B,
From the property which is mortgaged.
which is
on
mortgaged there, I have no problems.
A.
Not on loan A. No, it's the property which is now mortgaged, which is subject matter of the challenge in the instant petition, is subject matter of only loan A. Loan B, there are properties with there are other properties which are already mortgaged. We have no difficulty. But what they do is they club these two loans on the premise that number one, I have borrowed the money in respect of loan A, and I have stood as a personal guarantor in respect of loan B.
That's a complete different security.
Completely different secured asset. This is what is done. Now, if I pay this 34 lakhs, they are required to release this property. I'm ready to pay this money. Notice when we went before the bank saying that no, we are ready to pay this money after paying the 66 lakhs and odd, that is when they say that no, we are clubbing both the loans. If you want to undertake, discharge both the loans.
How can it be?
That's the only point.
What do you say?
Your Lordship, it is wrongly mentioned, Your Lordship. It is not correct. It is the own sisters. The father has taken a loan on both the properties and the children are inheriting it. And hence the loans, and if all the matters are pending in before the DRT, Your Lordship, it has to be heard in by the DRT because they know the facts. Because DRT in OS number 1389 of 2022 had clubbed this matter. Hello?
Yes.
Had clubbed the matter, Your Lordship. So all, as on today, the borrower owes more than 11 crores. So the learned advocate saying that this is not his loan is completely wrong, Your Lordship. It has to be heard in the DRT because the DRT knows all the where both the more than 3 cases are pending there, Your Lordship. The sale is there is tomorrow, and there are bidders also.
See the impugned order.
There's one
Hello?
list of citations here. Can I just?
No, let's see the impugned order.
Lordship, please. Page number 195.
Why it can't go to DRAT?
177, my lords, is the order.
Senior counsel.
Please.
Why it can't go to DRAT?
Lords, this is the only issue on the basis of which they wanted to proceed. The court was convinced and they did it. But the difficulty is the bank went to the extent of making an inaccurate statement which the DRT is unmindful of despite bringing to the notice of the DRT that this is what has happened. Kindly have a look at page 177.
Yes.
Lords, the third unnumbered paragraph, taking note of the above. Lordship gets it. Lords. Taking note of the above, all further proceedings initiated by the respondent bank as against the scheduled property stand stayed on condition that applicant remitting 18 lakhs in 3 installments, out of which first, second of 6 lakhs are to be paid on or before 39, 3010 and 3011 respectively. We have complied with this. 6 lakhs is already paid. Now what happens? Now your lordships may kindly take page number 208.
Yes.
Notice this is in OA. This is an order passed in SA. In relation to the second loan, B loan, they have initiated proceedings in OA, that is in the Debt Recovery Act, by specifically saying that these properties are no other property other than the properties which are mortgaged to that loan is with us. Kindly have a look at the order which is passed.
This
208.
No, SA is in respect of A loan.
No, it's A loan.
Then
OA is in respect of B loan. Where my father stood as a personal guarantor. Next, the applicant has filed 2 IAs. IA 367 is an application filed with the applicant seeking attachment of the scheduled property. Issue cause notice to the respondent to show cause why attachment sought for shall not be granted for 6 crores and odd, shall not be furnished. In the meanwhile, there will be an order restraining the response 1 to 3 from alienating and dealing with the property so as to reduce its value. Applicant is permitted to communicate this order to the respondent concerned, so on and so forth. No, we are not permitted to alienate the property. This is all the order passed in the OA pertaining to loan B. Now, kindly have a look at page 194.
194.
Yes, this is essentially the order impugned at your lordship's hands. Applicant had challenged section 14 orders and this tribunal passed an order staying all further proceedings on condition of payment of 18 lakhs. Taking note of the fact that amount outstanding as per the impugned proceedings is 65 lakhs. Counsel for the respondent submits that the property is offered as security in other loans. Also, kindly mark the sentence, minutes. I just wanted to point out that the bank was not fair before the DRT. That's all what I will say. In which the respondent has already issued a sale notice fixing 10/10/25 the outstanding in respect of applicant as 11 crores 18 lakhs 90,000. Taking note of the above order, the order dated 12/9 is modified, limiting the same as against disposition of the applicant. Now the sale is permitted pursuant to this order. What statement which they made before the DRT was not an accurate statement. Can I just persuade you, not your lordship?
No, let's understand. What is this A loan? How much you have taken?
Not 65 lakhs.
65 lakhs.
Now
What
the
is-
outstanding is only 34 lakhs.
Is the property that is mortgaged?
Not the property that is mortgaged. There is one at page number 113.
So 41.
I'm sorry, page number 41. I stand corrected. Loan A, memorandum of deposit of title. This is at page 41. Survey number 36 bar P1, 0.08 acres.
136 oblique P1.
Yes, 36 bar P1. Survey number 36 bar P1.
136.
This correct, though?
I think 40
Please.
136.
Yes,
oblique.
136 bar P1.
Extent is 0.08.
0. Not this is 8 cents. This is essentially 8 cents. Not this is a commercial property where there is a hotel running next to the temple.
Now please come to the
113.
11.
113 is the memorandum of deposit of title deeds pertaining to the loan B.
That is what is the property?
Not these properties are at page number 117. 136 bar 1P2 5 cents, 86 bar 2B1 30 cents, and 86 bar 2B2 Punja land 33 cents. Note they are completely different properties. And the flow of title minutes even in the schedule B, there are entirely different set of documents, different set of
So these are only two properties that are mortgaged.
3 properties mortgaged for loan B.
Where is the
Next
other
page, page 119.
one? What is this?
Notes schedule A.
86
Yes.
oblique 2B2.
86 bar 2B1 and 2B2. 33 cents and 30 cents. This is to syndicate bank. If your lordships were to see, the person who is mortgaged the properties is one Sasikala P. Shetty.
B.
Yes, B loan. The mortgage created by the first loan is by my father K. Surendra Shetty. Now, my father's guarantee agreement is also available, Milords, at page number 102. Purely a personal guarantee. This is executed by, this is purely a personal guarantee. Now, the question is, in respect of a loan for which I have stood as a personal guarantee, and if my property is already mortgaged in some other loan transaction where I am myself the borrower, whether it would be permissible for them to club it in a manner that the security interest of one loan can be recovered for the loans in for recovery of some other loan by utilizing the same security interest. This is the question. But this question came up for consideration on many occasions. Before that, on facts, one statement I wanted to make. They have clearly made a statement before the DRT at page number 200. At page 200. You know, this is in OA pertaining to the same OA 450 of 22 pertaining to loan B.
Yes.
Para 3.
Yes.
We submit that at the time of granting the said credit facilities, applicant has not taken any immovable properties except the OA schedule immovable properties as security and taking advantage of the undue fact with an intention to defraud. They want to deal with the property. This is their stand. In other words, categorical admission is that the property which is mortgaged for loan A is not subjected to mortgage in loan B. It says as simple as that. Borrowers are also different. I am just filing that memo for because they refer to that OA petition schedule property. For that purpose, I am just filing this petition. I just pass on this only for that limited purpose. At page number 13, there is a description of the immovable property mortgaged by the first defendant. 1, 2, 3. 136/1P2, then 86/2B1 and 86/2B2. These are the three properties. So now, on a question of law, that was a wrong statement which was made. So therefore, the statement made before the DRT saying that this is also the subject matter of some other loan transactions was not correct. They cannot take an order which is to my benefit by making a wrong statement, which the DRT was caught unmindful. But the position of law is, I just pass on this list of citations.
We'll continue after now.
Lordships.
Lordship may kindly hear my version of the Lordship, because all the statements made by him are not true.
Why don't you come physically? So many matters of yours are there.
Lordship,
Because
only
there
two
were
matters
lengthy
are there.
arguments online.
My lord,
Next week I'll
serial
come
number
and-
6, my lord, list 2. Entry order was not extended, my lord. Kindly be extended, my lord. Code officer, sir. Code officer, madam. Code officer, sir.
Sir?
Code officer, madam.
ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ ಬಂದಾಗ ಮೆನ್ಷನ್ ಮಾಡ್ಬೋದಾ?
Madam, code officer.
ಸರ್ ಹೇಳಿ ಏನ್ ಬೇಕು?
ಮ್ಯಾಮ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮೋಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿರ್ಲಿಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್
6 ಮ್ಯಾಮ್, ಲಿಸ್ಟ್ 2.
ಒಂದ್ ನಿಮಿಷ. 6 ಅಲ್ಲ?
ಹಾ ಮೇಡಮ್.
ಯಾವ ಲಿಸ್ಟ್ ಸರ್?
ನಮ್ ಲಿಸ್ಟ್ 2 ಮೇಡಮ್.
ಅದೇ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಲೋಡ್ 11
ಮೇಡಮ್. ಎಂಟ್ರಿ ಮೋಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಮೇಡಮ್, ಲಿಸ್ಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು
ನಿಮ್ಗಾಗಿ ಆಗಿಲ್ವೇನೋ ಇದು
ಮೇಡಮ್.
ಇದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಂತೆ ನೋಡಿ ತೋರಣ ಅವರೇ, ಇದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಂತೆ ಮೇಡಮ್ ನ ಕೇಳಿ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಅಲ್ಲಿ ನಿಮ್ 11 ಅಂತ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್, ಅದ್ರಲ್ಲಿ ಐವೋ ಇದೆಯಂತೆ, ಅವ್ರು ಸಬ್ಮಿಟ್ ಮಾಡ್ತಿದ್ದಾರೆ ನೋಡಿ, ಅವಾಗಲೇ ಸಬ್ಮಿಟ್ ಮಾಡಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಮ್ಯಾಮ್.
2:15 ಇವತ್ತಾ? 2 ಗಂಟೆಗೆ ಹೋಗಿ ಅಲ್ಲಿ ಚೇಂಬರ್ ಹೋಗಿ. ಇದು ಸೈನ್ ಆಗಿರೋವು ಡೇಟ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್. ಇದು ಎಂಟ್ರಿ ಮಾಡಿ ಇದೆಯಂತೆ, ಅದು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ, ಅಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ಇದ್ರೆ ಕೇಳ್ಬಿಟ್ಟು ಮಾಡಿ ಮೇಡಮ್ ನ ಕೇಳಿ. ಇಲ್ಲಿ ಮೇಲೆ ಹೋಗಿ ಈಗ ಅದೇ 2 ಗಂಟೆಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದಾರಾ, ಸೊ ಇಲ್ಲಿ ಮೇಲೆ
ಮೇಡಮ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತಲ್ಲ ಮ್ಯಾಮ್?
If you are outside that means, then you can't, they will laughing, they will tell you something like that. That kind of nature, I oppose. I oppose that kind of
ಎಷ್ಟು ಗಂಟೆಗೆಲ್ಲ ಅಡ್ಜರ್ನ್ ಆಯ್ತು ಅವತ್ತು ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ 35 ಇಲ್ಲ 35 ತನಕ ಹೋದ್ರು ಆಮೇಲೆ ಅಡ್ಜರ್ನ್ ಮಾಡ್ಬಿಟ್ಟು ಮಿಕ್ಕಿದೆಲ್ಲ 2 ವಾರ ಆದ್ಮೇಲೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ನೋಡೋಣ ನಾನು ನಿಮ್ಗೆ ಮಾಡ್ತೀನಿ ರೀ ಒಂದು ಅರ್ಧ ಗಂಟೆ ಮಾಡ್ತೀನಿ
ಇವತ್ತು ಮಾಡಿದ್ದೀರಾ ನಿನ್ನೆ ಇವತ್ತು ಇವತ್ತು ನೀವು ಅಯ್ಯೋ why are you searching because math will give the dates all the memos will go to paper and madam will
ಓಕೆ ನಾಳೆ ಚೆಕ್ ಮಾಡ್ತೀನಿ. ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್ ಮ್ಯಾಮ್. ಇನ್ನ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ನನಗೆ
ನಮಸ್ಕಾರ. ಕೋರ್ಟಲ್ಲಿ ಅದೇನೋ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. ನಿನ್ನೆ DRT 23 ನೋಡಿ ಕೊಡಿ. ಹೌದಾ, ಸರಿ ಒಳ್ಳೆ ಇಲ್ಲಿ 18ರಲ್ಲಿ ಒಂದಿತ್ತು. ಮಧ್ಯಾಹ್ನ ಕೊಡ್ತಾರ ಕೊಯ್ಲು ಆಯ್ತಾ? ರವಿ ಬಸ್ಮಿ ಕೊಯ್ಲಿಗೆ ಆಯ್ತಾ ಇಲ್ಲ? ಕೊಯ್ಲಿಗೆ ಓಕೆ ಒಳ್ಳೆ ನೋಡ್ತೀನಿ.
ಪೆಂಡಿಂಗ್ ನಮ್ಗೆ ಯಾವ್ದು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಯಾವ್ದು ಗೊತ್ತಾಗ
ಅಲ್ಲ ಗೊತ್ತಾಗಲ್ಲ ಅದರಲ್ಲಿ ಚಿನ್ನ ಇಪಿ ಯಾಕಂದ್ರೆ ನಮ್ಮ ಮೇಡಮ್ ರೇಷನ್ ಉಪಯೋಗ ಅದು ಇದು ಮಾಡಿಲ್ಲ ಅಂತ ಅಂದ್ರೆ ಬೋನ್ ಕೊಡ್ತಾರೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ಆಗುತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಈ ಅದನ್ನ ಟ್ರೀಟ್ ಮಾಡ್ಕೊಂಡು ಮಾನ್ಯ I didn't instructed them directly. He wrote the comments as well. I direction ಈಗ ಅರೆ ನಾವು ಈ ತರ ಇಲ್ಲ ಬೇಕಂತ ಅದೇ ಏನಾದ್ರು ನೋಡ್ಕೊಂಡು ಯಾರು
ಮೆನ್ಷನ್ ಮಾಡಿ ರೀಸನ್ಸ್ ಏನು ಕೊಡ್ತಾರೆ
ಏನ್ರಿ
ಮೋಹನ್ ಬರ್ಸಲ್ ತುಂಬಾ ಕ್ರಿಸ್ಪ್ ಅಂಡ್ ತುಂಬಾ ಇದಾಗಿರುತ್ತೆ ಅಂತ ರವಿ ಸರ್ ಅದು ಕೃಷ್ಣಮೂರ್ತಿ ಸರ್
ಮೇಡಮ್ ಅದು ಕೊಡಿ ಲಿಸ್ಟ್ ಆಫ್ ಸೈಟೇಷನ್ಸ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ರಲ್ಲ ಕಡ್ರೆ ಹಂಗೆ ಓದ್ತೀನಿ ಅದನ್ನ ಯಾಕೆ ಮಾಡಿದ್ದೀರಾ?
ಹಾಂ ಸರ್ ಅಲ್ಲಿ ಕೃಷ್ಣಮೂರ್ತಿ ಅವರು ಅದು ನಮ್ದು ಒಂದ್ಸರಿ ಕ್ಯಾಪಿಟಲ್ ಹೋಟೆಲ್ ಮಾಡಿದ್ರಲ್ಲ ಇಡೀ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡಿದ್ರೆ ನಾನು 4 ಜನ ಕೊಟ್ಟಿದ್ದೀನಿ ಕಣ.
You wanted me to read the Alcon, huh? Vasu Shetty's case 52. I think is attempts.
That's what even he tries to the.
Oh, yes. That doesn't mean that they can dispense with the requirements of following the Laland. 23, 24, 25. Then alkane. ನಾವು ಲೇಟ್ ಆಗಿ ಬರ್ತೀರಿ ಇವತ್ತು ನಮ್ದೇ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆಯಲ್ಲ ದಟ್ ಮ್ಯಾಟರ್ ಶೀಸ್ ಚೈಲ್ಡ್ ಕಸ್ಟಡಿ ಮ್ಯಾಟರ್ ಶೀಸ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ದ ಚೈಲ್ಡ್ ಸೀಲ್ ನಂಬರ್ 15 ಇತ್ತಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಜರ್ಮನಿ ಐದುವರೆ ಮೇಲೆ ಫೋನ್ ಮಾಡ್ತೀನಿ ಕೋರ್ಟಲ್ಲಿ. It's not that.
Which para in Matthew Rodriguez case we are referring?
29.3. Page number 24.
Which para is it?
Para 13.
ಅಪ್ರೋಚ್ ಹೇಳಿ. ಏನಂತೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗ್ತಾರಲ್ಲ, ಇಸ್ಕೊಳ್ಳಿ ಕಾಪಿ. ಸುಮ್ಮನೆ ಹಂಗೆ ಪಟಾಕಿ ಹೊಡಿತಾರಂತ. ಮತ್ತೆ ಸುಳ್ಳು ಹೇಳಿದ್ರ ಬೆಳಗ್ಗೆ ಅಬ್ಜೆಕ್ಷನ್ ರೆಡಿ ಇದೆ ಅಂತ. ನಾನು ಇಲ್ಲಿ ಕೋರ್ಟ್ 20 ನಲ್ಲಿ ಇದ್ದೀನಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ನಡೀತಾ ಇದೆ.
ಅದಾದ್ಮೇಲೆ ನಮ್ದು ಒಂದೇ ಅಲ್ವಾ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲ?
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇನ್ನೆರಡು ಇದೆಯಾ ಪಾಸ್ ಅವರು? ಹಾ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೆವೆನ್ ನಮ್ದೇನೆ. ಹೌದಾ, ಆಯ್ತು. ಮೇಡಮ್ ಇಲ್ಲಿ ಸುಮ್ಮನೆ ಹಾಕಿದ್ರ ಮತ್ತೆ ಸುಮ್ಮನೆ ಬುರ್ಡೆ ಹೊಡಿತೀರಾ? This is land users whose lands are utilized without acquisition. This is not applicable to us. This is a place, this is a matter where against an agreement they have taken possession of our property under lease dispute. They have to adhere to it. Stay, point to. ಅರ್ಥ ಆಯ್ತಾ? ಹೇಳ್ತೀರಾ ಅಷ್ಟು ಮಾಡಿಸ್ತೀರಾ? ಇಲ್ಲಿ ನಾವು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕ್ರಿ.
ಇದು ಫೈನಲ್ ಸರ್ ಕ್ಲಿಯರ್ ಇದೆ.
ಹಾ ಎಷ್ಟೊತ್ತಾಗಲ್ಲ
ಮುಗಿತು ಬಂತು ಸರ್. ಐ ಥಿಂಕ್ ಈಸ್ ಡನ್. ಇದು ಟೈಮ್ ಸ್ವಲ್ಪ
ಲೀಜರ್ಲಿ ಗಾಡ್. ಈಗೇನಿದೆ ಅಲ್ಲಿ ದುಡ್ಡು ಬೇಡವಾ ನಿಮಗೆ? ಇಲ್ಲಿ get forfeited because you have not paid within 80 days.
stay with it.
There's no stay.
stays to vacated March. From March, there is no interim order stay in the option procedure. Only stay is not to issue the sale certificate. Essentially means you are required to deposit the certificate. To go by Sharon Bero's case and Guraja's case. And now that the recent judgment of Justice Shamsundar, then chances are bound to pay and then come to the court and say, no, this is not done. Not the other way around.
Just talk to him.
The reason is because I'm telling this to you is that is the argument which we can. In case ಕೇಳಿ ಆ ಥರ ಏನಾದ್ರು we can ಅವ್ರಿಗೆ ಏನಾದ್ರು ಒಂಚೂರು ಜಾಸ್ತಿ ಕೊಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿಸ್ಕೊಳೋಣ. ಸರಿ ಕೇಳ್ತೀರಾ? ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ. ನಾನು 22ರಲ್ಲೇ ಇದ್ದೀನಿ. ತಾವು 22ರಲ್ಲಿ ಇದ್ದೀನಿ. Then nothing. See, that is wherever land is utilized without acquisition rate, telecast.
ಇದು application, demand application.
ಆಯ್ತಾ ಬರ್ಬೇಕು ಅಂತ ಒಂದು ಪಾಸ್ ಹೇಳಿ. ಒಂದು 15 ಎಷ್ಟು ಪ್ರಾಪರ್ಟಿ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಮೇಡಮ್ 50 ಕೋಟಿ ರೂಪಾಯಿ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟು ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ಟು ಏನಾರ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಎಲ್ಲ ಟೋಪಿ
Including penalty.
Including penalty, the bank is sitting, there is nothing to pay. The bank is sitting pretty with two things. 5 crores 80 lakhs paid by him, 4 crores paid by him to recover 3.4 crores. 5.8 crores also bank should get and he should get the portion. Law says that bank should get it. So now they should see what should be done. My regular
Only once he pays the entire amount, he can charge.
ಹೇಳಿದ್ರು. This is the scenario. This argument is to be accepted. Don't say that. He will also lose the money. Bank will get unjustly entered for 5.81 crores because there is no future. You will get a closure here saying that this is closed. Then everybody is win-win situation. Bank has got this money, I got my property, he's got his money back with solution. Finish. Explain ಮಾಡಿದ್ದಾರೆ. It is a fact that they are the tenants. ಬೇಗನೆ ಮಾಡೋದಿಲ್ಲ. ನೀವು ಏನು ನೆಕ್ಸ್ಟ್ ಯಾವುದು
ನೆಕ್ಸ್ಟ್ ಅದಕ್ಕೆ
ನೀವು ಸ್ವಲ್ಪ ಹೊತ್ತು ಮಾಡಿ ಆಮೇಲೆ
ಅಲ್ಲ ಅದಾದ್ಮೇಲೆ ಪಾಸ್ ಔಟ್
ಇಲ್ಲ
ಕಂಟಿನ್ಯೂ
ಲಾಸ್ಟ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಅಷ್ಟೇ
ರಿಪೀಟ್ ಮ್ಯಾಟರ್ಸ್
ಇಲ್ಲ ನೆನ್ನೆ ಕೂಡ ನಂದಿತ್ತು
proceeding. Yeah, exceptional case. One second, that 70. They say it is. Not they make a statement, then action will be taken. 70. What they will realize and make a statement. Yes, we are committed in this statement. But I got question. Judgments there. Yashodhara aggregate. Respect positively then.
ಯಾಕೆ ಗಯ ಕಲ್ಕ
Especially Hegde, Mohandas Hegde, that's what I'm saying. They are Hegde, they are Mohandas Hegde, lifetime lawyer.
ಅವ್ರು ಬಿ ಹೇಗೆ ಮತ್ತೆ ಇದು ಐಟಲ್ಲಿ ಕಡೆ ಬರ್ತಾರೆ
Family, they are very well built. Well built means they are around 6 feet. ಒಂದೇ ದಿನ Madam Ram Kishan, two paragraphs. No, paragraph. ಎಷ್ಟು ಕೊಡಿಸ್ಬೇಕು ಕೇಳ್ರಿ ಅದ್ರ ಮೇಲೆ 4 ಕೋಟಿ ಕೊಡಿಸ್ತಾರೆ. Just told him this. Just imagine a circumstance where the court accepts. I don't say it will accept, but it should be a win-win situation for all. Therefore, I suggested if he is ready to take some solution, he will actually send his money and he will get little more. If for any reason the court says because the law is now well settled, the bank had no option. If it is now to be taken that he is not deposited within 90 days, or the picture is not available, and bank gets benefited with this amount, he will also lose the money. And that will be in the order of the court. ಅವ್ರಿಗೆ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಏನೋ ಮಾಡ್ಕೊತೀವಿ ಅಂತ ಮಾಡಕ್ಕಾಗೋದಿಲ್ಲ.
ಅಷ್ಟೇ ಮಾತಾಡ್ತೀನಿ ಬಟ್ what should I tell him?
And he paid Indonesia how much he is expecting. See, now he is paying 2% interest. Let him pay double that, triple that. Let him pay 5%, 6% interest on that. It is still a good profit.
2% monthly is what he gets.
That's right. That's what I'm telling. See, for how many months is paid? 10 months, 20%. So 20% is essentially 1 crore according to his pay. Something like that is very close, isn't it?
I talked to him. Very difficult. Doctor, if he's willing, then I'll let you know. If he says, I take my chances, it's up to him.
That's right. I know that. Yeah. That's the principal condition.
Even chiefs,
Like a Gurraja was the case, and the Shanmugh was case, and now this is Mr. Shyam Prasad who said, in the event there is any impediment for concluding, the obligation of the option purchase is to deposit the money and then get it cleared. Not that you should wait for it to be cleared and then, because that is not contemplated. Best in case.
Yes, sir. I understand.
ಅದಕ್ಕೆ ಏನಕ್ಕೆ ಅವ್ರಿಗೇನೆ ಸರ್ ನಮಗೆ ನಾವು ದುಡ್ಡು ಕಟ್ಟಿದ್ದೀವಿ ಅದನ್ನ ಫೈವ್ ಪಾಯಿಂಟ್ 8 crores. Yeah. One crore interest rate. ಓ ಗೋವಿಂದ ಎನ್ಮ ಆಯ್ತು ಇಲ್ಲಿ ಇದು ಮುಗ್ದಿಲ್ಲ ಅವ್ರ ಹೇಳ್ತದ್ದು ಇನ್ನೊಂದು ಪಾಸ್ವರ್ಡ್ ಆಯ್ತಲ್ಲ ಅದನ್ನ ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿ ಅಂತ ಆಗಲ್ಲ ಬಿಡಿ ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿ ಇಲ್ಲ ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಡಿ ಅಂತ ಅದು ನಾನು ಒಂದು ಸ್ಪಿನ್ ಬಲಿಂಗ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಕೇಸಲ್ಲಿ ನನ್ನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನು ಅಂದ್ರೆ ಫೋರ್ ಫೀಚರ್ ಆಟೋಮ್ಯಾಟಿಕ್ 5.8 the bank purchasing is nobody's argument ಮಾಡ್ತೀನಿ my argument is accepted then your 5.81 crores ಅದರ ಬದಲು ನೀವು ಒಂದು ಕೋಟಿ ಸೇರಿಸ್ಕೊಡ್ತಿತ್ತು ಹೋಗು ಆರು ಕೊಟ್ಟರೆ ಆರು ತಿಂಗಳಿಗೆ 6 ಕೋಟಿ ರೂಪಾಯಿ ಲಾಭ ಯಾವೊಂದು ಕೊಡ್ತಿತ್ತು ಹೋಗು ಅಂತ ಹೇಳಿದ್ವಿ ನಾನು ಒಪ್ಕೊಳ್ತೇನೆ ಮಾತಾಡಿ ಆಮೇಲೆ ಒಂದು 3 ಕೋಟಿ ಕೊಡ್ಸಿ ಬಂದಿದ್ದಾನೆ ಆಲ್ಮೋಸ್ಟ್
ಚೆಕ್ ಮಾಡಿ ಅಂತ ಹೇಳೋರಲ್ಲ
ಇಲ್ಲ ಒಬ್ಬನೇ ಮುಖ ಇಲ್ಲಿ ಒದ್ದಾಡ್ಕೊಂಡಿದ್ದಾನೆ 60 ಕೋಟಿ ರೂಪಾಯಿ ಪ್ರಾಪರ್ಟಿ 40 ಕೋಟಿ ರೂಪಾಯಿ ಮಾರ್ಕೆಟ್ ಅವನು ಲ್ಯಾಂಡ್ ಓನರ್ ಇದ್ದಾನೆ ಇವನು ಪರ್ಚೇಸರ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಆಫ್ ಒನ್ ಆಫ್ ದಿ ಬ್ರಾಂಚಸ್ ಆಫ್ ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್ ಫಾರ್ ದಿಸ್ ಪ್ರಾಪರ್ಟೀಸ್ ಚಂದನ್ ಕುಮಾರ್ DCP ವೇಟ್ ಮಾಡಿ ಎರಡಕ್ಕೆ ಬಂದಾಗ ನಮ್ಮಲ್ಲಿ ಕುತ್ತಿಗೆ ಬಿಟ್ಟು ಹೋಗ್ತಾರೆ ಯಾಕಂದ್ರೆ ಇನ್ನೊಂದು ಮಗನು ಮಾಡಿರೋದಂತ ಬರೋರು ತೆಪ್ಪಿದ್ರೆ ಅವನೇನು 6 ಕೋಟಿ ರೂಪಾಯಿ ಹಾಕೋ ಅವಶ್ಯಕತೆ ಇರಲಿಲ್ಲ ಲೆಕ್ಕ ಸರಿಯಾಗಿ ಕಟ್ಟಿದ್ದಾರೆ
ಪಾಯಿಂಟ್ ಅಲ್ಲಿ ಹುಡ್ಕೋಣ ಅಂದ್ರೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ರೂ ನಾವೇ ಪರ್ಚೇಸ್ ಮಾಡ್ತೀವಿ ಅಂತ DLT ಹಾಕ್ಕೊಡ್ಬೇಕಾಯ್ತು DLT ಹಾಕ್ಕೊಡ್ಬೇಕಾಯ್ತು ನೋಟಿಸ್ ಕನ್ಸರ್ವೇಷನ್ ಈಗ 4 weeks ಟೈಮ್ ಕೊಟ್ಟರು ಪೇಮೆಂಟ್ ಕಾಸು ಕಟ್ತೀನಿ ಅದು ಕೂಡ ನಾವು ರಿಮೂವ್ ಮಾಡೋದ್ರಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಇಂಟೀರಿಯರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಸಿಕ್ಕಲಿ ಆಮೇಲೆ ಸಿಕ್ಕಲ್ಲ
ಅದರಲ್ಲಿ ಮೆಮೊ ಫಾರ್ ಡೆಪಾಸಿಟ್ ಹಾಕಿದ್ದಾರೆ ಇಲ್ಲ 67 ಅಲ್ಲೋ ಏನಲ್ಲ 110
ಸೊಲ್ಯೂಷನ್ ಮಾಡ್ತಾರೆ ಮುಗಿಸ್ಬಿಟ್ಟು ಬರೀತೀನಿ. ತಪ್ಸೋದು ಆಯ್ತು ಅಷ್ಟೇ.
Visitation is desired
ಮೇಡಮ್ ಇನ್ನು ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗ್ಬೋದಾ? ನಾಲ್ ಮುಗ್ದಿಲ್ಲ ಅಲ್ಲ, ಒಂದ್ಸಲಿ ಕೇಳ್ಬಿಡಿ, ನಾನು ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇದೆ ಬೇರೆ ಮುಗಿಸ್ಕೊಂಬರ್ಲ.
ನಾವು ಕಳಿಸಿ 5 ದಿನ ಮಾತ್ರ ವಾಪಸ್ ಕೊಡ್ತಾರೆ. ಮೆಕ್ಯಾನಿಸಮ್ ಕರೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟ ಅಂದ್ರೆ
One submission, Your Lordship. Lordship had disposed of this matter.
Dismissed.
Dismissed, my lord. Lord, may I make one submission? In fact, they have already reached the premise and they are locking it out. We are seeking only for a 2 days accommodation where we will take all the belongings. In spite of that, my lord,
Where are they?
they are,
Bank.
in fact, I telephoned him. He told that he is held up in civil court and he is unable to attend. In fact, we have shared the undertaking letter, all the undertaking memo also through WhatsApp. And we sought at least 2 days time may be granted so that we will take all the belongings. In fact, they are seizing the entire premise. And unfortunate thing is that,
You have done it in the morning.
Lord, I made that submission. In fact,
no.
I thought that
Typical time is not 2 days you're asking.
but the fact of the matter is that the husband is a,
Okay, the other side has to be here.
please, my lord. I telephoned him and I dropped the message also and I shared this.
Tell them that let him send his colleague. Court is insisting for that. Call him and tell him.
Please, my lord.
List number 2, serial number.
Yes, please continue. Where is it? And what about that matter? Just know that in that I have passed an order. The boy is ready to go to the father, meet the father on Sunday, and the father is ready to pay 2.5 lakhs. He'll be transferring 2.5 lakhs before Sunday. We'll have the matter on 20. I think I posted it to 23rd. Until further order, till the next date of hearing, they shall be stay of all further proceedings pursuant to the order dated so and so. The order so and so is stayed. The order dated so and so is stayed. Yes. Yes.
List number 2, serial number 12.
Lordship, appearing for the response.
Continue.
Lordship, in this matter, your lordship, two loans are availed, your lordship, for 2 guest houses. The father was running 2 guest houses. Mr. Surendra Shetty is the father.
Let us forget about the relationship of the parties. The
Yes, your
relationship of the parties is not the concern of the bank. You have an agreement with them, loan agreement, mortgage. So he was saying A, B, two loans they have taken. So this particular writ petition is pertaining to the A loan. One property is mortgaged. You are only concerned with that. The other property is yes.
The property which is mortgaged, which is a disputed here property, your lordship, is the father's property. And the daughter, who is the second person who has taken the second loan, she is also acquiring a share in the property. It is not Prakash Shetty's individual property. They want the share in the father's property. They don't want the liability on the father. This is the case of Mr. Prakash Shetty, your lordship, the petitioner herein. The same, he has.
No, let's not get confused with the facts. No, please tell the court for the A loan, the property that is mortgaged is 136/P1 is a property. You can proceed in respect of this A. You can only proceed against this 136/P1.
Lordship, that is attached to the second loan also, your lordship. It is attached in the second loan also, and the person who is the owner property also.
No. Unless and until that property is mortgaged to the bank, how can you attach that property for the realization of the amount in the second loan?
It is also both the guest houses are connected to each other because the same entrance and its first front portion and back portion, your lordship, the guest house, and both the properties are mortgaged. Both the properties are mortgaged, your lordship. It's not that.
Factually, what you are submitting and what the learned senior counsel is submitting is not one and the same.
It is the because he's
agreement. No, there must be an agreement. Where is that loan agreement?
I shall produce everything. Because this case is again posted on 26 in the DRT, Your Lordship, because the presiding officer clearly said, let the sale go on, post the case to 26, so that the facts and figures, everything comes out. Half of the facts are told because all the loan.
When will you come physically and appear before the court?
I did not want to make this statement, Milods, because since it's a bank, I did not use this language. Bank played fraud on the court to get this order.
That we will consider.
Not the reason.
Come up with the.
The auction is for tomorrow. Not, I'm not saying that in respect of 3 other properties there should be no auction. Let there be auction in respect of 3 properties for recovery of that money. Absolutely no difficulty. So
The loan
A is concerned, they are actually targeting only this property because there is a hotel which is standing here, which is a high-end hotel. The other one is a little low-end hotel, Milods, which is subject matter of the other mortgage. Let them sell those properties. Somehow there is something which is happening by virtue of which they have somehow wanted to bring this property also to auction. There is an element of malice, because why should the bank go and make a statement that this property is mortgaged in respect of other loans, when they make a statement before the DRT saying that this property is not subject matter of any other loan? It's a wrong statement made. Milods, if now I just wanted to put this question to myself. If this statement was not made before the DRT, the interim order granted by the DRT would have enabled to my benefit in a manner that this, and I have complied with the orders of the DRT.
After that, the case was posted on 9/11. They opted not to attend the case on 9/11, Your Lordship. This order was 4/11. Your Lordship, may kindly see the case was called on 9/11, where they opted not to appear on the court, to the DRT. And this sale notice is issued way back in in September 9th, Your Lordship. 1 month after that, they have come to this honorable court, Your Lordship. Tomorrow.
DRT, what is this?
It's only one clarification that is required. There is nothing much to be argued, because this court is not going to any of the issues. In respect of this loan, which is the property mortgaged, only to that property you can initiate the proceedings. Just because it is my father, daughter, sister, all those relations are not at all, the court is not concerned, neither you can do it. So you have to place before the court.
The loans, Your Lordship. Particular property is attached to.
No. Please come to the. They have filed the documents before the court. Looking at
Lordship.
the documents, please.
Your Lordship, I am on the. Your Lordship. All the documents, Your Lordship. Monday, I will physically be present and produce all the required documents, Your Lordship.
Don't go ahead with the sale tomorrow.
Only pertaining to this property. There are 4 properties brought to sale.
When that is so important, you should have come to the court. You should have come to the court basing on papers. You should have argued. You know that they will argue. Today they will insist for an interim order. Because
Your
on
Lordship,
the face of it.
Your Lordship, this matter is
convinced.
And the DRT has said go ahead with the sale, Your Lordship. It's after that they are coming here and making.
Basing on the submission made by you.
Yes, Your Lordship. All the documents are in DRT, Your Lordship. 3 cases pending matters are in DRT, Your Lordship. Because they are the competent authority. The DRT can.
I will record these reasons, and I have to. So you can't go ahead with the sale.
Your Lordship, the sale may go on, Your Lordship. At least the sale,
Sale as far as 136/P1 is concerned, you cannot go ahead.
Lordship, even after the sale of properties, the loan amount, the person the bank will acquire only 3.5 crores, Your Lordship. 3.5 crores. The loan liability is more than 11 crores, Your Lordship. Your Lordship may see that.
Property which is that the court can't help it, but we will also take a judicial note of the submission that is made before the DRT. Why such a submission is made?
Your Lordship,
why you have misled the court?
Correct facts are made. It's only that the learned counsel is telling us wrong submissions are made. It is not wrong submissions are made. Correct submissions are made and proper order is passed by the presiding officer. If the order is wrong, he can.
You have to demonstrate that. You have to demonstrate that, drawing the attention of the court to the relevant documents.
If the order is wrong, I shall definitely produce. Let him challenge the order. I will produce all the documents, Your Lordship.
She produced in DRT in statement of objections.
Once every single document which was produced before the DRT along with the statement of objections before the court.
They have DRT.
Order is passed on.
The order was obtained, and after I went and explained about everything. I advanced the matter, explained everything, and the order was modified, Your Lordship, and it is again posted on 26th. And 26 is just 4 days. I mean.
25/9/2025.
25, Your Lordship, it's posted on 26, the DRT matter is posted on 26.
Will stay the auction as far as this property is concerned.
Your Lordship,
Will stay the auction as far as this property is concerned.
but it is
Public P1.
property, both the properties are one and the same, Your Lordship. It's two guest houses, through this only the second property. I can't even sell the other properties, Your Lordship. I'm not in a position to sell it because this is the entrance, first portion and second portion, Your Lordship. Fair, on if 1 week time.
That's how you got the properties mortgage.
Your Lordship.
Before the mortgage is executed.
Lordship. The first portion, Your Lordship, and the second portion. I can't sell one portion of the property, Your Lordship. It is a joint property.
It's not. No, it's not. It's a wrong statement.
What? I should the facts and figures, Your Lordship. 1 week time may be granted. I will not go ahead with the sales certificate, Your Lordship.
Then I'll record that.
Yes, much obliged, Your Lordship. Sales certificate will issue only after Your Lordship is convinced with the facts and figures, Your Lordship.
You see, they will not go ahead with the sale itself.
Please, let them not go with this, please.
The sales certificate will not issue, Your Lordship. Sales certificate will not issue, Your Lordship. Sales will go on. Sales certificates are the outcome of the.
You're talking about finalization of the sale. No sale to be conducted. Where is the imperial order page number?
Your Lordship, sales certificate. Your Lordship, sales shall go on, Your Lordship. Sales certificate, Your Lordship, I shall issue later on, Your Lordship. Sale, there's already property bidders and everything is over, Your Lordship. Tomorrow morning is the sale.
Where is the impugn order? Page number?
It's page number 194 and the auction notice is at page 36.
194.
Yes.
Lordship, he is not the petitioner is not the single owner of the second. The Sushila Shetty is also a part owner of the first property, Your Lordship. Her liability is more than 11 crores.
Who has executed the mortgage? Please tell the court.
Sushila Shetty is father of the mortgage. First sale the father has executed and is expired, Your Lordship. She is inheriting the property. The person in the second loan is inheriting the property, Your Lordship. Is inheriting half of the, portion of the property.
She's the only daughter.
Towards this property also. She has a right in this property also.
That you will decide. She's the only daughter.
No.
And one
There are
son,
two other daughters.
Now this person is no more.
Janardhan Shetty is no more. Surendra Shetty is no more.
Hmm.
Surendra Shetty as a property, my lords, is subjected to one loan. That loan is virtually completely closed. The DRT gave the time saying that within this time schedule, we'll have to pay the loan amount. We have adhered to that. Now, first installment was paid. Then the council came and said this property, so far as that loan is concerned, they are not having a grievance. Since they said this property is also subject matter of mortgage in another loan, therefore the DRT passed that order. If otherwise the DRT, insofar as A loan is concerned, it has already satisfied. But what is due is only 34 lakhs.
This property is attached to another loan. This property is attached to subject to another loan. It is attached to the passed by the DRT itself.
Sale notice so far as the property is concerned.
This property is attached to another loan also, Your Lordship. Attachment order is also produced.
If these statements are being made like this carelessly, my lord,
no, Your
the
Lordship.
sale notice.
This property is loan also, Your Lordship.
For questioning the sale notice.
Lords, the
When
sale
there's
notice.
nothing wrong with the DRT order and proceedings are initiated there.
Lords, proceedings pertaining to loan initiated by before the DRT. DRT passes an interim order not to go ahead with the auction pertaining to this property. So therefore, DRT has confirmed that this property, no auction can take place, subject to compliance with the conditions. That's over.
This order
This order says, this order says.
This order is not supposed to be question?
This order, my lords, I realize, my lord, that my
I was
counsel
under
on
the
record.
impression this order is questioned.
Yes.
Without questioning the order, why would this court interfere with the
Lords,
sale
now,
notice?
if your lords were to see, my lords, why this order came to be passed? If the order is passed, yes.
Again,
I
it goes
understand, my
back
lords.
to
We are again going round and round and coming back to the same place.
And
Lords,
without that, no, this court cannot interfere with any of the sale
Lords,
notice.
I'm not saying that. Lords, I'm only saying that. Kindly have a look at the sale notice at page 36.
Yes.
Lords, now, sale notice is bringing the properties pertaining to KSS Hotel and Lodging loan, which is loan B, and the mortgage loan. Kindly have a look at page 36. This is all my contention. It is covered by at least about six judgments of various high courts.
He is in such a hurry that he can't even formulate a formal prayer. What is to be?
They should have.
No.
Sometimes
one paper you file and file the writ petition.
It's page 36, your lords may kindly see. This is ultimately the whole object of this writ petition, because the clubbing is never contemplated. Lords, assuming, my lords, that even page 194 they have to give effect to, it is that.
No. This particular, unless and until you question this order of the tribunal, you cannot find fault with the notification, that is a sale notification,
yes,
auction notification that is issued. So necessarily, court has to find fault with this order.
Yeah. Sale notice is 9/9. This is on 25.
Lords, on sale notice is on 9/9/2025.
Yes.
The order is on 25/9/2025.
There is an order by the
DRT. Kindly have a look at that order, my lords.
Yes, I'm looking at it.
Lords, counsel for the respondent submits that the property is offered as security in other loans, also in which the respondent has already issued sale notice. Kindly mark that sentence.
Yes.
Lords,
I've already marked.
Representation is not that in relation to this loan they want to bring the property to sale.
This order is bad.
Lords, now in relation to the other property, if they want the property to be sold, it should have been mortgaged. This is essentially the point. Counsel for the respondent submits that the property is offered as security in other loans also, in which the respondent has already issued a sale notice fixing the sale on 10/10/2025, total outstanding in respect of so. Taking note of the above, the order dated 12/9 is modified, limiting the same as against disposition of the applicant from the scheduled property pursuant to orders dated so and so. Now, so far as the statement which was made before the DRT is concerned, is that the sale notice is issued pertaining to loan B.
Absolutely, there is no difficulty in it. I understood your submission clearly. That's why I'm about to pass the order.
Can I make this request, Minutes? Before the rising of the court, I'll make that application seeking amendment. Minutes, tomorrow is the auction. Minutes, there are already people who are interested to. Minutes, now, out of 75 lakhs, I have reduced myself to 34 lakhs after paying 75 lakhs. So I have paid the interest, everything. Minutes, that's the reason. First statement which I made was, if I were to be asked whether there is any due, yes, there is a due of 34. If I am to be asked a question whether there is any overdue amount, no, there is no overdue amount. If 75 lakhs is taken into consideration, my account is already regularized. That is where it stands.
Then why are you not paying the remaining amount?
No, the DRT said that you pay this money in 3 installments, fixing the dates. Lords, may kindly take page number 177. DRT gave this leverage to me. So therefore, my lords, now if your lords were to even modify this order within a period of 20 days, I'll pay whatever is the outstanding. We even made this statement, but the DRT has passed this order. I have complied with this order.
39, you have complied.
Yes.
30-10, you are to pay.
Lords, that's the reason. If it is to be accelerated and paid, I'll pay it. Because due is only 34 lakhs. As against my property. Lords, now the property according to them is valued about 3.5 crores. 34 lakhs is the due. Out of that, another 6 lakhs.
Yes. Please come.
Your Lordship, in this matter, in OA number 1387, this property is attached to your Lordship. It is attached. They are not directed to do anything with this property, your Lordship. Very clear order of attachment is there. In another, in the other loan also, your Lordship. Property is attached and it is brought and it's on verification. Amended, your Lordship. This property is attached to another loan also. I shall produce the documents, your Lordship. I shall produce the documents.
Page 208, I produce the order sheet. That's again a wrong statement.
Your Lordship, may kindly see 208. Very clearly it says.
Meanwhile, you're not answering that, and you just simply say that property, this property, and you're confusing yourself and confusing the court, the council.
I am not, your Lordship. I'm telling
OA is pertaining to which loan? Please tell
There are
us
two
what.
OAs are pending, two OAs are filed, Your Lordship.
Please refer to, you have his papers filed by him? You have
I
the
do.
papers filed by the, is it
Yeah,
served
yeah.
on you?
It is
Please-
served on you.
Please point out.
Two loans are availed, Your Lordship.
Yes, please tell what are those two loan accounts?
The one second. Your Lordship. Lordship, may just pass over the matter, Your Lordship. I'll give you all the information, both the loan numbers, Your Lordship.
And from here onwards, we will not allow any counsel to appear online in all these DRT matters. Because already we have wasted a lot of time on this. Yes, pass out. Call the next matter. Complete the list and then take the pass outs. Yes. Yes.
So, serial number 13, Siddharth Suman.
Pertains to an auction in respect of an agricultural property. Now, insofar as SARFAESI is concerned, there's an absolute bar insofar as auctioning it or attaching it. Now, this is a very peculiar situation where the provisions of the RDDB Act are invoked first, then SARFAESI is invoked, then now they come back to RDDB Act. Now, this is a property which I am actively using for agriculture. I've produced the RTCs also. As on the date of me mortgaging the property also, we are only concerned that there are two properties which are mortgaged. Petition number 1 owns survey number 11 in Dodbalapur. This we are only pertaining to survey number 150.
What is the order imputed now?
This is the attachment order. Now tomorrow there's an auction. My lords, may kindly see Annexure B, the auction. Now they come to a calculation saying it's about 4 crores which I'm due. The total loan amount was only for 1 crore 2 lakhs.
If it is an agriculture property and
Please.
it is excluded from the act.
Please.
When they issued a notice under 13(2), what did you do?
My lord, then then what? My lord, I sent them a letter saying that, see, insofar as this is concerned, my lord, insofar as their knowledge, the party's knowledge, he would not be really privy to the fact that this cannot be attached. He makes a representation saying, see, I will please give me a notice. I will then ensure that.
Whole purport of 13(2) notice.
Please. So then he says, my lord, give me a notice and then I'll ensure that it's cleared. My lord, the OTS, there are some.
When the proceedings are initiated.
My lord, there's an OA order, my lord. So then there's, please. The OA orders in 2017, 19/6/2017.
So it's too early now, 2025.
No, there are much more. There are many more proceedings after that. In
That's why,
2000,
because we are all entertaining these kind of petitions.
my lord, may I just come to
it will
that?
never conclude.
I'll just come to that. I'll just take my lords
Let there be one forum for all this.
My lord, factually, I'll just take my lords very, very quickly because 2017 is the OA order. Then thereafter, my lord, I was given 6 months time. We make an OTS proposal. They make a counter OTS proposal. My lord, nothing happens then because there, my lord, I have a poultry farm also here. My lord, I had about 5,000 chicken dead because one is because but there was a hailstorm and there was a cyclone. Number 2 is because of the bird flu virus. So these are two aspects. I'm not going into the emotional aspect of it, but here factually, subsequent to this, when OTS proposals are going on, they forego the RDDB Act. Then they go into SARFAESI. 13 to subclause 2 notice is issued. Thereafter, 13(4) subclause notice is issued. Subsequent to that, there's a sale notice. Subsequent to that, in 2021, it was put down for auction. From 2021, that auction does not go on because there is a bar. So for whatever reasons, it does not go on. Subsequent to that, after 4 years, suddenly, now there's a notice issued. From 2021, nothing is done.
This year, yes.
May I make a request? Kindly take Annexure A, my lords.
Yes.
First, my lords, the decree is passed in 2017.
What is passed?
Order of OA is passed in 2017, 19th June 2017. my lords.
19th June 2017.
Pass on the recovery certificate, my lords.
Where is that order?
Annexure H, page 62.
63.
May I pass on the recovery certificate, my lords.
This is the latest one, sir. I have the old one.
Yes, 62.
My lords, pursuant to that order, my lords, the document which I have given, this is a recovery certificate issued in the year 2019. Subsequently, recovery certificate, my lords, the recovery officers takes charge. My lords, a warrant of attachment is issued. If my lords were to kindly take page number 27.
Of these papers or your papers?
His papers, my lords.
Yes.
Annexure. On 29/4.
Hmm.
Thereafter, my lords, 29/4/2025, the recovery, this is the order passed by the recovery officer.
Hmm.
Under executing a decree. Thereafter, my lords, page number 29, notice for settling sale proclamations has been issued. If my lords were to kindly take my paper book, my lords, kindly take page number 7, my lords.
This is dated.
My lords, that is also dated 29/4/2025.
Hmm.
My lords, after notice of attachment, sale proclamation is issued in under law. My lords, we also intimate them on, kindly take page number 7 of my paper book.
Hmm.
We intimate him on 16/7/2025.
Page number
7/7. He has signed it, my lords, where we have said that
Hmm.
the property will be brought to sale subsequently by the recovery office.
Hmm.
That's what my learned friend is saying. If my lords were to kindly take section 25 of RDDB Act.
Sir.
Recovery of debts in bankruptcy Act. Section 25. Plus, recovery officer shall, on receipt of the certificate under subsection 7,
Section 22.
25, my lords, modes of recovery.
That is not, that is rule. Yes.
Recovery officer shall, on receipt of certificate, copy of certificate under subsection 7 of section 19, proceed to recover the amount of debt specified in the certificate
No,
by
I'm not
one.
able to find it. You said section 27.
25, my lords, 25.
Mode of recovery. Yes.
Attachment and sale of movable or immovable property of the defendant. Taking possession of the property over which security interest is created or any other property of the defendant, appointing receiver of such property and to sell the same. Under section 25, my lords, he has initiated proceeding to sell the property. This mortgage was done in the year 2012, my lords. The mortgage deed also my friend has produced at page number
Yes, yes, we'll take it as 2012.
2012, my lords. 2015, my lords, the proceedings were classified as NPA. We have in 15. From 2015 till 2025, he has not even made single rupee payment.
Sorry, that is factually wrong, but.
What is
Let him
the
produce the statement.
What is the amount?
Well, 4 crores 39 lakhs.
As on 2015.
Plus, as on the date of sale notice which has been issued. 4 crores 39 lakhs, 23 lakhs 99,540. If my lords were to kindly, before this, my lords, this order passed by a recovery officer is appealable under section 30 before the DRT. May I request to kindly take section 30.
Yes. Appeal against the order of
Recovery officer.
recovery officer.
Notwithstanding anything contained in section 29, any person aggrieved by an order of recovery officer made under this act may within 30 days from the date of which a copy of the order is issued to him prefer an appeal to the tribunal. On receipt of an appeal under subsection 1, the tribunal may, after giving an opportunity to the appellant, be heard after making such inquiry as it deems fit, confirms, modified, set aside the order made by the recovery officer in exercise of power under section 25 to
The
28.
officer's order is 29/4/2025.
Please. First, notice was given on 29/4. Attachment was passed on 29/4. Subsequently, sale notice is issued on 11/9, fixing the sale on 16/10. From 11/9 till 14/10, they keep quiet. 14/10, they come before this honorable court, saying that all the proceedings which are, plus whether RDDB Act and SURFACE Act is in exclusion or exclusion. If my lords are to kindly take section 37 of SURFACE Act, my lords.
Yes.
Whether the bank has initiated 2 proceedings, 3 proceedings, my lords, there is no bar as such. The provisions of this act or the rules made under there shall be in addition to, not in derogations of Companies Act, so and so securities. The last word, my lords, the recovery of debts due to banks and financial institution or any time being in force. The bank has a liberty. Because bank initiated the proceedings. Subsequently, they contended it is an agricultural property. Bank went through OA, secured a decree, went to recovery officer, and now they have brought the property to sale. From 2015 is the last date of payment which has been made. From 2015 to 2025, my lords, if my lords are to kindly see, take his phone paper book. page number 90. His own paper book at page number 90. Offer for OTS was given to him. He never comes forward.
So page
This
number.
was in the year 15/5/2023, my lords, where the bank has called him to avail an offer where there was a scheme in the year 2023, my lords. And if my lords were to kindly take 72. First offer was given to him in 2017. Even we secured the decree to come forward and secure, settle if he wants to offer under 1 tier times 2020. In that, my lords, paragraph 7.1, page 54. It is in respect to surface where agricultural properties cannot be brought to sale by an authorized officer. It is a sale being brought by the court, not by an authorized officer. My lords, authorized officers cannot go beyond the act, so that there was a bar under section 31. And there is no such bar under the RDDB Act. Section 25 permits the recovery officer to sell all the properties which has been mortgaged, where security interest has been created. Yes, security interest has been. If that is a case which my learned friend, in none of the cases, my lords, where OA orders have been passed, no loan can be granted on agricultural.
Yes.
It cannot be sold on a securitization act, not on the RDDB Act. Section 25 permits the recovery officer to go against any of the properties where security interest has been created.
Please come.
My lords,
And
may
the
kindly
next-
see the
next judge-
RTCs, my lord. My learned
next
friend has said
judgment,
that there
my
is no
lords.
proof to say that this is agricultural land. It was an agricultural land in 2011. It continues to be so. My lords, may kindly see
No,
page
that's what,
52.
that's what the Supreme Court said. It says,
But that was a case where conversion was pending.
no, not conversion is
Please.
pending. The Supreme Court, in any event, having regard to the character of the land and the purpose for which it is set apart, we are of the
Please.
view that the land in question is not an agricultural land.
Please.
The High Court misdirected itself in holding that the land was an agricultural land merely because it stood as such in the revenue.
My lords, may then kindly see the photographs, my lord. I cannot create this. This ragi, my lord, from 2012, I have ragi farming, my lord.
Poultry farm is there.
Poultry farm is there in the side, my lord. Now today I don't have it anymore because after that, my lord, I have nothing. It's only ragi farming.
He cannot
My
take
lords, may
two
kindly
stands.
see. My
He
lords, may
cannot
kindly
take
see
two
the latest
stands,
RTC.
saying that there's ragi being
There
grown
is.
and poultry farm.
There is, my lord. It is
That's why I
together.
said The
It-
poultry
there is,
farm
my
is there in part of it.
My lord, it was there in the sense, my lord, when we made the mortgage also,
Anyhow,
it was there. my
I'm
lord.
not, in spite of all this.
My
I'm
lords,
not
may
inclined-
kindly see the RTC, the latest RTC, my lord. I will not.
Still, I'll not interfere with this.
My lord, tomorrow's the auction, my lord.
Let it
If
go.
that is the case, my lord, may I just propose something?
From 2017.
May I propose something else, my lord? May I
2025.
propose something else? Now, it's my learned friend's case that I have not made any payments, my lord. If that is the case, may I just propose to make some payments at least, my lord? Because I have a financer now
No,
who's
some
then, my
payment.
lord,
It's only substantial payment.
substantial payment, my lord. My lords may then indicate what could be a.
What is the amount outstanding?
4 crores 39 lakhs.
My lord, I'm disputing the amount either way, my lord. Either way, my lords were to propose something, my lord, I would. Because I have
The
somebody at least
statement
who's
which I'm producing.
Crores.
3 crores would be too much, my lord.
How
3
do they
crores,
not interfere?
substantial, my lord.
Why the High Court why the High Court should interfere in all
No,
this?
my lord, I do understand, but the issue is this, my lord.
Even considering that request is also
Please.
beyond the jurisdiction of this court, but this.
My lord, only on the agricultural aspect, one, my lord. Second aspect is, my lord, going on to the emotional aspect, my lord, I have nothing because this is my livelihood. Again, my lord, which is why I go back into CPC.
You had enough time.
I have
because of all
never,
this.
I've never been able to enjoy the property. That is the issue, my lord. I've never been able to enjoy the property.
Yes.
8 long years.
My lord, with
They
Ragi,
stalled the
what am I to
process
do,
from
my lord?
2015
With Ragi, how
till-
much can I make profit also? It's only Ragi.
Why did you take 1 crore loan?
I'm sorry, my lord.
What will you do? 1 acre of land.
My
you are
lord, that
growing
4 acres,
but you're-
35 guntas, my lord. Totally 4 acres, 35 guntas is for 2 lands.
1 crore amount. for
1 crore, my
calculation.
lord.
For
And I
calculation
asked
of
for
4
another
acres.
50 lakhs also to be given to me, my lord. Because I have absolutely nothing else to do. May I just say, my lord,
Not interfere with the process.
2012, my
my
lord.
lord,
Amount is
substantial amount, may I propose a crore, my lord, at least for the interim, my lord, because at least for the interim, my lord. May I just propose that because otherwise, my lord, I will be left nowhere. My lord, all my plantations, everything goes, my lord. It's not only the land which is going, all my produce also goes. That is the only issue, my lord. May I propose a crore, my lord, because at least that is something which is substantial. At least in my capacity, my lord, one crore is substantial.
Court do not want to be part of this, this whole.
Bargaining, I do, my lord, I do understand.
It's not about, it is about right from 2017.
My lord, 2000,
Amount of one-
2021 they do it, my lord.
2012, my lords.
25.
Please, my lord, I do appreciate.
2012 loan
And
was
what they
granted.
say is about 4.5 crores is due, my lord. If it is due, my lord, I have to pay it or I'll have to work out an OTS with the bank. But at least just to show my bona fides, let me at least do this. Because I have no other place to go, my lord. I'll at least do this because, my lords, 1 crore, my lord, because beyond this, I will not be able to push. My lords may put me on terms also. I'll come back before my lords itself and then show
What will
my.
you do? Okay, I'll entertain this writ petition.
Please.
You will pay 1 crore
Please.
tomorrow.
Please.
And this writ petition will come up for hearing after 5 years.
Not 5 years, my lord. My lords may fix a date.
And you will enjoy it.
I will work an OTS by then, my lord, at
You
least
will
because
work
if I have
out
an
by this
OTS,
time,
my lord,
that's
we've been
it,
trying, my lord. The only issue is this, we've been trying, my lord.
Let us stop this.
What happens here,
let
my lord,
everybody understand
are-
that this is how it goes on.
my lord, I'm trying to show my bona fides here. Being a farmer,
Not in 1 crore.
my lord, being an agriculturalist, my lord, this is the best I can do. I have a financer who's come to back me up now. He says, fine, fair enough. That's the only thing, my lord. I will make a deposit of 1 crore. My lords may put me onto terms.
Was in the fag end, my lords, from 2015.
Either
till
way, my lord, at
2025.
least it's my lord, it's not that I'm doing a favor to the bank, but at least it's money in the bank's pockets, my lord. It's not like I'm trying to make it look like it's a
It's
favor.
conducted that the
Please.
bank will get the entire
What are
money.
that?
Entire money
It's only
will get it.
10%, my lord, 10% because EMD is only 10%. Then max to max another 25%. My lord, that I will clear. I will clear that. That 25% will be paid by me itself. I will ensure that that is paid.
No, no,
Whatever they have to get,
if you come up with what is it you're going to pay by tomorrow? What
my
is
lord,
it you're going
20.
to pay? Whatever is the amount, when are you going to pay? Are scheduled within 2-3 months.
May I just, my lord, 10% is the EMD amount. 10% for sure, no difficulty. My lord, then they have to make a deposit of 25%. 25% also, my lord, I will do that 25%.
If the bidder pays entire
I will
amount
ensure
within
that.
a week, my lords,
Will the bidder pay the entire amount?
my lords, according to schedule, they have 30 days.
Hmm.
If he wants in earlier also, he can pay and get the sales certificate registered in his name.
Before that, my lord, so at least first let me do the 25%. My lords may put me in terms, my lord, I will come back on a date before the 30 days itself. And then let me at least
By
work out
tomorrow,
a notice.
tomorrow you will have to.
Let your client come up with an undertaking.
I'll make a notice, my lord. We'll at least just,
No
But
OTS
about this,
proposal will be accepted.
my lord,
payment
25%,
within 1 month.
25% will be made, my lord. 25% I will do it right away.
1 month the entire payment.
My lord, entire payment I'll have to work in OTS because 4.3 crores will be too hectic for me, my lord. I don't want to make a false submission just for,
Go
my lord,
before the DRT.
just for
before
an
the
interim
DRT,
order.
Your time and work it out.
My lord, just for an interim order, I don't want to make a false submission. What is my capacity? I can make that submission.
I
my
know
lord.
that you cannot pay. That's why I'm saying I'll dismiss it.
Which is why, my lord, let me just do this 25%, my lord, because this 25% will really help me. They will get that 25%.
It is not going to. It will not go to any logical.
My lord, 25% is what they will get, and my lords will fix a date, my lord. My lords may fix a date. I will come back on that date itself. Let me at least work an OTS with the bank within. Because all my OTS proposals,
Without working
my lord,
out
we have been trying to do this for quite some time, my lord. We've been going to the bank.
What you couldn't do.
When the bank gave him the offer, my lords, he didn't come forward.
My lord, the last proposal given to me did not even have a figure. What do I go and work out, my
He
lord?
never came forward for asking for the figure when we gave
I will
him
work, my lord. I'll work an OTS. My lords may put me on term. My lord, 1 crore, my lord. I don't want to, my lord, I don't want to negotiate here, but 1 crore, my lord. Let the auction not go on tomorrow. I'll make sure that the payment is made. My lords may put me on terms. I'm sorry, my lord. My lords may put me on terms.
Is not what the stay will not be granted. This one.
My lord, 1.5. I don't know what else to tell, my lord. How much more can I push?
2 crores.
My lord, I don't even know if I can make such a commitment, my lord.
3 crores. You pay 2 crores, then we'll grant.
My lord, I don't even know if I can make such a commitment, because
because court is not at all. I'm not inclined to interfere with this. With these
may
kind
I
of
then,
cases.
if it's 2 crores, my lord, may I then say, my lord, that 25% first I'll make for the 2 crores, at least about 1 week or 2 weeks may be given, my lord. At least that, my lord. That 25% I'll clear.
What is that 25% comes to?
25%, my lord, it may come up to almost a crore, my lord. So a crore itself will do. Let me at least do that, because what they'll get is that.
By tomorrow, by the time the auction starts, you have to pay that 1 crore, and within a week, he'll pay the other 1 crore.
May I make a
Little
request?
more than a week, my lord. Little more than a week.
May I make a request?
Let me breathe, my lord. Let me at least do something there in the farm.
We'll go ahead with the auction tomorrow.
Don't confirm it.
We will not confirm it, subject to payment of 2 crores within a week.
My lord, if they are going into the auction, my lord, all this, I jump through hoops.
If they
My lord, I
don't
jump
pay,
through
my lord,
hoops
we'll
and then
confirm
pay
it
a
to the-
crore tomorrow, and then they say, no, they'll go to the auction, but they won't confirm it, my lord. Then again, that 25% is exactly what I'm
We
paying.
cannot stall the entire
That
proceedings.
is exactly what I'm paying. What they're going to get tomorrow is what I'm paying.
So I don't know. By 7 days, I may get the entire money.
If the auction is not confirmed,
We have received
what
the
right-
bidders, my lords.
How is it going to defeat your interest?
My lord, what happens is, my lord, they will then fall back on the judgment of the Honorable Supreme Court saying that the minute it's already auctioned, you cannot redeem the mortgage. That is the problem. So
Even
that is
today,
where I
my
come
lords,
in.
they cannot redeem the mortgage. Even
That is
today
where-
also, they cannot
My
redeem
lord,
the
so which
mortgage.
is why I've come before the auction. If it is after the auction, I do understand. I'm
Auction
only
notice
saying, my
was-
lord, so which is why
Sale notification is issued.
49.
sale it's not a sale notification per se, my lord, not under the Surface Act. Now this is under the RDDB Act.
Yes.
Even-
uh,
We will go on with the sale, my lords. We will not confirm. If he does not come up with this commitment, my lords, we will confirm it. We have received the bidders. My lords, we have this process, he has stalled it from last 8 years. And my lords,
What
with
happens
great,
is, once an order is passed by the court, once the parties comes to know, there won't be any sale at all.
Plus, there will be a sale. We have received the bidders, my lords. I will make the statement. We have received the bidders. Let the sale go
We
on.
have received, but once an order is passed, that's subject to.
My lords, if he doesn't come, then it will be his property. If he comes, my lords, it is his risk, which he'll take.
They are quite confident that the sale will go on, my lord. On what basis they are saying this? Because you're talking for a third party now.
No, please tell the court, what is the mode of payment, when?
Honestly, my lord, I leave it to my lords. I have no idea. I don't know how I'm going to generate it, but I'll have to generate it now.
That is the reason, my lords, this statements.
I will have to
after
generate
15
it
days
now.
will
I
change.
don't even know if I can commit to the two, my
But
lord.
that's how he's making it, that's how he's saying that.
I do understand, man, but then I really don't know how I'm going to generate it, but I'll have to generate it.
What we do is,
If I'm being put to terms, I have to.
we'll grant him 2 weeks. 2 weeks for the 2 crores. Till 2 weeks means today is
Today we're on 16th, my lord.
16. So that's 30th. Till 30th, he has time till 30th. We'll list this matter on 31st.
My lords, the process is, my lords, again, I'll have to go before the recovery.
No. You
recovery
go
officer.
ahead, you go ahead with the.
I will go ahead. We'll not confirm till 31st, my lords.
Not to finalize, keep it till 31st.
If he doesn't
Then
pay the
on
amount, we will confirm.
Matter will list it. If he fails to pay,
We will confirm.
Lord, but then they're going ahead with the auction. So my payment, I can do it before 31st then.
yes.
But they're going ahead with the auction, my lord. Because
Now
the
they
only
want
issue is
to,
that
they want to extend the payment till.
This is the best, order for your client.
My lords,
my lord,
by
then-
tomorrow, some payment will have to be
With
made.
your persuasion.
My
my
lords,
lord, then I
by
know, I
tomorrow
may
they
be
will have to
pushing
make
it a
some
little
payment.
too much, my lord. Then,
By tomorrow, they will have to make some payment
then
to show
now,
their bona
then let
fides.
them not go with the auction then, if I'm doing it tomorrow.
Well, lords, they
cannot have it both ways
They
then.
cannot have a bread and butter both.
No, you're going ahead with the auction. We'll give him 2 weeks time for the
Please.
entire 2 crores. Court is for questioning the warrant of attachment. It's dated 29/4/2025.
Please.
And the e-auction notice 11/9.
Also, the e-auction notice dated 11/9/2025. It is submitted that the property that is mortgaged is an agriculture property. The property cannot be auctioned. It is submitted that he is ready for the OTS and also and settle the dispute, but the bank is not coming forward with any concrete proposal. That's why he couldn't pay the amount. The land council appearing for the respondent bank submits that the loan was obtained in the year
12.
2012 and the account was declared NPA in the year 2015.
15.
Right from 2015 till now, no amounts are paid. It is submitted that under the RDBA Act, there is no they can proceed with there is no bar to auction the agriculture land. It is submitted that the right from 2000 even in a OA an order is passed in the year 2017, that is on 19/6/2017, which was not questioned by the petitioner and it has become final. He submits that under section 30 of the RDBA Act, an appeal against the order of the recovery office, an appeal lies to the tribunal against the order of the recovery officer and the writ petition itself is not maintainable. In response to that, land counsel the petitioner submits the petitioner is ready to pay an amount of rupees 2 crores by 30th of October, and after that, within a short time, for the remaining amount, they'll negotiate with the bank, and that also he'll complete the process. Next para. So there is a right of appeal before the DRT, and this court will not interfere in a matter of this nature in the light of the law laid down by the Honorable Appeals Court. However, in the facts and circumstances of the case where the petitioner is ready to pay an amount of rupees 2 crores by 30th of October, this court is passing the following order. The respondents are at liberty to go ahead with the sale as per the notice dated 11/9/2025. However, they shall not confirm the sale till till 3rd of November. Number 2, the petitioner shall pay the amount of 2 crores by 30th of October. List this matter on 31st. By the time, if the amount is not paid, as amount of granted by this court stands vacated. List this
May I
matter
make one
on
request?
31st.
If on before 30th, if they don't pay, my lords, the bank can proceed in confirmation on 3rd.
No,
That line could be added.
No, it's coming up on 31st. What is the big urgency? That day we will sell. I'll pass that order on 31st.
Please,
Yes.
grateful, my lord.
Preliminary hearing B, till number 14. Salmani Prakash for petitioner, Francis Xavier.
My lord, I am for the respondent bank in this matter.
Yes.
Not sir. IA for filing WS, seeking permission to file WS has been rejected by DRT. IA for filing WS, seeking permission to file WS has been rejected by the DRT.
Where is that order? Please come to the order.
In page number 59, my.
59.
Yes, ma'am.
59 minutes.
OA is of the year 2018.
Yes, my lords. IA was filed on
'Why you have not filed the written statement?
19/10/2019. I have filed IA, my lords. One date before that, I have got the.
When is this order passed? 25th March 2024.
Yes, my lords. After 5 years, my lords. My lords, here, the paper book was received, just one paper book was received on 11/7/2019. Kindly peruse page number 35, my lords. Page number 35. Paper book was received. In spite of several reminders, they have issued the paper book on 11/7/2019.
Yes, what do you say?
My lord, that is not the order. That is not the order. 11/7. My lord, kindly see the order, my lord. D1 and D2 written statement was not filed. Steps for D3 PP on 9/10. That is the order. Kindly take, my lord.
That's on 12/12/2019.
Foregoing reasons,
In
a
page
written
number
statement
36,
filed by the
my lords.
defendants
My lord.
on 9/10/2019 cannot be taken on record.
Kindly see the applications, my lord, in page number 56.
This is the order.
In page number 56, their application.
67.
67 is the order.
Portion of the order.
56.
I filed it under
Once again,
151.
56 is the application. They filed an application to condone the delay to file the written statement.
How much is the delay?
The delay is, my lord, the written statement has to be filed within a period of 30 days. And my lord, extended period of 15 days. That is the settled position of law. My lord, under section 19 subclass 5 of the RDDB Act. My lord, the provision is not a discretionary. It is a peremptory in nature, as held by the High Court of Telangana, and also as well as the High Court of Honorable High Court of Delhi High Court and Madhya Pradesh.
There is no limitation act will not apply.
Will not apply. May be permitted to demonstrate in this matter, my lord, based on this judgment.
So on that reason, the court has dismissed.
Yes, my lord.
Tribunal has dismissed on that
Yes, my
ground.
lord. Kindly see the
Let's see the provision.
1954.
RDB Act.
11/7, my lord, even 11/7, my lord, 45 days. Yes.
Let's see. 19.5.
19/5 subclass 1.
30 days and 15 days is a.
Very servant.
1 minute.
My lord, I permitted to read, my lord.
Yes.
The defendant shall, my lord, the word used, shall within period of 30 days from the date of service of the summons, present a written statement of his defense, including claim of set off under subsection 6 or counterclaim under subsection 8, if any, and such written statement shall be accompanied with the original documents or true copy thereof, with a leave of this honorable leave of the tribunal relied on by the defendant in his defense, provided where the defendant fails to file the written statement within the said period of 30 days, the presiding officer may, in exceptional cases and in special circumstances to be recorded in writing, extend the said period by such further period not exceeding 15 days to file the written statement of his defense. Now, my lord, I will take my lord to their application. What is the reason they have assigned in the applications, my lord, in page number 56.
1 minute. So the provision is very clear.
Very, my lord, I am permitted to read the judgment. Three high courts have held, my lord, three high courts, Honorable High Court of Delhi, Honorable High Court of
Acting upon 19 class 5 lots, tribunal cannot grant any condonation of delay. But it doesn't speak that High Court can do it. Acting upon 19 class 4, it is limited only to the tribunals.
It is
Milords,
either it is High Court or the tribunal.
Yes,
We are
yes.
governed by the
Agreed.
act.
Milords, I have filed an application.
Whatever power the tribunal doesn't have.
No, my application is not under 14 class 9 because of 19 class 5. Why? Because 19 class 5 only 45 days time for filing it.
What is your
I
application?
have filed an application under 151 of CPC. CPC is applicable to DRT also, my lords. CPC, my application,
Permitted
kindly
to read the
peruse
judgments.
my application,
Judgments, sir.
page number 55, my lords.
So when there is a provision under the act, why will you go to 151 CPC?
Because 45 days was exceeded.
So you'll go to 151
Delay is
CPC.
90 days, not 120 days. If it is above 120 days, then even 151 I cannot apply. Not
There
it is
is a
90 days.
provision under the act. When there is no provision even under the CPC also, we'll file an application under 151 CPC. How can you file an application when there is a specific time period and a provision to file the application? Why should one go to 151?
That has been discussed in the judgments.
That is, no judgment is required.
Yes,
That
my
is-
lord.
that is-
Three high
Not
courts have discussed.
Inherent powers, not inherent
No
powers.
inherent power.
Inherent powers, because, and moreover, my lords, the
The whole
kindly peruse
purpose,
the order sheet, my
the
lord.
whole
Kindly.
purpose of keeping
Delay is
that,
only 90 days. Delay is only 90 days. And they have observed that the delay is 280 days. On what basis, I don't understand.
Anyhow, let's take it 90 days.
90.
Even 90 days also, you are above the cap.
Yes,
Please come.
not, but my right to counterclaim will be,
I will-
because I was negotiating with the builder. Not-
Whatever
The
it is,
builder
you
is the
please
one
do
who has
it.
played the foul.
Please come.
No, Lords, kindly, the builder was, actually the builder is defaulted. He is supposed to deliver, he was supposed to deliver
Lord,
the possession of the property within 1 year. He has defaulted. I paid 11 lakhs of,
So we are only concerned with what
Yes,
is the impugned
Lords,
order. Impugned order is correct or not. It is a correct order.
Yes, my lord,
So
but-
I'm not concerned with what are the consequences of that.
no, natural justice has been denied, my lord. They should have, I filed it in 2019. They should have
For the
rejected
equity-
it then and there. For 5 years, they have delayed it for 5 years. They have not filed objections even in DRT, even here. They have not filed objections. They have been given 5 years time to file objection on my application. And 5 years, who's the
My lord, the
liability?
statute is
Who holds the
when the
liability, my
statute
lord?
Wait,
Yes.
yes.
For 5 years also, I'm liable to pay the, as a borrower, I'm liable for the loan, my lord. 5 years delay.
I number, the present petition is filed. Agreed with the orders passed in I number 2303 of 2019 in OA number 1119 of 2018. The petitioner herein has filed an application under 151 CPC to file objection statement. To file the objection statement. It is stated that there is a delay in filing the objection statement to the appeal due to the reason that the builder had assured him to allot a villa after completing his project, but subsequently he was not interested in the said villa and sought for refund of the amount which he had paid for the allotment of the villa. The builder has not paid any amount and instead he kept on prolonging the issue. As such, he was under the impression that he will pay back the money and settle the issue. Due to this reason, he could not take interest in contesting the appeal. Now, as the builder has failed to pay the amount, it has become inevitable for him to file the objections, and hence he sought permission to file his written statement public objection. The tribunal, by order impugned, had dismissed the application. While dismissing the application, court had considered the law on this aspect and also section 19(5) of the
RDDB Act.
of the Recovery of Debts and Bankruptcy Act 1993, for short, RDB Act 1993, and observed that the strict timeline for filing written statement and counterclaim is that DRT is adjudicating on disputes involving huge amounts of public money, and if any delay is permitted in the adjudication of the disputes, the same will result in locking up of huge amounts of public money, which further would prevent utilization and recycling of those funds for the development of the country. In those circumstances, the court has, the tribunal held that the written statement filed by the defendants on 9/10/2019 cannot be taken on record with a delay of 280 days in filing the written statement, and the same stands rejected. Next part. Learned counsel appearing with the petitioner, petitioner submits that the delay is 90 days, but in the order it is recorded as 280 days. Further, he submits that he has filed an application under 151 CPC, but not under 19(5) of the Act. It is submitted that when under 151 CPC, the court has got the inherent powers, and the court ought to have condoned the said delay, and in the interest of justice ought to have allowed the petition. He submits that when he has filed a petition in the year IA in the year 2019, for several years the respondents have filed to file their objections, and the orders were passed in the year 2024, and there is no fault on the part of the petitioner. It is submitted that he has stated the reasons in the IA why an application is filed, and considering those reasons, the court ought to have condoned ought to have allowed the petitioner to file the written statement, and it is submitted that section 19(5) has no application to his case as the application is filed under 151 CAPC. Next, learned counsel appearing for the respondent submits that the court had rightly dismissed the IA considering section 19(5) of the Act. As per section 19(5) of the Act, the written statement has to be filed in 30 days, and the court has discretion to extend it by another 15 days. So within 45 days, beyond 45 days, the court has no power to entertain the same. He had relied on the judgment of the High Court for the state of Telangana in case of Mrs. Neelam Enterprises and others versus the Bank of India. He relied on paragraph number
10, 11, my.
Paragraph number 10 and 11. Extract
10,
that.
10, 11.
It's all extraction. Paragraph number 11. Yeah, he relied on paragraph number 11, and relying on that, counsel submit that the order that is passed by the court is basing on the is a well considered one. No interference is called for. Next, having other counsels on either side, peruse the material on record. The first submission of the land counsel that he has filed an application under 151 CPC. So the bar under 19(5) is not applicable to this IA. That's a submission this court is not able to appreciate. When a written statement is filed, and what is the time frame to file a written statement, and what are the consequences of it, has been clearly stipulated under section 19(5) of the Act. When the Act is very clear and there is a provision question of exercising filing an application under 151 does not arise, and arrest. Then coming to section 19(5) of the Act, which reads thus, extract section 19(5). The plain language employed in the section makes it very clear that the defendant shall file the written statement within a period of 30 days. The presiding officer may, in exceptional cases and in special circumstances to be recorded in writing, he can extend the said period to another 15 days. Admittedly, according to the petitioner, it is 90 days, but the court has recorded it as 280 days. Either it is 90 days or 280 days, that is above 45 days. And to condone the delay, the tribunal or any other court has no power in view of as the Act is very clear. The court had rightly observed at paragraph number 21 that the strict timeline for filing written statement and counterclaims is that as the DRT is adjudicating the disputes involving huge amounts of public money, and if any delay is permitted in the adjudication of those disputes, the same will result in locking up huge amounts of public money. And the court had rightly dismissed it. And this court finds no reasons to interfere.
Not natural justice administration. Not 5 years for liability. I am under 5 years liability.
What is
No,
the, what
penalize
do you
me for
expect?
that.
Huh?
I may be fined. I may be fined. I may be allowed to file the WS. Why? Because my lord, counterclaim, I cannot make the counterclaim, my lords.
Yes, next.
Please.
Cell number
Much,
15,
much of.
R.B. Srinivas Reddy for petitioner, Mohammed
Respondent
Ibrahim.
bank. Therefore, Your Lordship directed it will be dismissed today.
Yes.
DRAT, they have to go. And
No, Your
meanwhile,
Lordship, kindly
this is
see.
a builder.
Your
He wants
Lordship,
to
kindly
approach
see.
the bank and get things settled. With the liberty, it may be.
In fact,
disposed
we
of.
are ready to settle, my lord, whatever the principal amount which has been transferred
Don't
to
say
the
principal
developer.
amount.
No,
As
you
per
are-
the recovery policy of the bank, it can be
Your
settled.
Lordship, kindly see.
What is the order impugned?
Dismissal of the order of the DRT, my lord, under
What is
section
the
20.
order? What is the order of the DRT?
Directed the respondent, you Lordship, kindly see, page 36. ma'am.
36.
Ah.
Hmm.
The applicant bank is allowed to recover from defendants to pay an amount of rupees 60,36,578.
Hmm.
So and so under the housing loan facility account so and so together with interest at 8.5% with monthly rest plus 2% per so and so. These they are the first. My lord, in fact, since there was no notice in these proceedings, we have filed a miscellaneous petition before the debt recovery tribunal. That has been rejected only on the ground that we have not given proper explanation to the delay. That was at page 54, at the 54, you will kindly see. Page 54. We have given a suitable explanation in the delay application, but without considering the same, in page 54. May I read it? Counsel for the applicant is present. The defendant has filed the MA with a prayer to restore the OA number so and so and so. The present application is filed
If
by
it
the
is only
applicant.
49 days delay.
That section 20, he can go for appeal. It is not miscellaneous, it's based on the.
No, ultimately, even if he goes for the appeal also, the tribunal, DRAT, is going to decide about the delay of 49
No,
days.
they have to go in appeal for the OA order.
No, what is SL, no, what is impugned is 28/4/2025 order. 28/4/2025 order.
Yes, my lord, MA order they have
No
assigned
delay,
here.
they wanted to condone the delay of 49 days. That was not condoned.
It's not condoned.
So.
Because it was, they remained absent.
This is it. When is this petition filed? On 6/6/2025? What is that the bank is going to gain now?
Yeah, again, the whole case will
What
be
will
reopened.
happen?
Lord, I have filed the
DRAT will not decide the appeal. It will only decide this application whether this delay can be condoned or not. If it goes back, then the proceedings can they can take the proceedings further.
My lord, page 33. My OA is of 21.
Correct.
Decided in 24.
He filed it with a delay of 49 days.
Then he comes back. All along from 21 to 24, he was sleeping. After service of notice, he has not appeared. His contention is that notice was not issued, I would have paid. Come to page 39, my lord. It is not that merely delay. 3 years he has lapsed.
Yes.
My lord, see, 39.
When the notice is served on him.
Well, Page 17, my lord, A17. Legal notice, he said, I have not issued legal notice. 29/7/21, legal notice is issued, page 39. He says, if notice would have been issued, I would have come and paid. Notice is issued.
29/7/21.
21.
Postal receipt.
Against all the defendants, notice is sent.
What is your explanation on this?
No, Your Lordship, kindly see, this OA was filed in the year 2019, my lord. At that time, due to COVID-19, our company was closed, my lord.
21, my lord, not
21,
five.
please, my lord, 21. Our company was closed. The notice was served on some security man and take it as served on the company. My lord, immediately after coming to know about these
Did
proceedings.
you come to know? Where is that IA that you filed?
Yeah, please. May I take your in page 50.
Yes.
I submit that I filed the above miscellaneous petition against the ex parte order dated 28/5/2004 for setting aside the same and provided an opportunity of being heard.
How can, on these grounds, will any court condone the delay and set aside an ex parte order?
Can you see? Even now,
Nothing to see. You please tell the court. I've already seen. Now,
actually,
according to them, in the year 2021, notice is served on you. You say notice is not served. What all you have stated before this, does this affidavit contain?
in the main petition, you Lordship, my only grievance, you Lordship, kindly see, had the notice was served before the DRT, we could have definitely, we would have.
Who should tell all this? How should the
Even
court
now
know?
also, even now also, my lord, with great respect, we are ready to settle the amount, whatever the principal amount. I am a developer. I have not received, I have not obtained any
Why will
loan.
they take only
My
principal
lord,
amount?
There is a recovery
Oh,
policy.
no,
Based on that,
you
let him go
Lordship,
and
kindly
approach
see
and
the
get it
respondent
settled.
number, the
He cannot
respondent
say
number
that I
1
shall
and
accept the
2.
principal
The
amount.
respondent number 1 and 2 have obtained loan from the bank. Yeah, under the tripartite agreement dated, you Lordship, kindly see, as per condition number 19, they could have offered an opportunity, 15 days notice.
But I'm not going into the benefits of the matter. I'm only concerned with the impugned order.
In fact, my lord,
The
there are.
notice is issued. When the notice is issued in 2021, you file a, well, when is this, what is the date of this? You file a petition to set aside that ex parte order. In which year? 2024.
24.
So 21 to 24, when did you come to know? What has happened to the notice that is served?
No,
Nothing
my
has
lord,
been
there are,
stated.
I have stated, my lord, there are
Yeah,
other proceedings.
Read it. Read
The
page,
impugned judgment came to my,
page 50.
please, man. The impugned judgment came to my knowledge through my advocate who is representing in other cases on behalf of me before this honorable tribunal. There are other cases, you would Ashma kindly see. We were not at all, since we
I
could
think
not.
let's not waste the time. I'm not inclined.
You would I may be given an upper, I'm ready to pay the whatever the amount which I have received on, in respect of this particular flat.
Who is stopping you?
Stopping
We'll do one thing. No, we'll do one thing.
No, please.
What we do is, let him pay the principal amount. On that, whatever with regard to the other amounts and all, then we'll permit him to contest.
Obliged, my lord. That can be done.
When will you pay the principal amount?
Then, Lakshma kindly have done 24th. I will consult. There are 3 other cases, even 24th.
No, this will come up on 23rd. It will come up on 23rd. On that day, you have to get instructions. When are you going to pay the principal amount? On that, I'll set aside, I'll allow this, whatever the impugned order will be set aside. The matter will be remanded back. Whatever you want to contest, subject to the further result of the orders in the OA, you will be paying the amount. On that, we will allow this petition. Get instructions from the client.
Please.
When counsel for the petitioner submits that, you will get instructions from the client with regard to payment of the principal amount pending disposal of the OA.
Decretal amount.
Decretal amount.
Decretal amount, also. 54 lakhs I have obtained, not the decretal amount. Sorry.
I said principal amount.
Yes, please.
Yes, next.
Then number 16.
Listed matter on 23rd. Yes. 16.
appearing for the petitioner, sorry, respondent bank lordship. The petitioner has challenged this,
Any interim order is there?
no interim order lordship. The thing is, the petitioner is claiming that they have filed this petition. There is no interim order. Bank may be permitted to proceed in accordance with the law for the recovery of.
No, when there is no interim order, why you want a clarification?
They are telling that this writ petition is pending and
No,
there is
that will not come in your way.
that may be clarified
Why
because
should we clarify?
we may permitted to proceed along with it.
No representation on behalf of the petitioner.
In the
This
last
is-
date, this honorable,
This matter for dismissal on 13th of November.
much obliged.
Yes,
Number
17.
17, Gopal KB for
Yes.
petitioner. Divya Purandar.
Hearing for the respondent. Lords had directed notice to be served and taken notice for the bank. My lord, they've challenged the possession notice, my
Possession
lord.
notice.
Lord, we've complied with all the procedures, my lord.
On what ground you are before this court?
Only is mercy petition, my lord.
Only stay of
Yeah.
further proceeding.
But no, my lord, I am ready to pay some,
No sum. No sum. What is the outstanding amount?
My lord, 31 lakhs.
7 lakhs.
When, how much you will pay?
5 lakhs paid within a month, my lord.
First of all, writ is not maintainable.
No, my lord.
And above that, you say 5 lakhs you will pay and we have to,
Wow, what?
when is any, what is that? This auction notice or what is
So
it?
this is a possession notice
Possession
under
notice,
13.4, my
possession
lord. There's no
13.
option. They can go to DRT, my lord, or in fact, my lord,
No, my lord.
coordinate bench had held that this is a private bank and writ is not maintainable. This is Karnataka Bank, my lord. I beg to rely on this decision, of course, coordinate bench, my lord. That Karnataka Bank is
But the other
private
day,
bank.
like you have appeared in 1-2 matters.
So that is Union Bank of India, my lord.
No,
That
in
is,
Karnataka Bank also you
Karnataka.
appeared yesterday.
yes, my lord. That is next matter, my lord. I just
No,
took
no,
notice.
yesterday's matter.
Yes, my lord. It's next.
Else, some breathing time may be given to, I am ready to pay on 5 lakhs, madam.
No 5 lakhs.
Because I am suffering from lot, that's why.
No, she's relying on a decision that Karnataka Bank is a private bank and the writ is not maintainable. So, but still, if you are ready to pay, some substantial amount still will interfere.
I will ready, get
This is matter on 29th of October.
till the,
Number 18,
No interim order.
cell number 18,
Not appearing
For
for
this?
the, yes, my lord. Now, this is also Karnataka Bank, my lord. But in this, my lord, sale auction is tomorrow and some amount has been paid by the petitioner. And, but then there are no bidders. So actually, the only thing challenged is actually the sale notice, my lord. It may be disposed of.
Today is supposed
Tomorrow,
to
my lord. Yesterday, they were supposed to, the bids closed last evening at 4 p.m. There were no bids. Some amount has been paid by the petitioner, 10 lakhs. But then still there are dues about
We'll have it
35 lakhs.
Tomorrow, let the petition be here.
Yes,
If he says that about any other amount or not. This is matter tomorrow.
the passed over matters in list
Grateful,
number 2. Cell number 1, list number 2, cell number 1, pass over.
This matter.
This number.
Matter.
2,
Got my learned
Why
friend
is it
has-
passed over?
It was passed over, my lord, because he wanted to place on record the 13-2 notices as 13-4 notices.
According to them, it is.
Yes.
My lord,
When
if
you-
my
Yeah,
lords could, yes, he has served me the copy. If my lords could kindly see those documents.
Take that.
It's all pertaining to, my lord, during the period of COVID, wherein, my lord, they were not supposed to classify this account as NPA at all. Because they were, my lord, at that point of time, they were governed by the orders of the Honorable Supreme Court. Wherein, my lord, if your lordships could kindly see, 3/7/2020 is the first notice which they have issued. My lord, classifying of the account as NPA itself was illegal at that point of time.
Kindly come
And
to page.
thereafter,
let
one
me come-
second, one second.
Page 2.
ನಾನು
It was classified in
ಹೇಳಿದ್ರೆ
2018.
ನೀವು ಹೇಳಿದ್ರೆ ಮಾತ್ರ ಸರಿಯಾಗತ್ತೆ.
2018, not 2020. Kindly come to page 2, my lords. That's clearly mentioned. After lapse of 4 years, it's covered by Supreme Court judgment, my lords, where when the sale notice, in fact, in this case, lordship may come to page 2. Page 2, para 2. Last 3 lines, my lords. As non-performing asset on 4/11/2018. This account was classified as NPA in 4/11/2018. It is not that I classified, it's not that I classified. And my lords, kindly come. Paper publication is done. Demand notice paper publication is done. My lords, that paper publication is in page 18. In 2 leading newspapers.
Not only classifying the account, my lord, even 13-2 notice also. Thereafter ought not to have been issued. My lord, morning also I made a submission. I am not on merits of the case as of now. Tomorrow is the.
If you're not on the merits of it, we can't interfere.
That's the reason, my lord, I had made a request in the morning itself. I'll make some payment. Tomorrow itself, I'll make, my lord, 1 crore as a bona fideness, my lord. Since
What
my
is
learned friend
outstanding?
says
11 crores.
11 crores is the outstanding. May I make one submission?
Let him go
My
before
lords,
DRT.
kindly bear with me for 2 minutes. My lord, 1 crore tomorrow morning before
No,
auction.
court will bear with you for another 1 hour. but the
My lord,
result will
because
not
I
change.
don't want to waste time on, because I have been
It
seeing,
won't
my lord, your
change.
lordships, one submission. May I make one submission? My lord, 1 crore before auction tomorrow I'll make the payment. My lords may kindly give me 2 weeks time. Let the sale go on. Within 2 weeks, my lord, I'll pay 50% of the amount due. If I don't pay, my lord, let them go ahead with the
Again,
confirmation.
Supreme Court judgment is there, my
No,
lord.
Supreme Court
Redemption rights
judgment, my
he
lord,
has
I'm
lost.
aware
Again,
about
third
that
party,
judgment,
even
my
if
lord.
he permits us to go on with the sale, again, what happens, my lord, third party rights will be created. Again, auction purchase will come and contest, telling that all these things will lead to multiplicity of litigations. Let him go before DRT, let him file appeal. Tomorrow morning appeal can be filed before DRT. Tomorrow morning he can seek any interim order if he wants.
Situation in DRT,
And-
my lord, I
and-
cannot make an
Sir,
application.
let me complete, sir, please.
Allah,
After
when-
4 years, sir, let me complete, please. After 4 years he's coming and he's telling, morning he could have said the same thing. After 4 years he's coming and telling demand notice is not issued, possession notice is not issued. Now my learned friend should answer on that aspect. Why did he make such submissions? If it was issued, if
Stand by
personally
the
served.
submission,
sir,
my
let
lord,
me-
on merit, I still stand on my submission.
It is very
But
much
what
there.
is the- What is the submission I
Kindly
have
look
made
into
is,
postal
my
acknowledgements,
lord,
my lords.
what is that?
Postal acknowledgements are also there. He has
Postal
issued position
acknowledgements
notice
is of
way
the
back in
year
22.
2020. My lord, 5
21.
years, 5 years they keep quiet. All of a sudden they issue
No,
a
this is
sale
fourth
notice.
or fifth sale notice.
But you are aware of the amount you have taken, what has happened to
Ever-
that?
And that's
Till
the reason, my
approach
lord,
the
my
bank.
morning I have pointed out, my
For the
lord,
sake
even
of interim
after.
order, he can make any
Allah,
submission whatever you want.
Let me make submission, then you are making, if I
Yes,
make
yes,
submission.
yes.
My lords, may kindly